Go to pumpkin.care.
The murder of Tara Grinstead.
Former beauty queen
vanished from her Georgia home.
It was a bizarre mystery. Literally no one knew what happened to Tara.
Police arrested Ryan Duke.
His alleged accomplice, best friend, Bo Dukes.
Bo said he helped Ryan move Grinstead's body.
But that doesn't mean he couldn't have done it himself.
I think they both have the same story. Yeah, I helped in the concealment, but I didn't murder her.
The Beauty Queen murder trial, following the verdict in Depp versus Heard, only on Court TV.
Welcome back. As soon as the Johnny Depp Amber Heard case is over, we are going to be starting to replay that Duke trial, which took place over the last few weeks. And boy, some big surprises take place in that. Coming up, though, today, it's more of Johnny Depp's rebuttal case. This morning, in his ex-wife Amber Heard's dueling defamation cases, Depp is expected to take the stand today or possibly tomorrow as he gets the final word on the classic he said, she said. One of the fights in particular was subject to numerous witnesses. And that was that trip to the Hicksville Trailer Palace, where Heard claims that Depp assaulted a friend of hers and then proceeded to unleash his rage on their trailer. Heard's acting coach, Christina Sexton, testified that there was damage done that night to the trailer, but Depp's witness yesterday, who owns the property, contradicted that.
Can you describe for me what the trailer where Amber and Johnny were staying looked like?
The inside was in shambles. I remember seeing a light hanging off the wall. There was broken stuff everywhere. Dishes, it looked like, or not dishes, like the wood was broken. Things were hanging off the wall. It was in shambles on the inside.
I was speaking with Mr. Depp, just one-on-one, talking about Hicksville, and Miss Heard came over and she said that I want to talk to you and seemed really upset about something. So I went and back in the house because it was really, they went off on their own and she started yelling at him.
What you observed when you saw Mr. Depp and Miss Heard having an argument.
Okay. He was kind of cowering and seemed almost afraid, and it was really like odd to see because he was older than her, obviously. So, but I just went back in the house. The innkeepers let me know that there was some damage in one of the trailers, and it happened to be Mr. Depp and Miss Heard's trailer. So I wanted to inspect the trailer because I was extremely worried. All those trailers that Steve and I worked on were like my babies, and the one they were staying in was the only one that was mostly original and restored 1950s style, and so I was very concerned.
So what did you observe when you went to the trailer?
I observed that there was a light sconce by the bathroom in the bedroom that had been broken off the wall, and a couple pieces were on the floor, and they were, and yeah, it was basically just broken. The light fixture was hanging on the wall still, except for the pieces that were on the floor.
And he said that was it, that he was shocked and very pleased to see that it was just this sconce, and that because of that he had to charge Johnny Depp $60. And that was it. And in his mind, it was not trashed. Let's bring back criminal defense attorney Karen Felicia Nance in San Francisco and criminal defense attorney former prosecutor Josh Ritter in Los Angeles. Karen, to you first. What'd you make of his testimony? I mean, it came across as the sort of the perfect witness. I mean, if you're gonna cast the guy that came up with the trailer palace idea out in Hicksville, California, and redid the trailers, boom, he gets the job. What'd you think of his testimony?
Absolutely, Ted. And I enjoyed Mr. Knight. I think he came across as very credible. There are several things that really, I think, worked well for the jury, if not for us looking at it from the outside. He's like, no, I'm not a Johnny Depp fan. And he loved his trailer park. He loved this particular trailer that Johnny and Amber stayed in. And so he had a particular interest in making sure that it was not trashed, as he would say. In addition, I think it shows the power of social media. I mean, he was tweeting or on Instagram, and someone saw him and commented, "You need to come forward." So I think that shows the power of what we're all experiencing, and maybe this whole pro Johnny Depp movement is this is an example of it, right? This is why he was called. And I think that we can't unring the bell, right? So when he slips in that he was aware of or sensitive to the fact that Johnny was cowering, and noticed that Johnny was clearly the older person, and it brought attention to him because of his own personal experiences with abuse or trauma, and it was stricken, but we still heard it. So I think that overall, he was the only witness that we heard that actually observed an interaction other than Whitney between Amber and Johnny that showed that he wasn't the aggressor in this relationship, or at least in this particular instance.
You mentioned the way they got him. It was via social media. He had responded to a tweet, and Elaine Bretterhoff, who had a very aggressive cross with this witness, accused him at one point saying, "You follow the umbrella guy, don't you?" And his response was this. Take a listen.
You knew this was on camera, that it was being broadcast to a lot of people, and you saw testimony, did you not, in this case? And you seized the moment and responded to the umbrella guy, the lead person for Mr. Depp's Twitters. Did you not?
Objection, Your Honor. Argumentative compound.
Overruled.
Mr. Umbrella Guy is the lead. The lead.
You
what?
know that he leads one of the most predominant pro-Depp Twitters out there.
I have no idea. I don't care or follow the Umbrella Guy.
In fact, you do follow a Twitter called Johnny Depp Fan, don't you?
Absolutely not.
You don't? That's your testimony under oath?
It is my testimony under oath.
All right. And on April 21st, Mr. Depp testified in this case about Hicksville, didn't he?
I wasn't here.
And in fact, you tweeted in response to the umbrella guy on April 21, 22, quote, "That never happened. I was with them all night. Amber was the one acting all jealous and crazy." Do you recall writing that?
I do recall writing that.
Josh Ritter, what's your take on this witness, Morgan Knight?
You know, in that last little bit of cross-examination that we saw there, I was thinking to myself, it really shows, I think, how people have already kind of been dug in. Because if you're on Team Heard, you're going to look at that and you're going to go, wow, look at, even this guy's in their pocket. He's a fan of Johnny Depp. He can't be believed. If you're on Team Depp on this whole thing, you're thinking to yourself, how ridiculous. We're talking about the umbrella guy, and you hear people laughing in the audience. I don't know if those laughs are coming from jurors, but I would be paying very close attention to the jury during that whole bit of cross-examination there, because if they are laughing, then they feel it's ridiculous. They probably have made up their minds. So it's going to be interesting to see how this all plays out in the end, because I think at this point they've already made their decision.
Fair enough. We'll see. And to your point earlier, I think a lot of decisions have been made with this jury. They've had now 22 days to absorb facts in this case. Coming up tonight on Court TV, anchor Michael Ayala will bring you a special hour of testimony of the day. He does this every evening from the Depp Heard defamation trial. That's tonight, 7 p.m. Eastern, right here on Court TV. It is a sad day everywhere in this country, obviously. We're following the developments in the deadly school shooting in Texas. At least 19 children and 2 adults were killed yesterday when a gunman opened fire on the elementary school there in Uvalde, Texas. Many more were injured. Law enforcement eventually shot and killed the gunman. State public safety officials just announced that all of those children were killed in just one classroom. This morning, we're learning more details about the 18-year-old suspected gunman who died in this incident. Investigators say he shot his grandmother before driving to the Robb Elementary School and opening fire inside the school. Police have yet to identify a motive, but it is obviously a somber day for everybody in this country. Turning now to another major story we have been following out of Texas. A manhunt underway for a woman accused of killing an elite cyclist who died who dated at one time her boyfriend. Court TV legal correspondent Joylyn Necron has more.
Anna Mariah Wilson was killed in Austin, Texas, just days ahead of a big race that she was set to compete in Waco. She was a respected professional cyclist, just 25 years old, who traveled around the nation to compete in some of the biggest races around. Colin Strickland was a man with whom she had some romantic involvement at one time. According to the arrest warrant, Strickland told authorities he had gone swimming and gone out to eat with Wilson the day she died and hid it from his live-in girlfriend, 24-year-old Caitlin Marie Armstrong. And authorities believe Armstrong is the one who killed Wilson in a jealous rage. Wilson's family says she was not romantically involved with anyone at the time of her death. They said in a statement, in part, quote, "We're absolutely devastated by the loss of our beautiful daughter and sister, Anna Mariah Wilson. There are no words that can express the pain and suffering we're experiencing due to this senseless, tragic loss. Mariah was a talented, kind, and caring young woman. Her life was taken from her before she had the opportunity to achieve everything she dreamed of. Our family and all those who loved her will forever miss her. While we will not elaborate about the ongoing investigation, we do feel it's important to clarify that at the time of her death, those closest to her clearly understood directly from Mariah that she was not in a romantic relationship with anyone." Also, we've uncovered an interview Wilson gave to a cycling site called Pure Gravel just weeks before the race that she was set to ride in. She'd been planning for months to compete in the gravel locos in Waco and was actually favored to win until days before she was killed. Let's listen to her speak about the race that she never lived to ride.
I like the mixture of mountain and gravel is really exciting for me too. Because I love both, and it's been hard for me to categorize myself as one or the other, sort of. So I'm really excited for that. And then got a couple, just like, you know, a lot of the other big gravel events, BWR, Rule of 3, Gravel Locos.
And now authorities are still searching for Armstrong, last seen driving a 2012 Jeep Grand Cherokee with Texas license plate LDZ 5608. If you've seen it or Armstrong, you're asked to call U.S. Marshals at 800-336-0102. Wilson's family says she was very passionate about empowering women and building stronger communities, and they've created a GoFundMe page to set up a foundation to realize Wilson's charitable goals. Ted, back to you.
All right, thanks to Joylyn Necron. That case ongoing. Coming up, we're going to take a closer look at Johnny Depp's attorney, Camille Vasquez. But just a few moments ago, right now, Amber Heard arriving at the courthouse.
You're welcome. Have a good day.
Oh, sorry. Oh, that's all right. That's okay. Hi, good morning. How are you? Hello. Good morning. I know.
Amber Heard, who was there with her sister Whitney, who's been accompanying her all week since she testified. She's been able to then be part of the trial. She can be in the courtroom because of her testimony was over, so she's been arriving with her sister. We'll get a break in here, talk about Camille Vasquez, and we're expecting Johnny Depp to arrive at any moment. 15 minutes away from live testimony. Stay with us.
now.
Welcome back to Court TV Live. Johnny Depp expected to take the witness stand for his second time in his $50 million defamation suit against his ex-wife Amber Heard, all getting started. In about 10 minutes from now, we have our Court TV cameras in place inside that courtroom. They're also outside the courthouse where people have gathered, and they are highly anticipating the arrival of Johnny Depp. And I can see a monitor to my left, and he's just turning a corner about a block away from the courthouse, which is getting people very excited, as always. And every morning we watch his arrival, and we see this reaction. Here we go.
Alpacas, dinosaurs, all kinds of stuff. It's like paradise.
All right, Johnny Depp walking into the courthouse, talking to our cameraman, Austin Brady, who's out there every morning, and he noticed there was a dinosaur out there today, apparently. The crowd keeps getting larger and larger, and the attention this case has gotten stronger and stronger. In the past month, there's been a lot of attention about breakout performances by this person and the other. Well, Camille Vasquez is one of those breakouts. People have really taken to her. She's got a huge fan club now. Court TV legal correspondent Chanley Pater has more on Camille Vasquez.
That's the knife you gave to the man who was hitting you. You're the one who assaulted someone with a bottle in Australia. You weren't scared of him at all, were you?
From courtroom counsel to internet celebrity, Camille Vasquez has become known around the world for her zealous advocacy of Johnny Depp.
She would tell him he wasn't man enough because he wouldn't stay and fight with her.
She didn't let up when it came to her cross-examination of ex-wife Amber Heard.
As of today, you have not paid $3.5 million of your own money to the ACLU. Yes or no?
I have not yet.
Her repeated objections, now gone viral, had Heard's attorney struggling for momentum, all caught on TikTok and other social media platforms with millions of views.
Do you know whether the medical records from your EMT were produced in discovery?
Objection, Your Honor. Lack of foundation calls for speculation.
I'm asking.
Overruled if she knows.
Thank you.
Yes.
Okay. And do you recall? I'm trying.
The 38-year-old Vasquez has become the darling of Depp fans. Vasquez made her legal bones in California. She's an associate at Brown Rudnick. According to her firm's bio, her current practice focuses on plaintiff-side defamation lawsuits. She went to law school in Los Angeles, graduating magna cum laude from the University of Southern California, and received her law degree from Southwestern Law School.
No further questions, Your Honor.
Johnny Depp showed his appreciation for her cross-examination of Amber Heard with a hug and is often seen pulling her chair out for her. She does have critics who say her contempt for Heard's claims is a setback for abuse victims. But her supporters say she's standing up for male victims of domestic violence.
And still with us, Karen Felicia Nance and Josh Ritter. Josh, every night, a big trial like this, you get the attorney becomes a star themselves, and we're watching it with maybe an unlikely source of Camille Vasquez in that, she's younger, but boy, she's made an impression. Your thoughts?
Yeah, absolutely. She's really risen to the occasion, right? There's a lot of pressure. I mean, she knows the whole country's watching this, and she's doing a phenomenal job. And she's especially doing a phenomenal job in a difficult spot of cross-examining an alleged victim of abuse, right? I know from experience that is not easy because you have to walk a very fine line. You want to be a zealous advocate for your client, but at the same time, you cannot appear to that jury as though you're trying to re-victimize a person who's already suffered at the hands of domestic violence. But I think she played it very well. She waited until she had permission to really go after Amber Heard. And what I mean by that is she waited until Heard made it obvious to Camille, at least, that she was lying. And if you feel like you're dealing with a liar, then you can deal with them very differently and much stronger. And she was able to play that kind of dance, that delicate exchange there very well. I think she's doing a phenomenal job.
Yeah, absolutely. And has really gotten a lot of people's attention, and I would argue has probably motivated some people, some young people, to pursue a career in law, which would be wonderful. Karen Felicia Nance, thank you as always for your precious time on this Wednesday morning. Coming up, we'll go live to Fairfax, Virginia. They are ready inside the courtroom and outside the courtroom. The dinosaurs have shown up. Move over, Teddy the alpaca. We've got dinosaurs now at the Johnny Depp trial. Gets stranger and stranger. Live testimony when we return. Stay with us.
Get it before you need it.
She has a need for conflict. She has a need for violence.
But I was hitting you. It was not punching you.
Ms. Hurd had taken my cigarette from the ashtray and stomped it out in my face. She then grabbed that bottle and threw that at me. When she was in between us, Amber snuck in she reached, got the roundhouse in and nailed me on the cheekbone.
Welcome back. Top of the hour. Let's get you into the courtroom. Judge just took the bench. Johnny Depp versus Amber Heard getting underway. And as always, we start the day with a sidebar to get the rules of the road all set. Josh Ritter is still with us in Los Angeles, and Michelle Thomas joins us from Silver Spring, Maryland. Good morning, Michelle. What's your take right now in this case? Depp, a lot of talk. We understand Kate Moss will be the first witness today. Johnny Depp, though, also expected to take stand in the rebuttal. Good move, or what are your thoughts on bringing back Johnny Depp?
I think it's a positive move because he was a great witness for his case. He was clear, concise, he was believable, he sounded authentic, he was relatable to the jury. And so to have him have the final say and the final word, categorically denying the allegations by Ms. Heard, I think is a brilliant move.
Kate Moss dated Johnny Depp back in the day, Supermodel. And there was a rumor back that was out there in Hollywood that Johnny Depp had thrown Kate Moss down the stairs, and Amber Heard brought that up in her testimony, talking about the scary case incident, saying, and Kate Moss came to mind. And you saw the reaction that day from the Depp team, fist pumping, yay, we get to bring Kate in. Josh, what significance does Kate Moss have because she was an intimate partner with Johnny Depp, this monster?
Yeah, well, I'm imagining that in pretrial litigation, there was probably a lot of talk about Johnny wanting to call to the stand everybody he's ever dated to say he never laid a hand on me. Yeah, we got into fights. Yeah, we were passionate, but he never laid a hand on me. And they probably were precluded from doing so until Amber opened up the door by mentioning Kate Moss. And you saw that reaction from his team. We've seen that all over the internet. They loved it because they knew, fantastic, now we have an opportunity to bring this person to the stand. And I imagine we're going to hear exactly that type of testimony. We fought, we were passionate, we were, hot and cold lovers, but we were never violent with each other, and he never laid a hand on me. And that's going to have a huge impact on this jury.
And Michelle, that's it, isn't it? It's not necessarily the staircase incident, because we know that's not true. Otherwise, she wouldn't, the last person that they bring up. But it's the other part that Josh just talked about, and that is, hey, he never came close to hitting me, and that's what we're expecting. How important is that?
It's going to matter. I mean, no, it doesn't necessarily negate all the allegations because obviously Kate Moss wasn't there between Amber Heard and Johnny Depp. However, this is a matter of credibility, and it's going to serve to further undermine the credibility of Amber Heard's case by having an intimate partner deny that Johnny may be a lot of things, but abusive, he's not. So that's going to be impactful, I think, for this jury to hear from Kate Moss herself.
We also expect to hear from experts today, more experts to get into the minds of Johnny Depp and potentially Amber Heard. Dr. Shannon Curry's going to be back for a second bite at the apple. And at the end of the day, one of the arguments that has been made by the Depp team in openings, and Johnny said it on the stand, was, at 50 plus years old, I started hitting women. That's an interesting thing for people to think about. And Kate Moss, Josh, can possibly bolster that a bit, someone to reach back to during the close to articulate that nobody else except for this one person has come up with these types of allegations.
That's a really good point. We see that in domestic violence, that it isn't something that, all of a sudden appears in someone's history, that usually they have, a long history of kind of violence towards people, maybe violence towards children, violence towards animals, something like that. This isn't, and it would be an anomaly in his life, according to the way that we understand it for him, exactly as you said, at the age of 50 to all of a sudden start hitting someone, and not just hitting someone, but hitting and abusing someone in incredibly horrific sounding ways. I mean, punching a person in a face to the point that she lost count of the amount of punches, the sexual assault with the bottle. I mean, all of this is horrible, horrible stuff. And you do wonder, that's an excellent point and an argument that they will make. How does somebody go from 0 to 60 like that in their life, out of nowhere, with one person? No one can corroborate it. No one ever witnessed it. No one ever experienced anything like that before from him. I mean, the most we could talk about is Ellen Barkin said he threw a bottle one time. Even she said he never laid a hand on me. So it's going to be a powerful argument that I think we will see the Depp team drive home.
On the other side, Michelle, one could argue that, yeah, well, he was now dating someone younger. The jealousy was fueled, the drug, the alcohol, and she was a button pusher. Well, you can't hit button pushers. That's illegal. It's just like hitting anyone else. And that is really the Heard argument here. We're not, and do you expect that in close to sort of back off on Amber's holier than thou? But Amber, like anybody, doesn't deserve to be hit, and that's what we're alleging.
Yeah, I mean, that's very true, Ted. And I mean, I think that's a valid point. Just because it may not have ever happened before in Johnny Depp's life does not mean it didn't happen with Amber Heard. However, generally, I've litigated a lot of these domestic violence cases, and normally it escalates. Someone starts by being a little assertive, then a little more aggressive, then they hit one time, then they apologize, and then it begins to escalate over time until the person becomes this monster. I think it's uncommon where you just sort of wake up one day and just turn into a monster overnight. So I think it can certainly go both ways.
Josh Ritter, again, Kate Moss, we've been told, will be the first witness, or Chanley Painter. You can see her there in the courtroom, there in the second row, in her spot, has told us that. The significance of this witness, and she's not in person. She's in London, apparently, but it's live, and that's a lot different than these deposition playbacks, if you will. At least there'll be some back and forth. That makes a big difference, does it not?
Oh, absolutely. It makes a huge difference. I found that so frustrating that so much of the testimony was coming through in these taped depositions, because, you know, we're talking about taped depositions from years ago. Things have changed as far as, you know, how this case has developed, the strategy that each team is putting on. It's so important to have live testimony because of things like we saw with Camille. Well, she was able to kind of get into topics as they arose live there in court and watch it unfold in front of the jury. It's unfortunate she's not going to actually be in the courtroom, but I guess this is the next best thing, and it's going to be this is going to be one of the witnesses I think we'll be looking back on as being very impactful to Depp's case.
Yeah, and we're anticipating the beginning of it. You're seeing an extended sidebar here today. Each day they've been getting longer and longer as the stakes get higher and higher as this case winds down to its conclusion on Friday. We'll slip in a commercial break here. I want to thank Josh Ritter for his time and expertise. When we come back, Johnny Depp versus Amber Heard. It's day 22. Stay with us. Welcome back to Court TV Live. The extended sidebar continues this morning as we eagerly await day 22 of testimony in Johnny Depp versus Amber Heard. A live look inside the courtroom as Judge Escarate talks with the parties, trying to figure out the rules of the road for today. This is a practice every day. Make sure everybody's on the same page. Michelle Thomas is still with us. She's in Silver Spring, Maryland. And Michelle, you know this judge who has done, I think by most or all accounts, a very good job of herding the cats.
Absolutely, Ted. And I mean, Fairfax, they have very fine judges. And this, as you can see, is one of them. And it's so funny. Everyone's surprised how down to the minute we are, but that's how Fairfax is. You literally practice to the minute. They keep time, and when your time is up, that is it. So it's going to be interesting to see how both sides use these final hours that they have.
We understand from our sources inside the courtroom and our Chanley Painter and Grace Wong leading our team there on the ground that this sidebar is about not Kate Moss, but apparently the Depp team wants to introduce a recently discovered witness. We saw this play out yesterday. Michelle, in a case like this that's televised around the world, this is a possibility, and the case goes for 6 weeks. This is a real possibility that someone comes out of the woodwork. But how do you get someone into the, what needs to be done for an individual that says, hey, I have something to say, to get in at the 11th hour?
Well, you know, Ted, if they're coming in for the purpose of rebuttal, which at this point, as we're seeing Johnny Depp's rebuttal case, or if they're being brought in for the purpose of impeachment, you don't have to disclose those witnesses in the beginning in trial preparation when you're providing your witness list to the other side in preparation for trial. So essentially, as long as they can testify to rebut one of the allegations set forth by Amber Heard's case or impeach some of the testimony that we've heard previously in Amber Heard's case, they're going to be able to bring this witness in most likely to testify.
You can tell the intensity today because normally they'll send 1 or 2 members of each team to Judge Escarate's bench. Everybody's there today. Whoever this person is, this seems like this could be a big one. And in cases like this that could go either way, one would argue, every one of these little bits of evidence that is or is not introduced makes a difference.
Yeah, they're probably at the bench making proffers as to what the witness is likely to say. They're probably weighing the prejudicial value versus the probative value of the witness's testimony at the bench and arguing that to the judge. But to your point, as we come down to the wire, every single witness, testimony, allegation, statement matters. And so neither side wants to let anything go, as they should. They should be fighting hard for their clients the entire time.
What have you made of the legal force that both parties have brought to this case? Our Court TV viewers are used to a lead attorney, sometimes a public defender, and a few folks from the state. Every now and then we get a high-profile case with some high-profile attorneys, but there's 2 or 3. There's an army on each side, and the ones in the courtroom don't represent the entire effort.
That's absolutely correct. There's a lot of people behind the scenes for both firms working to make this happen. But this is what happens in private cases when there's money involved. If you can afford to have 4, 5, 6 lawyers on your team, then that's what you're going to do. And what that does is it enhances your ability to focus on each witness. So each lawyer can take 1 or 2 witnesses, get into the details for preparation for direct exam and cross-exam, as opposed to trying to cover everything, which makes it a whole lot harder for 1 or 2 lawyers to do. So that's what we've seen in this case, and Johnny Depp's team has done it, quite frankly, somewhat masterfully in terms of dividing the witnesses and ensuring that they are precisely prepared for cross-examination for each of Amber Heard's witnesses. So we've seen them take a much more aggressive approach, I think, than Amber Heard's team.
And the stakes obviously are incredibly high when you talk about the investment that both sides have put in. If you get a big goose egg at the end of the day from the jury, that stings.
It stings, especially when you get that legal bill at the end of the case, because when you have 4 or 5 lawyers on a team, you're looking at significant, substantial attorney's fees. And if you have 0 to show for it, that definitely hurts.
clearly creeping into the 7 figures for sure for both sides in terms of an investment in this case for preparation and just the trial alone, 6 weeks.
Yes.
And at the end of the day, the jurors are really in a potentially difficult spot because it's who do you believe? And then when you choose one or the other, it's, all right, well, how much do we give them?
Well, yeah, there's the whole damages issue that certainly Johnny Depp's team has dismantled the alleged damages case from Amber Heard's side by their rebuttal expert witnesses. But also this jury has to recall 6 weeks worth of information and data and be able to sort through all of these witnesses and now rebuttal witnesses. And so the jury, I don't envy them. They definitely have a tough road ahead in making this decision and even understanding all the issues before the jury.
And again, the schedule at this point is, and it's pretty firm, the judge has been clear on this, Friday morning, 9 o'clock, closing arguments. The jury will start that deliberation process Friday afternoon. Let's get another break in since this major delay is Johnny Depp's team is trying to introduce what has been characterized to court TV as a recently discovered witness. They're hashing it out at the judge's bench. We'll see what happens right after this.
Today.
Welcome back to Sidebar has broken up. The jury's in the courtroom, and Kate Moss is the first witness. Let's go.
Do you swear or affirm to tell the truth under penalty of law?
I do.
Thank you.
Good morning, Ms. Moss, or I should say good afternoon, your time. My name is Ben Chu from the firm of Brown Rudnick. Would you please state your full name for the record?
Kate Moss.
Ms. Moss, where do you reside?
London, England.
From where are you testifying today, Ms. Moss?
Gloucestershire, England.
Ms. Moss, do you know Johnny Depp?
Yes, I do.
How do you know Mr. Depp?
I had a relationship with him.
Did there come a time when you and Mr. Depp had a romantic relationship?
Yes.
For how long, Ms. Moss, were you and Mr. Depp a romantic couple?
From 1993 to 1994 to 1998.
Ms. Moss, did there come a time when you, while you and Mr. Depp were a couple, that the two of you took a vacation together to the Golden Eye Resort in Jamaica?
Yes.
What, if anything, happened when you were in Jamaica with Mr. Depp?
We were leaving the room, and Johnny left the room before I did, and there had been a rainstorm, and as I left the room, I slid down the stairs, and I hurt my back.
How did you...
And...
I apologize, Ms. Moss. Please continue.
And I screamed because I was because I didn't know what had happened to me, and I was in pain, and he came running back to help me and carried me to my room and got me medical attention.
Did Mr. Depp push you in any way down the stairs?
No.
During the course of your relationship, did he ever push you down any stairs?
No, he never pushed me, kicked me, or threw me down any stairs.
Ms. Moss, have you ever before today testified in any kind of court proceeding?
No, I have never.
Why did you decide to testify today?
Objection, Your Honor.
All right.
That's beyond the scope of what we just talked about.
All right, I'll sustain the objection. All right.
Thank you, Ms. Moss. We have nothing further at this time. We greatly appreciate your taking the time to testify.
All right, any cross-examination?
No, Your Honor.
All right, you're free to go. Thank you, Ms. Moss.
Thank you very much.
Thank you very much. Thank you.
All right, that was short and sweet. Kate Moss on the stand from England testifying. Not on the stand, but via video. We'll get a break in here. Next witness coming up. Johnny Depp continues his rebuttal case. It's Depp v. Heard right here on Court TV. Stay with us. Model Kate Moss testified just a few minutes ago and said the staircase incident never happened. Next witness for Johnny Depp in his rebuttal case is someone we've seen before, Dr. Shannon Curry, back on the stand.
Plaintiff calls Shannon Curry, Dr. Shannon Curry.
That's fine, ma'am. You're still under oath, so please have a seat, doctor.
Good morning.
Good morning, Dr. Curry.
Good morning.
Can you remind the jury who you are and what you do?
Sure. I'm Dr. Shannon Curry. I'm a clinical and forensic psychologist, and I'm here today to rebut the testimony that was provided by Dr. Hughes.
Which of the opinions rendered by Dr. Hughes do you intend to rebut?
So generally speaking, there are three main categories that I'd like to talk about today. So the first is that Dr. Hughes misrepresented the tests and the results that she utilized in her evaluation. She misrepresented my testing and the results that I obtained in my evaluation. And she communicated in a manner, provided testimony in a manner that presented essentially her own opinions and the self-report of Ms. Heard as facts.
Okay, the first category you talked about was a misrepresentation of her own test methods and results. What do you mean by that?
So Dr. Hughes she stated that she administered 12 tests. In actuality, she used 8 checklists. About half of those were symptom checklists. The other half were checklists about experiences that people can have with domestic violence. And those are not appropriate for forensic settings. They are easily exploited.
Other issues that you intend to address relative to misrepresentation of own results?
Yes, so in addition to using these checklist measures, which are easily exploited in a forensic context, they're developed for research or treatment only. She also stated that these checklists revealed things that they simply cannot reveal, especially in this context. Let's see. She also misrepresented information, clear indications on several of the objective measures that she offered. And there were indications visible that Ms. Heard had essentially engaged in what we call response distortion. So clear indications of exaggeration on one of the measures that's specific to PTSD, clear minimization of symptoms intentional on another more broad personality and psychopathology-based measure that she gave to Ms. Heard, which she did not acknowledge.
Did you intend to address anything relative to the CAPS-5?
I did. So Dr. Hughes administered the CAPS-5 about 10 days after I did, almost 2 years after she initially tested Ms. Heard. And she did not administer the test appropriately. So she left major components blank. She didn't apply the scoring rules that are clearly outlined with the test. And yet she diagnosed Ms. Heard with PTSD based on that assessment.
What about Dr. Hughes's use of the personality assessment inventory?
So of the tests that Dr. Hughes administered, 2 would be considered, of those 12, 2 would be considered what we call forensically relevant instruments, meaning that they're objective enough and they provide us with some information about how the examinee approached the test, that it would be appropriate for this setting where the examinee is going to have a natural incentive to present themselves in a way that benefits the outcome of their case. Now, on the PAI, there were clear indications that Ms. Heard was responding and obtained scores in a manner that's consistent with individuals who have a personality disorder. And there was also an indication that several scales, we call this a configuration. So you might have one main scale that you notice is elevated, but then you look for additional subscale information to get additional information on what could be elevating that scale. And there was a configuration that showed that even though Ms. Heard had moderately elevated one of the scales that can be associated with trauma, that elevation is better explained by childhood or distant traumatic experiences like the complex trauma Ms. Heard reported experiencing growing up.
Okay. You said that Dr. Hughes utilized checklists that are not appropriate for forensic analysis. Can you explain that?
Yes, so as I said, in any sort of forensic context, whether it's a civil or a criminal matter, a person who's being evaluated is going to have major incentive to present in a way that benefits the outcome of their case. So you always approach the examination, I believe Dr. Hughes said, with a healthy dose of skepticism, but that alone is not enough. We have to operationalize that. So we actually have to administer very comprehensive objective tests that either control for attempts to manipulate the test results or reveal attempts to manipulate the test results, so that we're not just blindly accepting the results or the self-report of the examinee.
How many tests were administered by Dr. Hughes?
She said that she administered 12 tests.
How many of them were appropriate for forensic physical examination?
So the trauma symptom inventory is appropriate. It's an objective measure, and it does have two primary scales that look at how the person approached the test. The personality assessment inventory is an excellent test. It is a broadband measure, meaning that it captures not only symptoms of mental illness, but also general personality traits. That also gives us pretty detailed scales similar to that one test I administered, the MMPI, that tell us a lot of nuanced information about the way the person approached the test. She also administered a malingering screen that can be very, very useful, but not in this context. So it's called the Miller Forensic Assessment Symptom Test. It's a brief set of questions that you ask the examinee, and it's been shown by research to be extremely effective at identifying an examinee's attempts to fake a severe mental illness or psychosis. And psychosis is when somebody loses complete connection with reality. It's excellent for that purpose. It's actually been shown in the research to not be effective at all for identifying a respondent's attempts to fake PTSD, anxiety, or mood disorders. The questions are just too odd for somebody who has the wherewithal to be trying to have PTSD to endorse. They see through it. So she used that. That's a fine test, but not appropriate for this context.
Of the various tests that she administered, how many were these checklists?
8 of them.
All right, and what are you talking about specifically?
Okay. So I had mentioned that there were 2 main categories of checklists she used. The first is the symptom checklists. Those included the Beck Depression Inventory. It's a brief inventory of items that essentially show all of the symptoms of depression that a person might have, and you rate which level of severity you have for each question. She also gave the Beck Anxiety Inventory, very similar, but just with questions about anxiety. She gave the Mood Disorder Questionnaire, which is a very brief, again, checklist. It shows symptoms of bipolar disorder. Bipolar disorder is a mood disorder where you might have an extended manic episode and then a very extended depressive episode. And then she gave the post-traumatic stress disorder checklist, and that is a screening instrument only. It contains every single symptom of PTSD. So there's a secondary danger here too. When you think about it, given that PTSD is the most frequently feigned and claimed diagnosis in civil courts, if you're handing somebody a checklist that lists every single symptom of PTSD, you're essentially teaching them all the little nuances that we're looking for to give that diagnosis. So she gave that to Ms. Heard. Ms. Heard endorsed most of the items, and Dr. Hughes diagnosed her with PTSD and substantiated that opinion by Ms. Heard's checking those items on the PCL-5.
Okay. Were there another group of checklists that Dr. Hughes used?
Yes, so she also, and I forgot one on the last because I don't think of it as one, but Previously, I'd explained, and I do not expect you to remember, it's called the Life Events Checklist, which is just an inventory of experiences a person may have gone through that are traumatic. Dr. Hughes also used that, and that's appropriate to use before the clinician-administered PTSD scale, the gold standard CAPS-5. However, she administered this long ago before she gave the CAPS-5. Now that going on to the second group, there were 3 checklists that she gave that are specific to abuse. And the first she gave, the Danger Assessment Scale, was actually developed for use by nursing staff in an emergency room setting, specifically for female victims of intimate partner violence. The purpose of this is important because our forensic ethics, our psychology ethics, talk a lot about relevance. Is the test relevant to the purpose? And the Danger Assessment Scale, its initial purpose was completely different. This was developed to show high risk factors for dangerousness and pretty much to help a female who is in an extremely abusive partnership, who is in the emergency room with extreme injuries, to stop rationalizing, because if she has to check off all the things that have happened that year that have been dangerous, does he own a gun, has he, I won't go into all of them, but the more she checks off, the more likely it is that she might realize that she is in imminent danger and then accept resources offered by the hospital and social work to protect her. That was the purpose of this scale. It was never intended to be used as a retrospective measure to look back in time and find out whether abuse was occurring based on one person's report years later in a litigation. She also gave the Conflict Tactics Scale, revised, the second edition. Similarly, this scale was developed for research purposes, to research family violence. Again, there is no control for exaggeration or minimizing. It was just given to research participants anonymously so that we could get data on the prevalence of abuse and how abusive dynamics work. And on that, there's 39 questions where the respondent indicates essentially certain abusive behaviors they may have engaged in, and then 39 where they indicate behaviors their partner might have engaged in. And obviously, you can understand that in a forensic setting, the respondent is likely to put a very minimal amount of behaviors they engaged in, and then extremely increase the number of behaviors their partner might have. And then lastly, let's see, the abusive behaviors observation checklist was the third checklist she gave. This one has not, there's no known research even on its effectiveness for what it was developed. It's a theoretical, very brief checklist that was meant to be used for therapy, where an individual who had experienced domestic violence could essentially read through some of the behaviors that constitute violence that they might not have been aware of. And if those behaviors applied to them, or if some of those coping strategies were ones they utilized, they would check that off, and then they have a way to talk about it because now it's been put to words. Again, this is similarly problematic if you're in a civil litigation, the person's motivated to have their results be consistent with a claim or an allegation of intimate partner violence and an allegation that they've been severely harmed, then they could simply just check off more. And not only that, but checklists like this one specifically give a lot of nuanced information about what clinicians might be looking for when they're assessing whether violence was present or whether the person's self-report is consistent with a genuine self-report of having been victimized. They're given all that information that we might be looking for.
Can you talk specifically about Dr. Hughes's use of the, I think you called it the PCL-5?
Yes. So the PCL-5 is the post-traumatic stress disorder checklist. This is different, not to be confused with the CAPS-5, which I've talked about previously as being the gold standard. The PCL-5 was developed by the National Center of PTSD. It's intended for treatment. So if I were, for instance, working with a service member who I know had been in combat, I would probably give this as a standard with my intake. Before we do the diagnostic interview, it kind of gives me a read on how somebody who's there for treatment, who we assume can be taken at their word because If they give us correct information, they're going to get an appropriate treatment. And if they give us incorrect, they might not get the treatment they need. So I would give this checklist to them, and then if they recognize some of those symptoms of PTSD, they could check it off. And that would probably indicate to me that I need to then do the next step. If they're checking off more items than not, I would probably decide to administer the clinician-administered PTSD scale, that gold standard interview, to find out more about a diagnosis.
The last thing is what everybody refers to as the CAPS-5.
Yes, the CAPS-5.
All right. What about, well, you talked about forensic use. What do you mean by that?
So when I'm talking about forensic evaluation, that's an evaluation that isn't done for therapy or treatment. It's specifically to assist the fact finder, to assist the judge or the jury in the court by providing information about the psychological status about an individual. And that's an important delineation too. We are not psychologists. I wish we were mind readers. I wish we had a crystal ball and could find out whether intimate partner violence occurred and look back in the past. But it's nothing like that. Really, it's a lot less interesting. We look at data. We have to control for those response biases. And then we also are looking at functioning, which is really the bottom line of the assessment. Did the person have a change in functioning from before the alleged trauma, or in this case, the alleged IPV, to after? Is there a decline in the way they're going about their lives?
Objection, Your Honor, may we approach?
All right.
Okay, sidebar. Dr. Shannon Curry on the stand still with us is Michelle Thomas. She's in Silver Spring, Maryland, in the D.C. area there. Gives us a chance to talk about Kate Moss. Very quick, to the point, didn't throw me down the stairs. No cross. Your thoughts on Kate Moss?
I mean, she was obviously convincing and compelling, and they kept her testimony so concise that there really wasn't much to cross on. Her testimony and explanation of what happened was believable, it was credible, and so there really wasn't much left there. They kept it narrowed, her testimony narrowed to rebut specifically the allegation regarding Johnny Depp throwing her down the steps. She denied that. There's not much more to say. It would have been nice if they could have found something to cross-examine her on, just to sort of just give that illusion of pushing back, but there really wasn't much there.
Yeah, and you don't want to give the other impression that you're pushing back on Kate Moss. Are you kidding me?
There's that.
All right, sidebar is broken up. Let's go back in.
Dr. Curry, let's look back at some of those domestic violence checklists that you were talking about.
Okay.
And did you see any problem with the use of those?
Yes.
What problems did you see?
Well, Doctor, first of all, they shouldn't be used. So we do have professional standards that require that we utilize instruments that are relevant and appropriate for the particular setting, and that we substantiate our opinions based on data that is reliable from tested, accurate, reliable tests for the purpose. So there's that. It's inconsistent with the ethics, and essentially they just shouldn't be used. They don't provide us with the robust information that it would be expected in such a high-stakes setting.
Would you have expected Dr. Hughes to comment on the limitations of the checklist she was using?
Yes. So, first of all, Dr. Hughes provided opinions based on these checklists. So she referenced especially the danger assessment scale several times throughout her testimony, stating that Ms. Heard was in a very dangerous situation. We also have an ethical guideline and a professional standard as well that indicate that whenever there is question about the reliability and the validity, and in psychology we use the term validity to talk about accuracy, of any of the methods that we're using to collect data, we clearly communicate not only that there are limitations to our opinions, but we also need to provide the fact finder with information about what the potential implications or impact could actually be. So, for instance, if we use a scale that's idiosyncratic for the purpose, but we would first need to explain why we made that decision to not follow standard procedures. And then we would need to explain the use of this scale might introduce some potential exaggeration of this symptom, and so I'm trying to control for that way, but that was one of the limitations of my opinion. You have to make it very clear. Transparency is really at the center of good science in general.
You talked a little bit about ignoring response distortion. What is response distortion?
Response distortion is a term that speaks generally about an examinee approaching a test and providing answers that are either exaggerated or minimized, but in some way an inaccurate representation of their current mental status or their experience.
What test do you believe that Dr. Hughes failed to acknowledge response distortion on?
So she administered the personality assessment inventory, which is similar to the test I gave the MMPI-2. It's that general broadband measure of psychopathology symptoms and personality traits. It includes several scales that are very good at detecting either exaggeration, minimization, or even trying to claim that you have unusually good qualities. On that test, there were clear indicators that Ms. Hurd, very similar to the way she approached my MMPI, engaged in defensiveness. And in fact, there's a function that you can look at. So you have that main scale elevation, we call it positive impression management, was elevated. And then, because we want to make sure that somebody isn't elevating that scale just because they have such well-being, there are additional configurations of scales that you can look at to find out what's going on. And so the Cashel discriminant function is sort of the name of one of these configurations, these equations that are done. And she was highly elevated on that. In fact, that elevation tells you that no, this isn't accidental. This isn't because she's just doing so well in life that she has an extremely, extremely low amount of problems. No, this is an intentional over-reporting, or I'm sorry, an intentional effort to minimize any appearance of having problems.
Now, you may have addressed this, but there was a reference to malingering.
Yes. So what's interesting about Ms. Hurd's approach to different tests is that it seems to be influenced by what we call the face validity of questions on the test. So if a test looks like it's measuring PTSD, you see exaggeration on her validity scales. If the test has less face valid questions, for instance, the personality assessment, which Dr. Hughes administered, the MMPI-2, which I administered, where she can't quite figure out what the questions are asking, they seem really banal in general. On those, you see extreme defensiveness, minimization of any potential pathology, essentially presenting herself as perfect and free of any mental illness or personality disorder. But on the trauma symptom inventory, which Dr. Hughes administered, that was the one that I previously indicated for ease of explanation. When the test results come out for how the person approaches the test, that test itself prints it as a percentage. And there's a really excellent scale for finding out if a person is exaggerating their symptoms of PTSD. It's called the atypical response scale. And the TSI-2 is the revised version of this test, and that scale was improved this time around to really try to be a clean indication of, is this person exaggerating? And it puts quite high questions in the test that are so unusual. They might sound like PTSD, but even the most severe cases of PTSD don't have these symptoms. And so somebody who's intentionally trying to exaggerate PTSD, or possibly unintentionally, but nonetheless, who's exaggerating it, is likely to endorse these items, even though they're not real PTSD symptoms. Ms. Hurd scored so highly on this that even if there is, although Dr. Hughes correctly said there tends to be a negative skew when people have the high levels of distress that's associated with PTSD, so sometimes People score higher on this even when they do have PTSD. She scored so high that that is effectively ruled out as a possibility.
Okay. What about Dr. Hughes's administration and use of the CAPS-5?
Okay, yes. So Dr. Hughes had diagnosed Ms. Hurd with PTSD back in 2019 when she began testing her. It wasn't till 2 years later, more than 2 years later, 10 days after I administered the CAPS-5 with Ms. Hurd, that Dr. Hughes held an impromptu evaluation session remotely with Ms. Hurd and administered the CAPS-5. She had previously diagnosed PTSD without using what we consider to be the gold standard PTSD diagnostic interview.
Dr. Shannon Curry continues her testimony as we approach the top of the hour. We need to step aside and take a break. We want to thank Michelle Thomas for her time and expertise. More after this.
hard work pays off.
Top of the hour. Welcome back to Court TV Live. I'm Ted Rollins. Glad to have you along with us on this Wednesday. The final week of testimony in Johnny Depp versus Amber Heard. It is day 22 of testimony. Dr. Shannon Curry is back on the witness stand as an expert for Johnny Depp in his rebuttal. Let's go back into the courtroom, pick it up right where we left off.
Again, when we're doing a forensic evaluation, it is an important responsibility, and part of our ethics and professional standards are that we document everything to allow for transparency and full judicial scrutiny. And Dr. Hughes administered incorrectly. She left huge sections, very relevant sections, blank. There's no way to understand why she scored it as high as she did based on the information that's provided. You're essentially supposed to notate the examinee's responses as verbatim as possible to explain your reasoning and implying their scoring procedure. It's a standardized test, and if you don't follow those standard procedures, it's completely invalid. Not only that, but it looks as though Dr. Hughes further invalidated it by trying to show that she had assessed for the childhood trauma impact, and she had said that she went back and asked the childhood question, but you can't do that. If you're assessing for two separate periods of one's life to find out the relatedness to PTSD, you do two separate CAPS interviews, period. You don't create your own question system. That is non-standard administration of the test, and it invalidates it.
All right. You also mentioned, with respect to the PAI, or the Personality Assessment Inventory, that Dr. Hughes failed to mention some elements. What did she fail to mention?
Oh, okay. So on the personality assessment inventory, so first she failed to mention that there were clear indications of response distortion. She also failed to mention that Ms. Heard scored in her score profile against their main scores. She did elevate a score for the borderline personality disorder sort of section, but that in and of itself would not indicate a diagnosis. However, the configuration of her scores overall is consistent with that, and in fact, it's one of the diagnostic suggestions given by the test itself. And then also, there's a configuration around Ms. Heard's trauma responses on that particular test, which demonstrates that it is more likely that those symptoms were reported in relation to something in the distant childhood. It's more consistent with childhood chronic abuse than present circumstances or recent circumstances.
Okay, I think you said, in addition to the issues with her own testing, Dr. Hughes misrepresented your results.
She did.
Can you tell us how?
So, I would say the main issue was that she said that Ms. Heard obtained a normal profile on my MMPI-2.
All right. How do you disagree with Dr. Hughes relative to the profile?
Okay, so the profile was not normal. So Ms. Heard already had subtle elevations just by the test by itself as it came out. There were subtle elevations, but they were elevations that, if the validity scales hadn't been as elevated as they were, you might have said this person has some traits, but this isn't necessarily at the level of a true pathology. However, Ms. Heard elevated a scale that essentially is a defensiveness scale on this test. And when you're giving this test, you always are mindful of different norms or groups who may have similar profiles. And there are certain groups of litigants who tend to elevate this scale as well. So I had that in mind. However, Ms. Heard elevated this so much that it was far beyond the mean for the litigants that are known to have the highest levels of this scale, this defensiveness scale. And when this scale is elevated to the level that it is, you automatically understand that it is very likely that those clinical scales, I keep doing this because I'm seeing it in my head, it looks like sort of an ECT. It's sort of these peaks you see on a graph. And when you see these peaks, And you have this huge peak over here for the defensiveness scale. What you know is that these peaks are they've been lowered or suppressed based on the respondent being so defensive. They still detected what's likely there for her, but it's not as high as it should be. So you make an adjustment. And the recommendation is that anything at 60 or above, we call it a T-score of 60, or above is considered significant. Ms. Hurd's were already over 60. Some were quite higher than that. And then you see a very clear profile. And that was how I got that. I had mentioned a 3-6 code type. Now, the test does its own correction also for some of the scores, but not the ones that are her main code type. With the test correction, she had a 1-3-6 code type, which is very similar.
What is a 3-6 code type?
A 3-6 code type is something that has been researched and found to be highly correlated or probabilistic of certain behavioral tendencies and personality traits. And the traits with a 3-6 code type tend to be marked by a lot of externalization of blame, a lot of denial about one's own personal faults, intentional or not intentional, but just extreme denial, hostility that is strongly controlled and suppressed. The person may not even realize how hostile they are, but family members, those closest to them, are very likely to report that they lose their temper, and when they lose their temper, it explodes. We have sort of what we call a cookbook for these code types, which will provide you with all the information that's been researched to be associated with them. And our cookbook actually states that 3-6 profile specifically tends to be associated with cruel and ruthless behavior, particularly to those who they perceive as less powerful than them and subordinates.
Describe for the jury the review process that you went through relative to the MMPI.
So I conducted a very methodical analysis of the scores. I do this for every test, and I also did it when I was reviewing Dr. Hughes's scores. So what you haven't seen that's in Discovery is that I created a 25-page outline just of her scores with, and it's sort of a table. So I'll put the score, I'll do it in sections so that I can understand different groupings, different research studies, and I start with looking at all the validity scales. So I put in the score, and I'll even color the table to show me if it's kind of in the high zone, moderate zone, or low. And then if it's low, is it a significant low score, or is it just low so it doesn't mean anything? And then in the right side, I put all the research data that I found on this particular scale score. And so I start with the validity scales, the way the person approached the test. Then I go down to essentially, we call these the first factors. So their overall sense of well-being and how well they cope. On this, actually, Ms. Hurd's, she endorsed scores or endorsed items that were the opposite of PTSD. So really saying that she feels free of distress and that she views herself very well. So then I go down to control, self-control, loss of control, coping abilities, and I put in the scores that are associated with that in the research and the test development. Then I go down to clinical and personality pathology, and I look at all the scores that are significant there, first with the top level main scores, then with all of the different sub-scores, again, citing the research, the meaning, the level of elevation, and what that means. And then I do comparison with different research groups. So for Ms. Hurd, I did a section that looked at all sorts of different scores that have been implicated with a PTSD presentation to see if any of those were consistent. I can't remember how many there were. I think I put 13 on there, but I could be wrong. But I believe that there was only one that could even be, in some research, is sometimes associated with it, but it was general anxiety, which turned out to be more trait specific. I looked at the scores that are typical of women with IPV. Hers were not consistent at all with those. I looked at the scores that were consistent with people who are frequently in litigation. Hers actually were very highly correlated with those. That tends to be also consistent with a 3-6 code type, and the reason for that is believed to be that they tend to perceive themselves often as victims who need to avenge wrongs.
Were there other results you believe Dr. Hughes to have misrepresented? For instance,
Whatever.
the TSI-2.
Yes. So Dr. Hughes generally said that testing supported PTSD and that there was an etiology for her trauma of intimate partner violence. She did reference that essentially I can't remember if she said that the trauma symptom inventory indicated PTSD, but she did say that the elevation on that validity scale is consistent with PTSD, and that's simply not true. That scale was designed and has been tested and shown to be there to show when somebody is endorsing extremely unusual items that are not consistent with PTSD. And even though when some people are experiencing PTSD, their distress level is so high that they'll engage in what we call a cry for help, and they may sometimes exaggerate distress. Again, when you're looking at scores as high as Ms. Hurd's, and then you're not seeing indications of PTSD in the more subtle tests where she doesn't know what she's endorsing, it's good evidence that her over-endorsement on that one test is because of the reason the scale was made, to detect exaggeration and feigning of symptoms.
Is this the test that resulted in the 98 percentile
Yes.
score?
Yes, on that atypical response scale.
And what does that 98 percentile score represent?
So that 98th percentile score just represents that among 98% of people who take that test would not have endorsed. She scored more of those unusual items that are not consistent with PTSD than 98% of people who have ever taken that test.
Does that relate to this concept you talked about before called feigning?
Yes.
What is feigning again?
Well, feigning is essentially exaggerating symptoms of a disorder.
Quick break. Back with more testimony. It's Johnny Depp versus Amber Heard, day 22, when we return.
Go to prettylitter.com.
Back we go to the courtroom. It's still direct on the rebuttal case, the second appearance for Dr. Shannon Curry. Let's go back in, right where we left off.
I think the third thing you indicated you were going to talk about was self-reports and personal opinion as facts. What are you talking about there?
So in any science and in psychology specifically, it's really important that we use precise language and we say what we mean and we do not present opinions as facts, because when you are in the role of an expert witness or an expert in any setting, essentially a layperson may not be able to detect the difference between something that is a personal opinion that you're giving versus something that is substantiated by research data, test data, reliable test methods. So our ethics talk about, especially the specialty guidelines of forensic psychology, the responsibility we have to distinguish between data, then inferences we're making from that data, what the data can mean, sort of like those tables I do. I put the data, the inferences based on the research, and then what my ultimate opinion is, integrating all of that data. And it's very important that we clarify that to the fact finder, to the judge, the jury. That's our responsibility, that we do not cloak personal opinions or the self-report of an examinee as an expert fact or somehow scientifically based when it is just a personal opinion or self-report of an examinee.
What do you mean by self-report?
The self-report is essentially what the examinee tells you during the interview.
Okay. When did Dr. Hughes do this most?
She did this most when describing instances of alleged IPV. And there's also an issue there because one of our ethics also discusses the importance of relevance and withholding, essentially constraining our testimony to the data and not including private information, personal information that unnecessarily compromises the dignity of any of the litigants. She provided a lot of what was Ms. Heard's report to her, the allegations of abuse, when describing Mr. Depp, who she had not examined, when describing Mr. Depp's behavior, his motivations. I believe she used the word obsessive jealousy quite a few times, talked about Ms. Heard being in a highly dangerous situation. These are simply things that we cannot detect based on testing and a psychological evaluation. We have to evaluate the person, we have to get consent, and we can only describe an individual, not whether or not IPV has occurred. And we certainly shouldn't go into explicit details about sexual encounters or other things that are highly prejudicial, shocking, and hard to forget.
All right. Dr. Hughes says that Ms. Heard has PTSD. Do you agree?
I do not.
Why not?
The results of my multi-method comprehensive evaluation based on carefully selected, researched, relevant test instruments, based on comparing those instruments to Ms. Heard's self-report, observing Ms. Heard's behavior over 12 direct hours of assessment, reviewing copious notes from prior therapists who indicated symptoms in their notes, reviewing the notes of Nurse Filati, previously Nurse Borum, who spent, I believe at one point, almost 2 months with Ms. Heard daily, reviewing the notes of her treating providers, all of the legal documents and discovery. There was no evidence of PTSD.
How is evidence of PTSD generally exhibited?
So really the bottom line in a forensic psychological evaluation is a change in functioning. That's what we're looking for. Again, I said we don't have a crystal ball. We're not wizards. We can't get into somebody's head. What we're looking for were there identifiable changes in the way the person engaged in their world. Were they able to keep a job? PTSD is an extremely disabling diagnosis. When a person has true PTSD, it is difficult for them to work. You'll see unemployment, job loss, it causes extreme levels of distress and impairment. There's divorce, there's isolation and estrangement from children, from family members, extreme alcohol abuse, often a string of sudden DUIs when the person never had any before. They become homebound, they can't go to the store. They're certainly not going to events. They're not having success in their film career, usually. They're not exercising every day, pursuing their hobbies, being avid readers, obtaining level 3 sommelier training, having dinner parties with friends, speaking to public groups. Those are just indications of very high functioning. And when you're looking for a decrease in functioning over time, that is inconsistent with that decrease.
What about Dr. Hughes' suggestion that Mr. Waldman's statements served as a trigger for Ms. Heard's PTSD?
All right.
All right, sidebar. Let's slip in a commercial break here, and we'll have more from Dr. Shannon Curry right after this. Stay with us.
6363.
Dr. Shannon Curry is back on the stand. We've been watching her for the most of the morning. Kate Moss started the day for the Depp team, but she has taken the rest of it. Let's go back in after the sidebar concluded.
Dr. Hughes had suggested that perhaps Ms. Heard's PTSD was somehow triggered. What's your view on that?
I would say that it can't be triggered if PTSD isn't present.
Thank you very much, Doctor.
All right, cross-examination.
Thank you.
All right, what do you do with Dr. Hughes on cross? Let's see how aggressive it is. Keep in mind
Curry,
time,
I just
too.
want to make
Oh,
sure
here we go.
that we all remember, you're not board certified, correct?
No, I'm not.
Okay. And you've been licensed for how long?
I've been licensed for 10 years.
Okay. And you are being paid by Mr. Depp's legal team to be here, correct?
Yes.
How much have you charged so far?
I actually don't know.
Over 100,000?
I truly don't know. I don't do my own books.
Over 200,000?
I don't know.
Over 300,000?
That would be way too much, but I do not know.
Okay. Now, just so that we all remember, you had dinner at Mr. Depp's house for 3 to 4 hours with Mr. Depp, Mr. Waldman, Mr. Chu, and Ms. Vasquez, correct?
I was interviewed. I asked if there was anything I could eat because at about 3 hours I started to get hungry. Mr. Depp then offered to order takeout for the entire team.
So you had dinner with at Mr. Depp's home with Mr. Waldman, Mr. Chu, Ms. Vasquez, and Mr. Depp, correct?
Yes.
And you had drinks as well, correct?
I actually don't know. I do remember that there were drinks.
Do you recall testifying earlier that you did have a drink, a mule something?
No, I remember testifying that there might have been a mule, a Moscow mule.
Okay, thank you. We didn't have animals there as well, right?
No animals.
Okay, that's good to know. And you talked about transparency. I just want to make sure you had several designations, expert designations and reports in this case, correct?
Yes.
And in not one of them did you disclose that you had dinner and drinks at Mr. Depp's house for 3 to 4 hours with Mr. Waldman, Mr. Chu, and Ms. Vasquez. Is that correct?
Ms. Bredehoff, you're mischaracterizing what occurred.
Dr. Curry, please answer the question. Not once did you disclose this in any of your reports,
I did not
correct?
disclose that I was interviewed as that standard procedure.
But it's true that you have never gone to a client's house to be interviewed for an expert witness position, correct?
Yes, because I never had a client that was essentially homebound because of their celebrity status.
All right. And you talked to Mr. Depp for 3 to 4 hours before taking on the role of assessing Ms. Heard and deciding whether she was suffering from any distress, correct?
I did not talk to Mr. Depp. I was talking to his legal team, and he was there to observe.
He was present for the 3 to 4
Yes.
hours. Oh, and are you saying now he just stayed silent and said nothing all day?
I don't recall what he didn't or didn't do. I was answering questions.
Okay. Now, your expertise here is limited to whether Amber Heard suffers from PTSD currently. Is that correct?
Yes, I was tasked with conducting an evaluation to determine
Dr.
Ms.
Curry,
Heard's mental
We're all on
status.
very, very strict time limitations
Okay.
because we've promised to get this case to the jury. So I'd really appreciate if you just answer my question rather than trying to go further,
Sure.
okay? Thank you very much. Now, after you had the dinner, you then provided a designation in February of 2021 in which you said, and this is long before you ever saw Amber Heard, correct? You said that Amber Heard, quote, exhibits patterns of behavior that are consistent with co-occurring cluster B personality disorder traits, especially borderline personality disorder, end of quote, correct?
No.
No, we went through this before.
We did.
But, and that was on the designation, was it not?
I told you last time that I did not write that.
Okay, and you don't know who did on the legal team, correct?
No.
Okay, And then I also asked you, if you may recall, whether you listened to the audio recording in which Mr. Depp taunted Amber Heard that she had a borderline personality disorder. Do you recall that?
I recall you asking me that, yes.
Did you recall listening to that audio tape?
I don't recall Mr. Depp taunting Ms. Heard. I do recall that he at some point suggested she might have that diagnosis.
Okay, and that was back in these audio tapes back when they were together, correct?
Yes.
Okay. Now, you've never before been asked to testify or serve as an expert with respect to someone who has bipolar disorder, correct?
No, as I previously stated, that's not true.
All right. Let's get you in that position. Your Honor, my extra copies were all distributed before. Does everybody have those?
Not up here anymore.
Okay. Then my apologies, but I'm going to go ahead.
Your Honor, can we approach?
All right.
Sidebar, let's get a break in. More from Shannon Curry and the cross-examination of the expert witness next. Elaine Brennerhoff is conducting the cross-examination of Dr. Shannon Curry. Let's pick it up right where we left off.
Now, you recall testifying in your deposition on March 21, 2022, correct?
Yes.
And you were under oath at that time, correct?
Yes.
And the question I just showed you on page 207, line 5, have you ever been asked to testify or serve as an expert with respect to whether someone has bipolar disorder? And your answer at that time was no, correct?
Yes, I had forgotten that case.
Okay. And have you ever been asked to testify whether anyone has behavioral or characterological conduct that suggests they may be an IPV perpetrator?
I can't, yeah, I may have. It's difficult. After about 250 cases, it's difficult to remember specifically.
All right. And have you ever been qualified as an expert in the area of IPV?
No.
And have you ever been qualified to testify as an expert in domestic abuse or violence?
Domestic.
Abuse or violence?
Yes, that's been a component of testimony.
May I approach you?
All right.
You're still on page 2.
I can see what you asked me on that. Can I take a look? Do you want?
Okay.
Line 16 of page 207, have you ever been qualified as an expert in the area of IPV? Your answer on line 20 was no, under oath, correct? Then the next question, have you ever been qualified to testify as an expert in domestic abuse or violence? That and goes into page 208, line 4. The answer then under oath was no. Now, you would agree that the literature is quite clear that trauma-based symptoms such as PTSD or complex PTSD have symptoms that overlap with borderline personality disorder and histrionic personality disorder, yes?
Yes.
Okay. And you would agree that it's important to use valid and reliable measures for an accurate diagnosis, correct?
Absolutely.
Okay. You chose, however, not to administer the structured clinical interview for DSM-5 personality disorders, the SCID. Is that correct?
I did.
Okay. And would you agree that that is a state-of-the-art structured clinical interview?
Not for a forensic evaluation with a sophisticated examinee.
But to determine if a personality disorder is present?
No, not in this setting.
You don't agree with that?
I do not.
And you don't agree that that is the gold standard assessment for reliable, accurate psychiatric diagnosis?
It's a good one, but for treatment settings especially.
Okay. Now, did Ms. Hurd, you said you read all of the treatment records, right?
Yes.
Okay. Do you recall reading the treatment records for the psychologist Bonnie Jacobs, who saw Amber Heard over 5 years?
I do.
And did you see anything in Bonnie Jacobs' notes over 5 years in which she diagnosed Ms. Heard with borderline personality or histrionic personality disorder?
No.
Now, you also saw the notes of Dr. Connell Cohen, correct? Mm-hmm. And you even attended his deposition, correct?
Yes.
All right. And he saw Amber for roughly 2 years. He was part of the Dr. Kipper connection,
Mm-hmm.
right?
Yes.
Right. Okay. And did you see anything in Dr. Cowan's notes, and did he say in his deposition that he diagnosed Amber Heard with borderline personality disorder or histrionic personality disorder?
I saw the symptoms clearly delineated throughout his notes and in his deposition. He does not use diagnoses, so he would not have diagnosed her.
He said specifically in his deposition he did not diagnose her with that, correct?
Yes, and he also specifically stated that he does not use diagnoses.
All right. And you also have seen Dr. Banks, Dr. Amy Banks, the psychiatrist, her deposition, correct?
Yes.
And did Dr.
Not
Anderson,
her deposition. I reviewed her notes in the transcript.
all right. Did Dr. Anderson diagnose Ms. Heard with borderline personality disorder or histrionic personality disorder?
I don't believe she provided any diagnosis since she was a couples therapist.
All right. Now, you've said quite a bit about Don Hughes, but do you remember how many years of experience Don Hughes has in IPV and domestic abuse and violence?
I know it's quite a bit.
Extensive, and she is board certified, correct?
Yes, she is.
All right, and she spent 29 hours of examination with Amber Heard, did she not?
Yes, mostly
Okay.
interviewing.
All right, and she interviewed her therapists, Bonnie Jacobs and Conan Cowell, correct?
Yes.
And she also interviewed Amber's late mother.
Yes.
Okay, and she administered 12 different tests over the period of that time, correct?
Well, as I said, the majority of those were checklists, which are inappropriate for the forensic setting.
I understand, that's what you say, but she administered 12 different tests, correct?
If you want to qualify them as tests, sure.
Okay. And so you disregard, no, I'm not even going to say that. Okay. Let's go to the CAPS-5 and PTSD. Now, you assessed Ms. Heard's traumas in her life, correct?
Yes, I did give her an instrument to assess for any trauma exposure throughout the entire lifespan.
Yes, it's fine. And you wrote that Ms. Heard's exposure to a traumatic event, namely one of the sexual assaults by Mr. Depp, more than satisfied this requirement. Did you not write that in your notes?
That is not what I wrote in my notes. Do you have my notes so we can
And you
look at them?
administered a structured clinical interview based on that trauma, correct?
Not exactly. It's not quite right.
Okay. Now, Dr. Hughes administered a full intimate partner violence assessment, correct?
That's not a psychological assessment. We can't assess for intimate partner violence. That's an event.
Dr. Hughes administered a full intimate partner violence assessment,
She
correct?
stated that, and that's actually something I'm rebutting today.
Okay, and you reviewed her psychological testing?
I sure did, yes.
Okay, and are you aware that in September 2019, Ms. Heard had a trauma-based symptom on many of those valid tests?
Can you be a little bit more specific? Many of those valid tests, which tests are you talking about?
Do you have a recollection of that, September 2019?
She administered all of her testing in September 2019, so I'm not sure which one. Oh, except for the CAPS-5, which was 10 days after mine in 2021.
Now, Dr. Hughes clinically evaluated those symptoms and established that Ms. Heard does have PTSD from the totality of the intimate partner violence by Mr. Depp, correct?
That's what she stated, yes.
Okay. Now, Dr. Anderson's clinical notes that said Amber had come to
Objection, hearsay.
I haven't even asked the question yet, Your Honor.
Are you going to read her notes?
Well, no, actually, I wasn't going to read her notes. I was
okay.
going to ask a particular question.
Okay.
You talked about danger. Do you recall that in your testimony?
Yes.
All right. Now, if a patient comes to you as a couples therapist with two black eyes, would you assess that there may be a potential danger there?
Sure.
Okay. Did you read Dr. Anderson's notes?
I believe I did.
Now, you administered the Minnesota Multiphasic Personality Inventory 2, the MMPI-2. Do you recall that?
Yes.
And you used that to determine whether Amber had PTSD, right?
Not by itself, but it was a part of the data.
Okay. And in the 60 to 70 T-score range for that test, which, quote, deliberate attempts to mislead are uncommon, end quote. Isn't that correct?
Sorry, could you repeat that?
In the T-score section of that, for which assesses deliberate attempts to mislead, do you recall? She scored a 60 on that test, correct?
So there are multiple T-scores for each scale, so I'm not sure which scale you're talking about.
Okay. Well, we can deal with that later. So you would agree that you need to follow ethics and best practices in forensic psychology, correct?
Yes.
Okay. And the two primary sources are the American Psychological Association Ethical Principles and Professional Code of Conduct, right? And the American Psychological Association's Specialty Guidelines for Forensic Psychology, correct?
Yes.
And Specialty Guidelines 1.02 states that forensic practitioners, quote, strive for accuracy, impartiality, fairness, and independence, correct?
Yes.
Okay. And Specialty Guidelines 1.03 states that you have to avoid a conflict of interest, correct?
Yes.
Now, in addition to not listing the 4 hours you spent with Mr. Depp, Mr. Waldman, Mr. Chu, and Ms. Vasquez, you also did not list that you spent an hour with Dr. Shaw, correct?
That's incorrect.
You say that the designation said that you spent
During
an
my
hour?
deposition, I also clarified this. I didn't spend an hour with Dr. Shaw. There was an introduction with the attorneys present on Zoom. My time on that call was less than 30 minutes.
Okay, but you still didn't disclose it, did you, in your reports?
No.
Okay. Now, you have not been asked to testify about Ms. Heard's behavior in the context of her relationship with Mr. Depp. Is that correct?
I was asked to testify about somebody's behavioral mental status in general, so that can include behavior involved in a relationship with Mr. Depp, but not specifically.
Can you pull up day 10 of the trial testimony at page 2710? Are you able to do that, Michelle? 2710, lines 12 through 18.
May we approach?
All right. All ready?
All right, sidebar. Dr. Shannon Curry continues on cross-examination. This is rebuttal, her second time around, and her goal is to refute what we heard from Dr. Dawn Hughes, who, of course, was the expert put forth for Amber Heard. The old battle of the experts. Sidebar broken up. Let's go back.
Also have, okay.
Yep.
So, Dr. Curry, this is your testimony from day 10 in this case, and if you can look at page 2710, line 13. Now, my question was, now, is it your testimony under oath today that you have not been asked to testify concerning Ms. Heard's behavior in the context of her relationship with Mr. Depp, including any abuse? And your answer under oath to this jury that day was, that's correct.
Yes.
Correct?
I still agree with that question.
All right. And you have not made any determinations, including any opinions, that Ms. Heard abused Mr. Depp or Mr. Depp abused Ms. Heard, correct?
Correct.
Okay. And in fact, you said that's outside the scope.
Yes.
Right? Okay.
Of psychology.
And you cannot testify whether Amber Heard suffered any emotional distress as a result of any of the defamatory comments that she has alleged Mr. Waldman made through Mr. Depp, or Mr. Depp made through Mr. Waldman, correct?
Objection, Your Honor.
Do you want me to read my response?
What's
Sure.
the objection? I'm sorry. Hold on, Dr.
Sorry,
Curry.
Your Honor.
That's okay. What's the objection? Are you on approach? Okay.
Another sidebar to figure this out. It's been common in this trial because they don't want speaking objections. Get up there, have the judge rule, and go back to it. You don't have to send the jury out. Elaine Bredehoff, keep in mind the time issue here. How much of this is going over the jurors' heads, the technical testing and the results and all of that? Is it worth using the valuable time that they have left? Let's go back in. Sidebar broken up.
You have not rendered any opinion as to whether Amber Heard exhibits patterns of behavior that would suggest her allegations of abuse against Mr. Depp are false. Would you agree?
No. I mean, yes, I would agree with that.
Thank you. And you have not, no, that's right. That's all I've got. No further questions.
All
Thank
right,
you.
redirect.
You were asked about the skid.
Yes.
What's that?
It's a structured clinical interview. It's for rendering a diagnosis. It's best for treatment because you're asking direct questions of the examinee and about symptoms. So if you have an examinee who has a tendency to minimize, you're not going to get much information.
Why didn't you use it?
Because, well, first of all, I had a limited amount of time for my evaluation, and I had already had to use, just to complete the interview was extremely time-consuming. And I had to even restructure it into handouts so that I could keep Ms. Heard on track. I determined based on that, so this is where you would make an inference. So because I was having difficulty getting direct answers to my questions from Ms. Hurd, I had determined that creating forms of those questions would be a better use of the time, which it was, and then I further deduced that adding on the structured clinical interview would probably be unproductive, given that I had limited time and needed to use the best, most reliable methods for getting information in that time.
You were asked about the APA specialty guidelines.
Yes.
Specifically 1.02 and
Yes.
1.03. Have you complied with them?
I have.
No further questions.
Thank you.
Thank you. Dr. Curry, you can have a seat in the courtroom.
you,
You're
Your
free to
Honor.
go. Thank you, ma'am. All right. Ladies and gentlemen, let's go ahead and take our morning recess for 15 minutes. Do not discuss the case and do not do any outside research, okay?
All right, time for the mid-morning break. Dr. Shannon Curry, round two for the doctor, the expert on behalf of Johnny Depp. Let's bring in our expert, Jack Rice. He's in St. Paul, Minnesota. Jack, before we talk about Dr. Curry, let's talk about Kate Moss. Very short and sweet, but, you know, and no cross. Your thoughts on what she brings to the case, denying there was ever any sort of staircase incident?
What this is about is one more little cut against Amber Heard. In the end, the idea of a lot of cases like this, but this one in particular, is the concept of death by 1,000 cuts. What you're doing is you're cutting away at her credibility on the edges, and you continue to cut and you continue to cut to the point that a jury says there is nothing in the core. That's the reason you bring Kate Moss back in.
What about Dr. Shannon Curry? A lot of technical jargon back and forth with the different tests, how they were administered, how the results were interpreted. Maybe one or two jurors are right with you and they're picking up all of it. In your experience, what about the other jurors, the ones that are like, all right, bring back Kate Moss, and they, you know, do they just evaluate on feel? Who do they believe more, or do they throw out the experts?
You know, actually, it's a great question. I think lawyers can get lost in the weeds. They start getting sucked into minutia in their cases because they know it so well, and it's really easy to do. I think one of the things that's most important, especially with experts, but this is true with any witness, is that people and jurors hate the idea that you're just bringing in somebody and you're essentially bringing in a hired gun. And they'll say whatever you want them to say, and it's money well spent. That's the logic. And they hate it so much because they don't trust it. So anytime I put any witness on, but specifically an expert, not only do I say what is their competency, capability, but then I have to be able to establish for the jury that they would never say anything just as an advocate. They are talking because they are there as an expert to talk about what it is that they know. This is about credibility. You have to build them up so a jury buys in, because in the end, and I think Dr. Curry did this very well, if she comes across as not just smart, capable, competent, but she also comes across as objective and above the fray. And I have to tell you, if you have any characteristics that you want from an expert, it's this. It's these exact characteristics.
And they will roll on. The mid-morning break is still going on. We'll slip in our break as we approach the top of the hour, but we're not going anywhere. We're not going to miss anything because we have Julie Grant who's going to pick up our coverage. Good morning, Julie.
Hey there, Ted. Good morning to you as well. Yes, Dr. Curry was great, wasn't she? She's one of those expert witnesses who could tell you the sky is pink, and you would believe her just because she says it with such conviction. We're going to see what's next after this break. We know Johnny Depp is going to take the stand in his rebuttal case. Will he be next? Stay with Court TV Live to find out.
MileDirectClub.com.
We were leaving the room, and Johnny left the room before I did, and there had been a rainstorm, and as I left the room, I slid down the stairs, and I hurt my back.
How did you...
And
I apologize, Ms. Moss. Please continue.
And I screamed because I was because I didn't know what had happened to me, and I was in pain, and he came running back to help me and carried me to my room and got me medical attention.
You know who that is. British supermodel Kate Moss testifying in the defamation trial between ex-spouses Johnny Depp and Amber Heard. Welcome to Court TV Live. I'm your midday host, Julie Grant. So if you're just now tuning in, Kate Moss was called to testify this morning. She testified remotely as she is in the United Kingdom right now. She lives in London. And she talked about an incident that happened back in the 90s in Jamaica when she was vacationing with her then boyfriend, Johnny Depp. We're going to show you the entirety of her testimony later in the show. But first up, the jury is back from that mid-morning break. Today is day number 22 in this dueling defamation trial, and we're in the rebuttal portion of the case, with Depp's legal team calling a number of witnesses back to the stand this afternoon, and later today, Johnny Depp could be one of them. Look at this. This is a list of the rebuttal witnesses. He is listed as the final one. That, I think, would be very smart. Let me ask my guest analyst on the program what he thinks about that move, if that's the way they're going to do it. On the show today, criminal defense attorney and former prosecutor and former CIA agent Jack Rice is with us. Jack, what do you think?
You know what? He is the best weapon in the Depp arsenal. Let's face it. He's funny, he's self-deprecating. I mean, from the beginning, what impressed me most about him was it always felt like he was willing to show you all of the broken parts of him, but most importantly, he would pull back the curtain and he would say, look, this is what I am, this is who I am, and then he'd sort of laugh, but in a painful sort of way. His credibility is incredible. And I think it actually worked for him. So that being said, the question is, what's the benefit to bringing him back? Primacy and recency. The first thing you remember, the last thing you remember. At the same time, there is an exposure issue because he did so incredibly well. If you bring him back a second time, do you open him up? And if things go south, it's the last thing that a jury might see. So I think there's a real risk in doing it, but tell you what, he's quite a witness.
That's a good point, Jack. That's a really good point, because he did do so well the first time around. On the one hand, you may want to leave well enough alone and say, look, they heard from him. He was up there for a long time. He said everything he could possibly say. Was her case that damaging? You assess, as you said, you know, is this worth the risk of potentially opening him up to a rigorous cross? You know, I think I would only be afraid if it's going to be Benjamin Rottenborn crossing him. You know, Elaine Bredehoff has clearly shown she struggles with question formulation. She struggles with the rules of evidence. If that's who, you know, but, you know, who knows who they might put up. The way they've been doing the musical chairs throughout this case, that's tough. And your thoughts on that, please, Jack, as an advocate. You know, when you see those different voices during the trial, what are the advantages to that and the disadvantages in formulating the case?
You're always thinking of it from the perspective of the jury. I mean, always, because it's from their perspective that you're trying to see how that evidence comes in and how it impacts them, how they see it. So as an example, I recalled bringing in a second lawyer just to handle the technical side of a case dealing with DNA and the really internal aspects of it, because not only was she so incredibly smart, she did it in such a way that the jury could understand it really easily and really, really well. And so sometimes what you want to do is you bring in people for their strengths. But in the end, it's not about their strengths. It's about what the jury hears and how the jury perceives it, because the truth only exists. It only exists inside their heads. They're the arbiters of truth. And that's why they are, at the end of the day, everything.
And we see they're still at the sidebar there. Been doing many of these today, the last couple of days. Some of these things, I think, probably could have been hashed out in the pretrial litigation that we know occurred, but they're happening in front of the jury. And Jack, I was thinking about this yesterday on the show, and you're a great one to ask about this. You know, when you're running a trial, you know, you have momentum when you're one of the advocates and things are running the way you want it to run, and then sidebars just stop all of that. Everything kind of comes to a screeching halt. And then if you're a juror, it's like, here we go again. Do you think they could run the risk of frustrating this jury, doing so much out of the jury's hearing and making it very apparent as they are right now?
There is no question about it. The fear is always, especially in a big case like this that lasts so long, is this jury is exhausted. This jury hasn't seen their family in the ways that they want to because they're having to deal with this every day. They're always so focused, even if they're not sequestered. The problem is that they have to keep coming back. This is a massive chunk of their lives. And if the jury perceives that somebody, whether it's the judge, whether it's one team or the other, is wasting their time, they will start to get angry. But there's the other part of this. They know this case is almost over, so they're leaning into it. And the problem is that if you're going to do something, now is your time. The idea that you're actually standing in front of a judge wasting their time, I think is really foolish. You could have done this before court started. You could say, you know what, Your Honor, why don't we just stay after you release the jury at, say, 4:30, 5 o'clock? We'll run an extra hour, and we're going to hammer out all of these issues, because I want that jury on my side. I want them to say, those guys are working for me. The other ones are the problem. You're always trying to figure and work that angle.
Right. You know, and I should point out too, I'm assuming, I don't know because we can't show the jury, but I'm assuming right now they maybe haven't been brought in yet, because I would think the length of this sidebar, I don't think Her Honor would keep them up there that long. You're nodding too, so you agree with me, Jack. Yeah, so at least they're good here with this one. And I can see with another camera view we have in the studio, some folks are moving about in the gallery, which tells me they're probably not there. How about, let's talk about how there's a witness that the Depp team wants to call. Someone named Morgan Tremaine, who used to work for TMZ. And we know TMZ is trying to protect this witness from being called and having to divulge any information learned as a journalist, and protect that, the rights and the privilege journalists have with confidentiality. And the Depp team wants to call this witness. Apparently this is a newly discovered witness. Jack, what are your thoughts that the court will or will not allow the team to try to bring in this witness who used to work for TMZ?
Let's start with disclosure, right? I mean, as we're going to work through this for listeners, before a case starts, what you generally do, what you're required to do is you're required to provide a list to the opposing counsel as well as to the court that says, here's my list of witnesses. So essentially, you know what's coming. That doesn't mean you have to call every single one, and sometimes you even add a bunch of them so they're unclear who you're going to call. However, when you're talking about rebuttal, you're saying something happened, either there's a new witness that we didn't know about that came out of nowhere, or something that came from the other side that tells us we need a witness to rebut exactly what it is that they're saying. Well, one of the aspects of this, and this is what the Depp team is really arguing, is this idea of the videotape. And this, at least this is what's been reported in the media. They remember the videotape that she ran when Johnny Depp was, I believe, assaulting cabinets. I think that was his language.
Yes, the assault on the cabinets video, right.
Well, the argument is that, in fact, that she shot this video unknowing from Mr. Depp, and then allegedly gave it to TMZ. That's what the allegation is. And so the question becomes, does this show a manipulation, a motivation by Amber Heard to not just make Johnny Depp look bad, but really about something broader? And from the Depp's perspective, it's about manipulation. And so they want to use it. Now, of course, TMZ is trying to make the argument that what does manipulation have to do with whether or not she was assaulted and whether or not this was true? That's their argument. The question for the court is this too far afield, or will they allow it in because this actually goes to Amber Heard's credibility? And as you and I have discussed many times, credibility is always, always, always relevant.
Yes, it is. It's always an issue. You're right, Jack. Here's that video. We're talking about the assault on the cabinets video. And TMZ filed this motion to intervene.
The mega pint, right?
Pardon me? I'm sorry, I couldn't hear
And
you.
the mega pint? Wasn't that the mega?
Yeah, that's
mega
the one
wine?
where Benjamin Rottenborn was saying you poured yourself a mega pint, and he's saying I poured myself a large glass, and it was a big glass of wine, that's for sure. But that was funny. Yeah, the term mega pint kind of went viral with that. But yeah, TMZ, filed this motion with the court to intervene, saying, issue an order, judge, preventing this former employee from having to talk because the Depp team wants to use this for purposes of impeaching Amber Heard's credibility, as you said, not because it is part and parcel of the defamation claims that are at issue. So as you know, very different when it's being used for that purpose versus the one that establishes all of the elements. Jack Rice, I have many more questions for you, but we're gonna squeeze in a break because this sidebar is awfully long and we don't want you to miss any of the testimony coming up next. Don't go away. All right, welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. So after that sidebar has concluded, Johnny Depp's team called its next witness, Johnny Depp.
Are we ready for the next witness, or do you want
Yes,
to?
we call Mr. Depp.
Okay. All right. So just a reminder, you're still under oath, okay?
Yes, ma'am.
All right, thank you, sir.
Good morning, Mr. Depp.
Good morning.
We heard a lot about some statements that Mr. Waldman made. Do you remember that?
Yes.
And Mr. Waldman is your attorney or was your attorney?
Yes.
Could we please pull up Defendant's Exhibit 1245? And this is already in evidence, so permission to please publish. If we could scroll down to the second page. Mr. Depp, do you see the statement here attributed to Mr. Waldman?
Yes, I do.
When's the first time that you saw this statement?
Objection, Your Honor. May we approach?
All right.
All right, so another sidebar, but this was expected that he would be taking the stand in his rebuttal case. I was talking with my guest, who I'm going to bring back in again, Attorney Jack Rice, about that. We were saying very smart move, especially if he's the last witness called on rebuttal, because that would be the last thing the jury would be left with before Sir Rebuttal, which Amber Heard's team will have an opportunity to do if they so choose. So what might this mean? Jack Rice, they were up there for a long time. We know not every witness on the list may necessarily be called. Could this be that he's their final witness? What do you think?
You know, it's certainly possible. Again, primacy, recency. The last thing that you hear is what it is that the jury is going to remember. And this is big. So you know that. I think this fight, I think everybody was up there for this reason. What we're going to see right now is potentially a very narrow direct examination, because the purpose is to try to keep Johnny Depp in a very particular lane so you can narrow what the recross, if you will, is going to be of Johnny Depp. And what I really think is going on right now is they're trying to make a distinction between Waldman, his former lawyer, and Johnny Depp himself. So in other words, the other side was all about making those three statements that Waldman made. If Johnny Depp says, it wasn't me, it wasn't mine, then it's not Johnny Depp's responsibility, his liability.
Right. Okay, let's go back in and listen.
August. It was when the piece was when she August 2020, when I was countersued by Miss Heard. This is the first time that I saw any of these statements.
Can we please pull up Defendant's Exhibit 1246? And this is also already in evidence.
All right.
Thank you. If we could scroll down to the second page, or the third perhaps. Thank you. Mr. Depp, do you see this statement that's attributed to Mr. Waldman here?
I do.
And when is the first time that you saw these statements?
Same, when the countersuit was filed.
And could we please go to Defense Exhibit 1247? And again, this is already in evidence. And if we could scroll down, please, thank you. Mr. Depp, do you see the statement attributed to Mr. Waldman?
I do indeed, yes.
And when's the first time that you saw this statement?
This is the same. It's the counterclaim to August 2020.
After you saw these statements for the first time, did you form an understanding as to where they appeared?
I didn't, as to where they had appeared, these statements.
In what publication?
No, off the bat, I didn't know exactly. It just seemed like a lot of word salad to me. I didn't know where they'd come from, or, I mean, where they ended up, or...
Mr. Depp, do you recall Ms. Heard testifying that you did not assist her in getting her role in Aquaman?
Yes, I do, yes.
And what is your response to that? It's not exactly true. Do you know when Ms. Heard first auditioned for Aquaman?
Strangely, I know the date and everything. Well, no, yes, I do know the date, because I was scheduled with my band, the Hollywood Vampires. We had done 2 shows at the Roxy, which is a place in Los Angeles, to rehearse for we were invited to play at the Rock in Rio concert, which is a huge rock and roll festival. So we did the 2 shows to go to Rio and play there. Miss Heard wanted to come with me, and Whitney, her sister, had come as well. While we were there in Rio, we were rehearsing and getting ready for the show. Miss Heard informed me that she would have to get back to Los Angeles for an audition, meaning it's basically after our 2-hour show or whatever, we would have to get on the plane immediately to make it back to Los Angeles for this audition. And that audition was at Warner Brothers. It was whatever film it was.
And when were you performing at the Rock in Rio?
Oh, sorry. Yeah, that was I believe it was the 24th of September.
In what year?
That was 15.
What do you understand happened after Ms. Heard auditioned for Aquaman?
After Ms. Heard's audition, or possibly auditions, for Warner Brothers and I suppose the creative team, Ms. Heard had expressed to me that the film was going to be, Warner Brothers had said that the film was going to be shooting in Australia. And Australia was for Ms. Heard, that was a potential problem, which...
Objection, Your Honor. Your approach?
Okay.
Okay, so we don't know the basis of the objection Mr. Rottenborn is citing, because it's going to be put before the court at Sidebar, which is outside the hearing of the jury, but still, of course, part of the court record and taken down by the court reporter. We're going to squeeze in a break. You will not miss any of Johnny Depp's testimony on rebuttal. This is Court TV Live, your front row seat to justice.
gutter inspection and estimate.
He is back for rebuttal. Johnny Depp has returned to the witness stand to testify in his rebuttal case. And something to pay attention to here, his attorneys are going to ask him really specific questions, mostly relating to those statements with his agent, attorney Adam Waldman. Now, if he is asked anything on cross that is not relating to what he's asked on direct, that would be what's called beyond the scope of the examination. So listen for that objection, see if you see any of that as we go back, or we hit the pause button before so you wouldn't miss this. That sidebar broke up. The questioning continues.
I apologize, Mr. Depp. Could you please continue? What happened after Ms. Heard auditioned for Aquaman?
I was informed by Ms. Heard that the film was going to be shooting in Australia, and that was of concern to her, and because it was of concern to Warner Brothers. So she asked if I would, because I'd had a multi, for a few years I'd had a multi-film deal with Warner Brothers, and so we'd been in business together. So I knew these people. I'd been on films with them. So she asked me if I would speak to them. I made a phone call and I spoke to.
Objection, hearsay, Your Honor.
I don't believe he said anything. I think he was going to say who he spoke to.
All right, we'll see. Overruled at this point.
I spoke to the three upper echelon Warner executives, Kevin Tsujihara, Sue Kroll, and Greg Silverstein. And I told them that...
Objection, Your Honor. Hearsay.
All right, I'll sustain the objection. Next question.
What was the result of you speaking with those individuals?
Well, I can only say that ultimately she did get the job in the film. So hopefully I suppose I had curbed their worries to some degree.
Mr. Depp, do you recall Ms. Heard testifying that she saw you consume 8 to 10 MDMA pills while you were in Australia in March of 2015?
Yes, I do remember that.
How many?
I also remember her saying that I took a handful.
Objection beyond the scope. Question.
Sorry, that was extra residue.
All right, I'll sustain the objection. Next question.
How many times have you done MDMA in your life, Mr. Depp?
Actually, not that many times. I would say in my lifetime, maybe in my lifetime, MDMA 6, 7, maybe.
And how much MDMA have you done on those occasions?
Not enough to properly. Well, not enough to properly experience what the chemicals are supposed to do to you.
Have you ever consumed 8 to 10 MDMA pills at once?
No, ma'am. No, I have not.
And why is that?
Because I'd be dead. I'm pretty sure I'd be dead. I think one would die. Yes, and probably rather quickly.
Mr. Depp, I'd like to show you some pictures from the home in Australia that Ms. Heard testified about.
Sure.
Could we please pull up Defendant's Exhibit 1817, which is already in evidence? Mr. Depp, do you recognize what's depicted in this photograph?
Yes, I do. That's the downstairs bar of the house we rented in Australia.
And can you please show the jury where you were sitting when Miss Heard threw the 2 vodka bottles at you?
If I touch this thing, it'll make a
Yes,
mark.
it will.
Yes. Okay. So this chair, that one here, was over here. And it was in pretty much when I was turned around toward, they were on a swivel, so when I was turned around towards the bar, I'm facing the bar. When I turned around this way, this chair here was in pretty much exactly this same position as this chair. It was when I was facing Miss Heard, who was, let's say she was, if you're looking at the photograph, she would be about here.
Could you draw a line in the direction where Miss Heard was relative to where you were sitting?
Yes, absolutely. So if I'm sitting here, she was over here, like back here.
Approximately how far away from Miss Heard, from you was Miss Heard, if you can recall?
I would say it was probably 10, 12, 15 feet, maybe 10 feet, 12 feet.
And approximately where was your hand when the vodka bottle hit it?
It was leaning. My arm was leaning on the marble bar, right there where the imaginary seat is, and leaning, kind of just leaning back and looking at Miss Heard. She just walked away with the second bottle. I mean, she walked this way when she threw the first bottle, which is actually visible in the background on the floor.
Yeah. Could you please circle where the first bottle is?
Oh, sorry, excuse me. Yeah. All that is the exploded first bottle that went past my head. And the second bottle hit right up here where my hand was resting on the marble bar.
Can we please pull up Defendant's Exhibit 1820? Mr. Depp, do you recognize what's depicted in this photograph?
This is behind that very bar.
And what do you see on the floor in this picture?
I see what looks to me like some kind of napkin. It looks sullied, soiled, blood, I don't know. And I see glass in the corner, blood obviously on the floor, and a towel leaning up on something.
Do you know how that bloody tissue got on the floor?
My best guess.
Objection calls for speculation.
Sustained.
Do you know how the blood got on the floor, Mr. Depp?
I know how the blood got on the floor. It came from my dripping finger. So that's why the tissue is I'm 99.9% sure, since it is, looks like it's got blood on it as well, is what what I held my finger with.
Do you see the wall on the left side of the photograph?
I do.
Was there a wall-mounted phone on that wall?
On the left side of the photo, no, I didn't. No. Not that I recall, no.
Could we please pull up Defendant's Exhibit 394, which is already in evidence?
Yes, ma'am.
Mr. Depp, do you recognize this text message?
I do.
And what is this message?
It's a text to Dr. Kipper. I'm sorry, just reading through.
Sure.
Yeah, this is my text to Dr. Kipper, who had just happened to be in town, telling him that I've had it and that I just lost a fingertip.
How long after your finger had been injured did you send this text message, if you can recall?
It's hard to tell because when I look at the timestamp, it says delivered 3/7/2015, 5 o'clock. But I know that because of Australia time, it was the 8th, and it was probably, the whole thing lasted probably until about 2 p.m. Or so, when that was when Kipper was called, Jerry was brought in, Jerry Judge, sorry, excuse me.
So do you have an estimate as to how long after your finger had actually been injured that you sent this message?
I don't think it was very long. I think it was probably within the next, I'm sure it was within the next half hour or so. I would have had to sneak into a bathroom, lock myself in to type this out.
And how were you able to send this text message to Dr. Kipper in the state that you were in?
Well, he wasn't available at the time, so just sort of thumb your way through, don't you?
How long after sending this text message did you see Dr. Kipper?
I don't recall, but I think it took them probably 30 minutes or more, 30 to 40 minutes to get there.
And what did Dr. Kipper do when he first arrived at the home?
Oh, the first thing he wanted to do was inspect the damage of my finger and try and figure out exactly what had happened, how it happened.
And what did you tell Dr. Kipper about how your finger had been injured?
Objection, Your Honor.
May we approach?
Hearsay. We've discussed this several times.
Let's go.
Certainly a proper objection right there by Benjamin Rottenborn. Okay, so what we're going to do is hit the pause button. You are not going to miss any of Johnny Depp's testimony on rebuttal. He is going into a lot, not just the statements made by his agent, Adam Waldman, but also talking about the MDMA pills, the incident in Australia, the vodka bottle, finger incident, which we expect to hear more about in terms of that treatment and what he might have said during the course of that treatment. We'll squeeze in a break. Thank you for being with us here on Court TV Live, your front row seat to justice.
today.
Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. Thank you for being with us on this Wednesday. Johnny Depp has returned to the stand in his defamation trial. This is allowed to happen because he's on rebuttal. This is evidence that his team is presenting to refute what Amber Heard has presented in her case. Let's go back in now, exactly where we left off.
Mr. Depp, when Dr. Kipper was treating your finger, what did you tell him about how your finger became injured?
I told him that there was obviously, I mean, when you saw the damage in the house and everything, the blood everywhere, I mean, obviously there was serious damage done. There would be no point in lying to the man. He'd been through it with me and Ms. Heard before. I told him that she had thrown a bottle of vodka and smashed and cut my finger off, the tip of my finger, but a good chunk. I miss it.
Mr. Depp, you heard Ms. Heard testify about an alleged incident of abuse on your honeymoon. Do you remember that?
I remember her testifying to that, yes.
And when did you and Ms. Heard go on your honeymoon together?
I believe it was somewhere in the neighborhood of August, because I just finished the film. Maybe end of July, August. I'm not quite good on the exact date.
Do you recall the year?
It was 2015, I believe.
And where did you and Ms. Heard go on your honeymoon?
We took the Orient Express from Bangkok, Thailand to Singapore.
And what happened while you and Ms. Heard were together on the Orient Express?
There were times when it was very agreeable, very nice. And then there were times when something had become dissatisfactory for her, and she would start the rant, the blooming of a fight would be on deck there, and at one point, it didn't. I mean, I don't remember it lasting long at all. I just remember that I took a pretty good shot to the face, to the eye, to somewhere up here. So I had a bit of a shiner. But it all ended, and then everything got fine again, and we'd go to dinner, and it was all fine.
Did Ms. Heard ever apologize to you for giving you the shiner?
I don't recall.
Can we please pull up Plaintiff's Exhibit 162, which is already in evidence? Mr. Depp, do you recognize this photograph?
I do. It was with the chef and the maitre d' and the staff were asking if they could take a photo with us, and they'd been very kind. They'd given us a private dinner card.
So where was this photograph taken?
That was in the, that looks like it's in the, yes, that's towards the back of the Orient Express. That's in the back train bar compartment. And just out back, you could smoke on the sort of caboose or whatever.
And What, if any, injuries do you have in this photograph?
I think the eye's a little bit bugged out, if you will. It's, yeah.
How did that happen?
These things could happen very quickly if you disagreed.
Objection, Your Honor, non-responsive. She just asked, how did that happen?
I believe he was about to explain.
Well, I'll state the objection.
Okay. So, Mr. Depp, specifically, how did the injury in this photograph occur?
I'm sure it hit me. Is that better?
Does this picture accurately reflect what you looked like on that date?
I don't look at myself much, but it certainly looks like me with a black eye. Yeah.
Does this picture appear to have been photoshopped in any way?
No, I think it would be difficult to photograph or to start getting into sort of digital processing with a number of people in the shot, especially in a wide shot.
Could we please pull up Plaintiff's Exhibit 1301? And this is a new one, Your Honor, so this is not in evidence.
Okay, thank you.
Mr. Depp, do you recognize what's reflected in this photograph?
Yes, this is the staff. It's the manager and his staff at the Raffles Hotel in Singapore. And before we left, they asked if they could take a photograph with us.
And when was this photograph taken?
Well, that would have been, we were off the Orient Express. We stayed in Raffles, I believe, a couple of few days. And then from there, we flew to San Francisco.
So this photograph was taken after the photograph we just looked at?
This photograph was taken after the photograph in the dining car of the train, yes.
Your Honor, I'd move Plaintiff's Exhibit 1301 into evidence.
All right, any objection?
Oh, happy honeymoon. So it's
Any
31st of October.
any objection?
No objection, Your Honor.
All right, 1301 is in evidence, can be published to the jury.
Mr. Depp, what, if any, injuries do you see on your face in this photograph?
I see pretty much the same. I see that the area in here has been is swollen and yeah, there's a bit of a shiner there.
Thank you. We can take this down. Mr. Depp, do you recall Ms. Heard testifying that she punched you in the staircase incident because she thought of Kate Moss in the stairs?
Do I remember her saying that?
Yes.
Yes, I do. 3 times. Yes, I do.
Do you have any understanding as to what Ms. Heard was referring to?
Yes, I do.
All right, we have to squeeze in a break. We're hitting pause. You're not going to miss any of his answer. We just have to hit a break at the top of the hour. Thank you for being with us here on Court TV Live. We'll be right back with more Depp versus
9583. That's 800-731-9583.
This is Court TV Live, your front row seat to justice. I'm Julie Grant, your midday host. Thank you for being with us on this Wednesday. It is a big day in the dueling defamation trial in Virginia between Johnny Depp and Amber Heard. Right now, we're on the Depp rebuttal case, so they're offering evidence to refute what we saw presented by Amber Heard's team. First up was Kate Moss. She's an ex-girlfriend of Johnny Depp's, and she testified that there was never an incident where he pushed her down the stairs. She talked about an incident where she slipped and fell because it was rainy and wet outside. It was when they were on a trip in Jamaica. So she put to rest that rumor that Amber Heard referenced when she was on the stand talking about her own staircase incident with Johnny Depp. And she said it made her think of Kate Moss and what happened with her. So this was rebuttal evidence to show the jury it never happened. Then, in somewhat of a surprise move, Johnny Depp took the stand on rebuttal, and we have hit the pause button on the video, so you're not going to miss any of his testimony. We knew there was a chance he would testify. We thought he would be last, so this could be the end of the case. This would be a very strong note for his team to end on. When we last left off in our last hour, he was talking about that staircase incident with Amber Heard and her sister Whitney. Let's go back in together now.
As Kate Moss, Kate testified, it was many, many years ago. And exactly what happened is what she said happened. I recall speaking with Ms. Heard about that very incident because of the downpouring of rain, because it was raining very heavily that day that Kate slipped. And I recalled the story to her.
Objection, Your Honor. Hearsay.
May we approach, Your Honor?
Okay.
You know, I know you couldn't hear me at home, but I was saying out loud a few moments ago, objection, hearsay. I do that with any time there's an objection, no matter whose side is presenting. I always try to catch them to see if the attorneys catch them, and that was a proper one. Johnny Depp can't testify to what he said, but he can say what Amber Heard said.
I'll make it easy for Mr. Rottenborn. Ms. Heard took the story and turned it into a very ugly incident, all in her mind. There was never a moment where I pushed Kate down any set of stairs, yet she's spewed this 3 times before.
Objection, Your Honor. Ms. Heard simply testified that she had heard a rumor, and that's non-responsive to the question.
Sir, hold on.
Sorry.
Objection. I'll overrule the objection.
Misstates the facts and evidence.
I'll overrule the objection.
Sorry, I was drawn by Mr. Rottenborn's voice.
Certainly.
What was it?
So what specifically had you actually told Ms. Heard about the incident with Miss Moss and the stairs?
Very simply that we were in Jamaica. I had left our bungalow about 3 minutes prior to her. I was standing outside, and suddenly rain starts just coming down like it's, monsoon. And then I remember looking and seeing Kate coming out the door, and there were 3 little wooden stairs, and she slipped, her legs went up, and she landed directly on her coccyx and her lower back. So, and she was obviously physically in pain, and she was hurt, she was crying. So I ran over and grabbed her to make sure she was all right. That's it. That's all I ever. That's the whole story. But then the rumor of it, I'd never heard a rumor of that before Miss Heard grabbed hold of it. It's like that. I'm sorry.
Mr. Depp, we heard testimony from Miss Heard's sister, Whitney, during this trial. Do you remember that?
Yes.
And how would you describe your relationship with Whitney when you were in a relationship with Miss Heard?
I liked Whitney very much. Initially, when I first met her, I liked her very much, and grew to love Whitney. Very much. Because I always, it seemed, Whitney, Amber's sister, Whitney, seemed to always get the sort of dirty end of the stick, and I felt bad for her for that, because it wasn't new. It had been there for life, and that was seemed pretty obvious. So I took to Whitney very, very quickly, very easily. She was a very sweet kid. She was wonderful.
What do you mean that Whitney got the dirty end of the stick?
It was a kind of a strange combination of loving sister, trusted sister and friend, and then lackey, and then, either the punching bag or the dartboard, or the recipient of some rather demeaning and ugly words, or she would have wine thrown in her face.
And who was the source of those demeaning words and the wine that you just referenced?
Well, that would be Amber Heard, her sister.
And how do you know that?
Well, I witnessed quite a lot of it. The wine in the face was something that happened in New York, which I think that even made it into the papers. I believe that even made it into the papers. It was in an elevator.
How did you first learn about that incident?
Miss Heard told me in detail.
What else did you observe of Miss Heard and her sister Whitney's interactions during your relationship with Miss Heard?
They were just constantly up and down, but I could sense, I could feel that Whitney was trying to please her sister, trying to be up to snuff, and it just seemed like she got shot down.
Objection, Your Honor. This has gone beyond the scope of the question or his foundation for knowledge of that.
Your Honor, I asked what he observed, between them. I think this is responsive to that.
In his testimony as to what Whitney felt is...
I'll sustain the objection. Next question.
Okay. Did you ever see Miss Heard physically attack Whitney?
No, I've never seen any full-on blowouts, physical blowouts between them. Tons of verbal blowouts.
Objection beyond the scope?
Overruled.
I I've certainly seen Miss Heard grab Whitney, push her around. There were a number. There were half a dozen times when some of us, whoever was in the general vicinity, would have to leave. This is at Orange, when Whitney and Amber were living at Orange. Whitney and her boyfriend at the time, Sean Krajewski, and we had to leave the apartment and wait in the car while they fought.
And when you say fought, do you mean physically or?
Physical.
And when you said Miss Heard would push Whitney around, do you mean that physically push her or metaphorically?
Both.
All right, we're going to hit the pause button and then squeeze in a break. Don't go anywhere. You're going to hear all of Johnny Depp's testimony next. And boy, he isn't holding back. We thought this might be a quick rebuttal with him testifying and maybe confine it to just some of the key issues, but no, they are hitting on it all. This is Court TV Live, your front row seat to justice.
How you want to see?
Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. Let's get you back into the courtroom now in Virginia. Johnny Depp has returned to the stand to refute quite a bit of the testimony given by Amber Heard and the various witnesses called by her team. Where we left off, he's talking about that staircase incident in their penthouse apartment where Amber Heard alleges that he struck her sister Whitney in the back. Her sister said the same thing when she testified, and we're getting to that point where Johnny Depp seems to be ready to address it. Let's watch.
You heard Whitney testify that she lived in penthouse 4 at the Eastern Columbia building for a time, correct?
That is correct, yes.
How did Whitney come to live in penthouse 4?
My recollection when Whitney first came to stay at the Eastern Columbia building in penthouse 4 was she and her boyfriend, Sean, had broken up. And she needed a place to go. And so Amber asked if she could stay in penthouse 4, and I said, well, of course, of course, you know.
How long did Whitney live in penthouse 4?
It was well over a year, on and off.
Did you ever ask Whitney to move out of penthouse 4?
No, I did not, no.
Why did Whitney ultimately move out of penthouse 4?
Objection, foundation.
It's his apartment, Your Honor. He was living there.
Oh, overruled.
Whitney moved out of penthouse 4 long before the marriage, and it was due to an argument that Ms. Heard and Whitney had, which had to do with Whitney working at the Art of Elysium with Jennifer Howell and those people. And Amber asked her to leave, get out.
Where did Whitney live when she moved out of penthouse 4?
My understanding is she went to live with Jennifer Howell.
Your Honor, I know you anticipated having a motion at noon.
You can keep going. That's
Okay.
fine. We can. How much longer in direct do you have?
I have a bit.
Okay, that's okay. Go ahead.
Mr. Depp, do you recall hearing testimony during Ms. Heard's case from Mr. Mandel?
Yes, I do.
And who is that?
Mr. Mandel is my former business manager of 17 and a half years, who at a certain point I discovered had been embezzling quite a lot of money. So I had to take action against him and he and my lawyer of 17 and a half years, as they were in cahoots, as it were. And so yes, Joel Mandel is, and they settled their case with me. They made their settlement. But yes, it was the big. That was a very, yeah. Joel Mandel is a very bitter man who ended up with a lot of money that I worked hard for over the years.
Do you recall Mr. Mandel testifying in this case that you do not spend very much money on charity?
That I don't, sorry?
That you do not spend very much money on charity?
Objection, Your Honor.
Just one approach. Okay.
All right, while they're at Sidebar, hashing out the objection and the response with Her Honor outside the hearing of the jury, let's talk about Amber Heard's visible reactions. And I see them walking back, so I don't want to talk over this testimony. We'll save that.
Mr. Depp, just to remind you, my question was, what is your response to Mr. Mandel's testimony that you do not spend very much on charity?
My response to that is Mr. Mandel is a very bitter man, and one thing about that, myself personally, with regard to charity donations, sending money to a charity, I prefer, I would rather that my name were not on it. I don't want the name to be the important thing or the thing that people talk about. So when I donate money, I donate without my name being involved because I don't see that that's important, my name being there in terms of money. Now, if I am able to visit hospitals, or if I'm able to meet with Make-A-Wish children, and have held on to the relationships that I've held on to within the Make-A-Wish Foundation and the Children's Hospital and various other places. Then obviously my name is involved. When we held premieres in Leicester Square for several films, Charlie and the Chocolate Factory.
Again, beyond the scope of his response to Mr. Mandel's testimony.
I believe this is in response to Mr. Mandel.
I'll overrule the objection.
So basically, when it was a public, let's call it a donation or whatever, I would talk to the studio. I would talk to Disney. I would talk to Warner Brothers. I would talk to whoever the studio was well before the premiere, and make the premiere a benefit that would, once we did what we benefited, we did a premiere for Great Ormond Street Hospital. We did a couple of benefit premieres for the Make-A-Wish Foundation. I mean, if you can turn a premiere with that many thousands and thousands and thousands of people there into a benefit, it works and it helps, but it wasn't presented under my name, you know. It was Disney's doing this or Warner Brothers is doing this. I'm not looking for the pat on the back, as it were. If I can make it happen, great. But I don't need the pat on the back. I don't need the adulation. I don't need the attention.
Did you hear Ms. Heard testify that one of the charities she donated a portion of your divorce settlement to was the Children's Hospital of Los Angeles?
Yes.
What is your relationship with the CHLA?
Objection, Your Honor. Irrelevant and to the issue.
May we approach Your Honor?
Yes, ma'am.
I have to say, Benjamin Rottenborn is on the ball this morning and afternoon with the objections. He is very quick, and that's the way you've got to be. I always say the attorney who best knows the rules of evidence wins the day at trial. So we will see what happens today. This is still very early on in the day and in Johnny Depp's testimony. Of course, the more testimony that comes out on direct, the more time there will be to spend on cross, because there's more content the Heard side can cross on. We'll squeeze in a break. Thank you for being with us here on Court TV Live. We'll be right back. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. We're watching the final stretch of Johnny Depp versus Amber Heard playing out in Virginia. This defamation case has had so many twists and turns. In the latest, we saw Johnny Depp's former girlfriend, Kate Moss, testifying this morning on Rebuttal, saying an incident never happened that Amber Heard referenced in her testimony. And now we're seeing Johnny Depp refuting several things that Amber Heard testified to. And there was an objection from Amber Heard's attorney about Johnny Depp talking about his relationship with the Children's Hospital of Los Angeles. Let's go back in now and see how Her Honor ruled.
Mr. Depp, what is your relationship with the CHLA?
I've had a relationship with the CHLA for probably 20 years or so.
And what's just the nature of that relationship?
Well, essentially, you know, sometimes there are Make-A-Wish kids who are in the hospital there, and that their wish is to...
Objection, Your Honor.
Your Honor, may we approach?
Okay, sure.
Okay, something tells me there must have been some sort of prior ruling on this from Her Honor when they went to that last sidebar about it, because Mr. Rottenborn didn't put the basis of the objection on the record. He just said objection, and then there's always a basis that has to be stated, whether it's hearsay, calls for speculation, form of the question, argumentative, all of the various things that could be cited as a basis for an objection to be lodged. But here he didn't say it outside the listening of the jury. It's being argued. Perhaps this is something, I know before he said this was irrelevant. And so this testimony is very good for Johnny Depp. I mean, look at that packed gallery. These are tons and tons of diehard Depp fans who come to court day in and day out. And what he was just sharing is very good stuff, talking about how he wants to make donations, not with his name attached necessarily, just to do good. So not looking for the credit for it. And that is really the definition of charity when you think about it, not wanting anything in return or wanting any attention. And so this is very, very good testimony for him, especially at a time like this on Rebuttal where they're tying up all the loose ends. Amber Heard's side, of course, is going to want to keep this out because it's not relevant to the matter at hand. And I have a view where I'm sitting in the studio of all of the attorneys up at Sidebar. I'm wondering why so many of them are there. Let's listen in now.
Afternoon, evening. My mom made her exit. She'd been fighting cancer numerous times and for many years, and she fought all the way to the end. And so my mother passed away on the 20th of May. Which does bring instant perspective into one's mind. I spoke to Amber that night. I called her on the telephone, explained to her that my mom had passed, Betty Sue had passed, and that I thought that the best thing we could do was to that I filed for divorce.
Hearsay. What Mr. Depp told Ms. Heard.
We can move on, Your Honor.
Yes, ma'am.
Mr. Depp, what happened at the end of that week on May 27th, 2016?
May 27th, my daughter's birthday. May 27th, I was not in Los Angeles. I was on the way to on tour, and that was when Miss Heard went for the restraining order. And oh yeah, also that was the day that Alice Through the Looking Glass, a film I'd done, was opening.
Did Miss Heard know that you were out of town on May 27th?
Yes.
And how would she have known that?
Well, I told her I was going on tour. I mean, that was well established.
How long were you going to be out of town on that tour?
2 to 3 months.
And did Miss Heard know how long you'd be out of town?
I don't know if she knew exactly how long I'd be out of town, but it was a pretty extensive tour of Europe.
How did Miss Heard's actions on May 27th, 2016 affect you?
Changed everything.
Objection, Your Honor. Relevance.
Oh, it didn't change everything?
This lawsuit.
Right.
Mr. Heard, if you could wait till the objection, please.
Yes, I'm sorry.
Relevance.
Tourette's.
Your Honor, this is one of the key
If you want to
dates.
approach, that's good.
All right, Johnny Depp being funny there with that response to the objection. He knows better, but he took an opportunity to be funny. He is very, very likable on the stand. Let me bring in my guest for some analysis. I have trial attorney C.K. Hoffler on the program. She's standing by in Atlanta. C.K., always great to have you. What did you think about that moment just now with Depp on the stand, please?
Well, I think he absolutely took an opportunity to just sort of crack a joke, because obviously that was a pivotal moment in their already toxic relationship. But and he just kind of made a joke. I agree with you. He's very affable. He's very likable. The jury probably was right there with him when he cracked that joke. Oh, it didn't take a turn. And so I think that was probably a good thing. He's been testifying in a very measured way, so that kind of lightened it up a little bit. This is tedious when as you know, as a trial lawyer, we have these things happen when there's a sidebar. It's very tedious. The jurors don't like it because it interrupts the flow. So him making that comment was just really a nice thing to do, and probably a way of engaging the jury even more in a way that was fun and funny in a very, very deep and toxic subject matter trial.
Yes.
So I think he's actually doing very well on in this rebuttal. They're touching on every single issue, as well they should. He wants to be the last voice that they hear. Every single issue that could have made a jury feel uncomfortable, and cleaning up. They're using Johnny to clean up things, to set the record straight. And Amber's reaction is also very interesting.
Oh yes, CK. I was tweeting about that, and thank all of you on Twitter who were responding because you noticed it too. All of her reactions, the body language, the facial expressions today. This is the most reactive I think we've seen Amber Heard this whole trial. And I really like how you put it, CK. It's kind of like Johnny Depp is batting cleanup, if you use the ball game analogy. And they have the time. They have more hours left for him to be up there. So they're probably thinking, why not? The Heard team doesn't have nearly as much time, even though there's going to be a lot of material for Cross. We are going to squeeze in a break. You're not going to miss a moment of the testimony in Virginia. Thank you for being with us here on Court TV Live. Thanks for staying with us here on Court TV Live. I'm Julie Grant. Johnny Depp is back on the stand on rebuttal in his case, and he was starting to talk about the point in their rocky romance when they decided to divorce and how he felt when he heard that Amber Heard wanted to divorce. Let's go back in at that moment where we left off when the attorneys went up to Sidebar. Benjamin Rottenborg made an objection and Johnny Depp made a little joke.
Mr. Depp, what has it been like for you to listen to Ms. Heard's testimony at this trial?
I'm sorry?
What has it been like for you to listen to Ms. Heard's testimony at this trial?
Objection relevance, Your Honor.
Oh, overruled.
Insane. It's insane to hear heinous accusations of violence, sexual violence, that she's attributed to me, that she's accused me of. I don't think anyone enjoys having to split themselves open and tell the truth. But there are times when one just simply has to, because it's gotten out of control. Horrible. Ridiculous, humiliating, ludicrous, painful, savage, unimaginably brutal, cruel, and all false. All false. I wanted no human being is perfect, certainly not. None of us. But I have never in my life committed sexual battery, physical abuse, all these outlandish, outrageous stories of me committing these things and living with it for 6 years and waiting to be able to bring the truth out. So this is not easy for any of us. I know that. But no matter what happens, I did get here and I did tell the truth, and I have spoken up for what I've been carrying on my back reluctantly for 6 years.
Thank you. No further questions.
All right. Did you want to take lunch at this point? Or just, okay, all right, let's do that. All right, ladies and gentlemen, let's go ahead and take lunch this time. Do not discuss this case with anybody and don't do any outside research, okay? Thank you.
Wow, what a powerful note for Johnny Depp's team to end on there. His testimony was outstanding just now. And we're calling balls and strikes here at Court TV. We're not on Team Depp or on Team Heard. We're Team Court TV, facts and law. We don't have a horse in the race. On the other side of things, Amber Heard's counsel should have been objecting. He went on and on and on, and he could have said objection, narrative, because you have to respond just to a question. When you're in the witness box, you can't just keep talking. And what I always say, you know, in trial prep is, look, talk as long as you can talk if you need to explain. So that's good for Johnny Depp that he did that, of course, and not good that Amber Heard's attorney wasn't standing up and interrupting that, because it was not responsive to the question. It went on and on and on, and was a very powerful thing for this jury to be left with. We always say primacy and recency, and they're going on their lunch break and presumably gonna think about what they just heard. Let me bring in someone who knows all about trial advocacy, attorney C.K. Hoffler. She is standing by in Atlanta, Georgia. She's also the former president of the National Bar Association. C.K., always a delight to have you on the show. Let's talk about the advocacy, if we can. You've been watching this trial since it began, and fortunately for me, I get you on my show today. I know you've talked with some of my colleagues here and there, but I'm curious to get your take on the advocacy. Overall, these lawyers, are they evenly matched? What's jumping out at you as good, bad, sideways? Share it all with us, please.
Well, Julie, I will say that both sides have excellent counsel. Excellent counsel, well-trained. They're obviously used to trying high-profile cases. They understand the rules of engagement. They understand the rules of evidence. You said it previously. If you're a trial lawyer, you must know the rules of evidence like you know your own name. And these lawyers know and understand the rules of evidence. That's critical. Obviously, both sides have the ability to get the best and to have a team of lawyers to research every single issue, to look at they both have, jury consultants and other consultants that are looking at the jurors and looking at every single issue as it's playing out. Plus, this is one of the most hotly viewed or widely viewed cases probably right now in the world, certainly in this country. And so I think they're very, very good lawyers. I will say this, though. I do think that there's been quite a bit of creativity, which is the key when you're trying a case, that I have seen displayed by Johnny Depp's attorneys. I think it was very, very, very wise to have a woman cross-examine other women. That's very, very important. The reason why I say that is when you have a tough cross-examination, such as with Amber Heard, we knew that cross-examination was going to be very methodical, very tough. That Camilla had to take that onion, peel it back methodically without allowing the onion to confuse her or to make her cry. Because onions, they make you cry if you have it too close to you. And she did an excellent job. And because jurors do not like it, and this is statistical, this is what jury consultants tell us, and this is what the evidence, just statistical evidence has proven, no one, not men, not women that sit on a jury, like to see men beating up on women, even if you have a cagey witness, even if the woman is being very dishonest, misrepresenting, and making inconsistent statements. They just don't like it. It just doesn't feel right. And particularly in a case like this where there are allegations of, violence, sexual abuse, allegations that a man really mistreated and victimized a woman, you have to be very, very sensitive to that, to the optics. And so I think Johnny Depp's team played that beautifully. I think that the cross-examination was riveting in the sense that Amber was not able to hold her own, in my impression. I think that made an impression on the jury. It certainly made an impression on me because you've got two parties who have allegations against each other. Johnny Depp is in a very, very difficult position where he's been called a wife beater. And not only a wife beater, Amber said he beat several women. And so to disabuse or to turn that around is very, very difficult. And I think they did that very effectively with a great deal of creativity. So I would give them points on that. The dueling experts, for instance, I think that both lawyers were very good at putting on their experts. And they had good experts. And when you have good experts, all you do is ask, as you know, Julie, those key questions, and you let them testify. And that was very effective. Right. This judge is letting the evidence in. She overruled a great deal of objections. So as to your comment at the end, Johnny Depp, by the way, what a way to end your case. But of course, cross-examination is coming up. But that jury is going to lunch thinking of the last words that Johnny Depp said. And I bet they'll come back, and if I were in the courtroom, I'd like to see how many of them are crossing their arms. Because at this point, I think, based on his performance in the rebuttal, Johnny Depp is ahead. He was a little bit ahead before, but I think he was really successful in a very human, likable way. He is odd, you know. He is very odd, let's just face it. He's odd in the way he expresses himself. He's kind of has a Columbo-esque way of expressing himself, and I think that really is just how he is. But he was very effective in disabusing, and he was particularly effective with talking about the damages in this case, how difficult it was for him to listen to the testimony that he said were all lies. He reiterated the themes of the case. That's what you want your client to do. That's what you want your best witness to do. He talked about the themes of the case. These are lies. It was that all sitting and watching Amber tell these lies over and over and over again with these witnesses. He really, really nailed it. In fact, that I think is the finest moment of this trial. Now, on cross, are they going to score points? Julie, no, they are. Because on cross-examination, basically when you get up and all they have to do is score a few points, but they're not going to be able to unravel that testimony. Why? Because this is rebuttal. This is the rebuttal, and this is the cross of the rebuttal. So the judge is not going to allow a lot of back and forth.
Yeah, you know, speaking of rebuttal, too, I want to look ahead, and we should have a little bit of time before we have to hit a break. The Sir rebuttal. Amber Heard's going to be next. I mean, this is so powerful as you're talking, and I'm in agreement with you here, CK. I don't know how you follow that. If I'm on the Depp team, even if you have other witnesses who you can call, I think you have to know when to hold them, when to fold them at trial. Absolutely. And this is a time you hold back. This was powerful. It was poignant. It was spot on. Leave it alone. If I were them, I would say that's it for us, you know, unless there's anything else they need to, you know, move for the admission of. At this point, I believe there was one new photograph that came in that was kind of where he had the swollen face. But with Amber Heard, do you think they're going to call her now on rebuttal to refute some of this?
If I were them, I would not. Because Amber did not make a great impression when she was cross-examined before. So there's no reason to believe that she would do a better job now, particularly when she's on the defensive. So if I were them, I would rest my case. I would not call Amber Heard. I think that would be devastating for them. But Amber was taking copious notes, and she had, based on the expression on her face, and of course it's going to be her ultimate call, probably, she wants to get up and set the record straight too. And that, I think, would be devastating for their case. I don't think they should do it. I really don't.
Yeah, this is a tough one, and you wonder if she wants to get up there because she has been so reactive, as you said, and as many of you on Twitter have been saying. Quickly, CK, we have about 30 seconds, but I got a great question on Twitter I want to have you answer. I was asked, if you were Amber Heard's counsel and you see her making these expressions, laughing, smirking, all that, would you say something to her at the table?
Yes. Yes.
That's what I said to the
I would slip her a note and I would say stop.
Yep.
It would say S-T-O-P.
Yep.
Stop, no expression, poker face. I wouldn't even have sentences. Just the word stop, poker face, no expression.
Yep, knock it off, absolutely. CK Hoffler, always great to have you on the show. You're going to stay with us as we go into the next hour. We want you to do the same. We'll be right back. This is Court TV Live, your front row seat to justice. I'm your midday host, Julie Grant. Thank you for being with us on this Wednesday. Boy, oh boy, what a day it has been in Virginia in the dueling defamation trial of Johnny Depp and his ex-wife, Amber Heard. So if you're just now joining us, we're in Johnny Depp's rebuttal case. After Amber Heard's team rested earlier this week, it's his turn to present witnesses and refute what was put into evidence. And just moments ago, he concluded his testimony on the stand on direct examination. There's still going to be the cross when the jury comes back, but he ended on an incredibly powerful note, saying that it has just been insane for him to listen to Amber Heard's accusations. Let me bring in now someone who was in the courtroom watching it all unfold. Court TV legal correspondent Chanley Painter, who's joining us now live outside of the courthouse in Fairfax. Chanley, good afternoon.
Hey, Julie, yeah, a lot going on inside that courtroom today. Where should we start? Let's start with Johnny Depp retaking the stand. Of course, the jury was there in the courtroom, but the gallery full of his fans. It was like they weren't expecting it yet, and so it was like this gasp, collective gasp in the gallery, like, oh, there he goes. He's going to the stand. And as he retook the stand, of course, several jurors smiled towards Johnny Depp, particularly number 2, number 8, number 9. Those are the 3 who show the most on their face throughout the testimony every day in the trial. And of course, they were glued in as he started to answer questions on direct examination. And there were moments where he brought out his personality again, those wisecracks of one particular was if he took 8 to 10 MDMAs, I would be dead. That got a laugh from juror number 2. The back and forth with Rottenborn objecting over hearsay. There was one moment where Mr. Depp said rotten and he paused. Born. That got some laughs from the gallery, and 2 of the jurors caught that as well. So definitely no love lost between Rottenborn and Depp over the weeks ever since he got off the stand weeks ago. So very much a moment that everyone is listening to. And I know you mentioned it ended on a high note for his direct examination. And you could tell that when he was thoughtfully answering the question, he would pause. Those pauses are powerful because all 9 jurors were turning, looking towards him, and listening attentively. But this has been a big day. Let's go back, if we can, to talk about Kate Moss, who was on the screen before the jury. Very short testimony, but juror number 7, a young man, probably in his 20s or 30s, his face kind of lit up like Kate Moss. And of course, he was glued in, taking some notes as she testified, and it was an impactful moment, even though it was short-lived.
Chanley, tell me, back to Johnny Depp, when he was on the witness stand and everyone was glued to his testimony, did you see any of them turning and looking toward Amber Heard? Because she was noticeably reactive today.
Yeah, there was a moment where juror number 8, a woman probably in her 50s on the front row, did turn to look at Amber Heard. And that was the moment that Johnny Depp was talking about hitting him on the Orient Express and having a shiner on his face. And in that moment, she turned and looked as though to examine if Amber had any sort of reaction to what he was saying. And there was also a moment where jurors looked towards Whitney Heard, who was sitting in the front row behind Amber's counsel tables, because she was a topic that was brought up on direct examination. And Johnny Depp was talking about how he loves Whitney Heard, and jurors, a couple of them, turned kind of to glance over to Whitney in the gallery. And then when, of course, Johnny Depp was accusing Amber of pushing Whitney around sort of verbally and spilling wine in her face or splashing wine in her face, that garnered a nod like this from Whitney in the gallery in disagreement. And of course, Amber turned to look at her sister too, gave her a little nod like, don't know what he's talking about.
Oh boy. How about those folks in the gallery? Did you hear anything from them? Anything? I know you said you heard that kind of surprise gasp when they called Johnny Depp. Anything when some of the testimony was coming out that's been the really contentious things, like you mentioned the staircase incident with Whitney?
No, this crowd today not as reactive as far as hearing any murmurs or shifting in the seats. They do laugh out loud in those moments where Johnny Depp had a comment. There are laughs in those moments from the gallery. I noticed there a little bit more security. The deputies in the courtroom are patrolling down the aisle more, and especially on sidebars, they kind of flank the front of the courtroom to prevent anyone from waving towards Johnny Depp as he sits there. As we wait for a sidebar, you can hear the white noise. They're not supposed to talk in the gallery, and they don't want any attention drawn towards him. During one of the first sidebars, Johnny Depp kind of turned towards the jury, gave a little nod, juror number 8 nod and smile, a slight smile back to him in one of those first sidebars. And also Johnny Depp turned to the gallery and gave them a nod during the sidebar. So that's probably why the deputies started to walk towards the front of the gallery to prevent and to shut down anyone trying to wave or get Johnny Depp's attention as he sat on the stand. He drinks a couple of sips of coffee during sidebars, I noticed as well, and I heard from a source that he likes his coffee black.
Okay, good to know, like some strong coffee there. So Chandler, with that testimony being so powerful, we know there's going to be the cross, but in terms of other Depp witnesses, are we hearing of anybody else we know for certain who's going to be called by them this afternoon?
Well, a source told us that there's this last-minute witness that Depp's team wants to try to convince the judge to allow them to call. It's a witness that has to do with that 2009 arrest of Amber Heard for domestic violence at the Seattle airport when she was with Tajia Van Ree, her girlfriend/wife, before she was with Johnny Depp. And that's been mentioned in testimony. Amber Heard was asked about it on cross-examination, and they want to bring in possibly one of those arresting officers. So we'll see if they're able to convince the judge of that. All these sidebars happening throughout the day, they're doing a lot of work up there. I can see sitting in the gallery, they're passing papers, no telling what all they're talking about and working out outside of our ears up there, but definitely a lot of movement at council tables today. It's just a different level of anticipation, and I don't know if I want to use the word excitement, but inside the courtroom, it's just hustle and bustling.
Oh, most definitely. Like the banner we've got on the screen says, it's like the sequel with him returning to the stand today. Chanley Painter, thank you for all of that. We know you need to return to the courtroom. We'll let you go. In the meantime, what we want to do is play for you something that happened in the court just after the judge dismissed the jury for their lunch break. So this is not in front of the jury, but our cameras were rolling on it, and we want to take a moment to go back to it. So Her Honor Judge Penny Azkarate decided to take up that motion from TMZ. Remember we told you about this, where they're trying to intervene because the Depp team has subpoenaed their former employee Morgan Tremaine to give some testimony about that incident, the video where Johnny Depp is seen assaulting the cabinets, so to speak. And they filed a motion to intervene, citing the First Amendment and the protections afforded to journalists in America, saying that the judge should stop that testimony from happening. Let's go back into the courtroom now and watch.
Mr. Tobin?
Yes, Your Honor.
How you doing, sir?
Very well, thank you, Your Honor.
Thank you. Thank you, Mr. Tobin. If you could just come to the center.
Your Honor, before Mr. Tobin begins, I would just...
Okay.
May I approach?
Sure.
Thank you, Your Honor.
Thank you, sir. Go to the other side. All right.
Good to see you.
Mr. Tobin, if you want to.
Certainly, Your Honor. Thank you.
I got to make this relatively short, as you can understand, but I wanted to take up your motion. I have read your motion and the declaration and everything attached to it in all the cases, and I have reviewed it, so I'd rather you not regurgitate that based on our time limit, but anything you wish to add to that is fine. If I could focus you a little
Please.
bit. Okay.
Thank you, Your Honor.
All right. Yes, sir. As far as your comments about Virginia Rule of Evidence 2:508, that's a criminal rule of evidence, so that's not your strongest argument. And as far as what goes on is when or if the witness testifies, whether it's hearsay or it's third-party knowledge, that's something I'll deal with at trial. So again, not what I'm concerned with. As far as Supreme Court Rule 314, which I would like you to talk a little bit about that as far as intervention. And I got to tell you where I'm at right now. The concern, the issue I have with the argument is intervention obviously would make you a plaintiff or defendant in the case, and it has to deal with an issue that's germane to this case, and this is a defamation case. So if you could just tailor your argument to that issue, sir.
Sure, I'm happy to address the intervention. For the record, Your Honor, Charles Tobin from the law firm of Ballard Spahr,
yes,
here
sir,
representing TMZ, which is the publisher of news and entertainment for the celebrity and entertainment industry. And Your Honor, we're seeking to intervene simply to protect the relationship between reporters and their sources when it comes to reporting news in the public interest. We, as the court noted, we really don't have a dog in this hunt as far as Mr. Depp. Ms. Heard, we're really here purely on the First Amendment-based issue of reporters' privilege and reporters and their sources. Your Honor, the intervention rule, as the court is aware, allows intervention by anybody where the issue is germane to the subject matter of the proceeding. And certainly, Your Honor, the purported testimony, the proffered testimony of a former employee of TMZ who purports to be in a position to disclose confidential information learned during the operation of journalism, during his work as a journalist, is a germane issue that is being raised in this case. And Your Honor, we would point the court to the Tafts, Fletcher, Malden, and Reed versus Southern Bank and Trust case, 213 Virginia Circuit, Lexus, 253. It's a Norfolk Circuit Court decision from 2013. And there it was an interpleader action. The funds had been interpleaded into the court by two trust companies that were fighting over it. And the man who had sold his property, who had no interest in the funds themselves, intervened in the case because he was uncertain as to his liability for excess funds, which was an issue that was not directly in litigation between the two parties. It was not part of the cause of action between the two trusts fighting over the money that had been pleaded into the court. The circuit court held that certainly the rights of that man was going to be affected by the decision making in the case. He would be prejudiced if he didn't have an opportunity to intervene, and no party was in a position to assert his rights. And so similarly here, Your Honor, TMZ is a news organization. It routinely accepts information, as is common in journalism, under exchanges of promises of confidentiality. If it is not able to intervene in this action, and neither of the parties is going to be in a position to assert the reporter's privilege, it is TMZ's journalist privilege that we're talking about, then the rights are certainly going to be prejudiced.
But if the witness, in all the cases, and I reviewed the cases that you had, in those cases the witness was compelled to testify and came and was forced to testify, so there was an issue about the privilege of the witness. It's my understanding in this case this witness wants to testify and is not under subpoena.
He has been subpoenaed, Your Honor.
That's incorrect, Your Honor. He's voluntarily. A subpoena from this court would not be enforceable.
Okay.
Your Honor, I have a copy of a subpoena that was entered last night compelling Mr. Tremaine to give testimony in this case. And so he is coming under a compulsion under subpoena.
Well, and if he takes a stand and he asserts some sort of privilege, then that's something I will deal with at that time.
Sure, but I'm here because of the scenario where he may not assert that privilege.
Right, exactly. And that's why I'm saying all your cases that you showed were the opposite, where they did assert the privilege.
Well, it is a unique situation.
Right, and I understand you might have some issues with a former employee, and you have some avenues to go deal with that.
But once he testifies and the privilege is waived, we have lost our opportunity to intervene and to intercede.
Right.
And Your Honor, the privilege, I know, Your Honor, you said you read the case law.
I did.
Appreciate that.
Yes, sir.
But the privilege has been recognized by the Virginia Supreme Court in the Brown case and applied by the circuit courts uniformly. It is a very important underpinning of the relationship between reporters and sources and reporters and the public. Without the ability to enforce its promises by current employees or former employees. A news organization will have absolutely no control over being able to enforce its promises. And so we would ask the court to permit us to intervene and to assert the privilege that belongs to TMZ, which is the organization, after all, Your Honor, that would be responsible to the source if the privilege were waived.
All right, I understand, Mr. Tobin, your argument. I appreciate it very much. Okay, did the parties wish to be heard?
Okay, we're going to hit the pause button. This is really interesting. So this attorney is representing TMZ. The employee who is set to testify is no longer employed by TMZ. So you see here, they think that he is not going to invoke that journalistic privilege, and they want this privilege to protect the situation so that he does not have to give the information in open court about the sourcing, how that video was obtained, and whatever else came along with that exchange of information. So we're going to squeeze in a break. We'll be right back into the courtroom and hear the rest of it after this.
free at thezebra.com now.
Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. So we are watching very carefully the dueling defamation trial playing out in its final stages in Virginia between actors and ex-spouses Johnny Depp and Amber Heard. So we're in Johnny Depp's rebuttal case. The jury is on their lunch break, and the judge is taking up a motion outside of the jury's presence from TMZ. They filed a motion to intervene with potential testimony of a former employee named Morgan Tremaine. And so this employee was subpoenaed by the Depp team because apparently there was some exchange of information and video, that famous cabinet assault, as it's been deemed in the media, where Johnny Depp is seen punching the cabinets and Amber Heard was surreptitiously recording him until he realized it. Well, apparently TMZ is concerned that this is going to come into open court and be part of the public record. That employee is the one who is willing to testify about it. TMZ is trying to stop it. So that's kind of where it gets tricky. This employee is no longer working for TMZ. And so this lawyer has come to the courtroom to intervene ahead of time before it is too late for them. That's their position. Let's go back in where we left off.
Good morning, good afternoon, Your Honor. I'd like to begin where Your Honor began. As a threshold matter, the court should deny TMZ's motion to intervene. Intervention is not appropriate for the reasons suggested in Your Honor's questions. As Your Honor is well aware, intervention is only appropriate with leave of court where a third party seeks to, quote, file a pleading to intervene as a plaintiff or as a defendant to assert any claim or defense germane to the subject matter of the proceeding, unquote. Virginia Supreme Court Rule 3:14. As Mr. Tobin, to his credit, has conceded, TMZ is not asking to file a pleading. It cannot properly categorize itself either as plaintiff nor defendant, and it seeks to assert no claim or defense germane to the subject matter of this action. Moreover, even if the privilege were applicable, which is not the case here, the testimony intended is directly relevant and would outweigh any qualified privilege. Quote, an intervener must be asserting an interest that is part of the subject matter of the litigation, unquote, Hudson versus Jarrett, 269 Virginia 24/32. Here, as Mr. Tobin stated, TMZ seeks to protect potential information solicited from a third-party witness, which is in no way a matter before this court, citing Commonwealth versus Gill, 89 Virginia Circuit 323, a 2014 case denying a motion to intervene where the intervener filed it, quote, to protect a property right, not a matter before the court, unquote. The outcome of this trial will not affect TMZ, and it does not have a sufficient interest in the subject matter of this suit to intervene. See Texas Fletcher, Maiden and Reed, PC versus Bank National Trust Co., 2013 Westlaw 5849140, granting, and this is distinguishing it, granting the motion to intervene where the intervener's liability would be affected by the outcome of the litigation. Finally, Your Honor, TMZ lacks standing to object to testimony by a third party in this action because TMZ, as Your Honor pointed out, is not being compelled to testify. TMZ's reliance on the Philip Morris case for the proposition that the privilege cannot be circumvented by seeking confidential source information from an employee is inapposite. 36 VA Circuit at 1. For one thing, as noted in that case, there is no testimonial privilege akin to that enjoyed under the Fifth Amendment, which would allow a reporter to refuse to appear before a grand jury and answer questions. And Philip Morris, as Your Honor is aware, the party issued a third-party subpoena for records to trace confidential sources. Philip Morris is inapposite here, as that case related as this case is related to witness testimony, not records. As Your Honor suggested, TMZ's quarrel, if any, is with Mr. Tremaine to the extent that he had an NDA that was enforceable, applicable, and that's not what we're hearing from Mr. Tobin. So to the extent that TMZ, which is not exactly Edward R. Murrow, Your Honor, to the extent they have a beef, as it were, a cognizable beef, it is with Mr. Tremaine. It is not with Mr. Depp. And they clearly do not have standing to assert or to intervene because they are not intervening as a party, plaintiff, or defendant. So we respectfully submit, to the extent the court disagrees, I can go into the arguments why the privilege is inapplicable, but I will reserve that.
Thank you. All right. Yes, ma'am.
Your Honor, I would like to weigh in from just a different perspective, and that is because we're trying to deal with some important issues of privilege, et cetera. But from our perspective, representing Ms. Heard, we have issues with this witness separately, and I want to make them very clear for the record. This is somebody who should have been identified in discovery, was never. Second of all, it's not relevant whether, apparently what they're saying he's going to testify, and we have not had the opportunity to discover that, is he's going to claim that someone leaked to TMZ that Ms. Heard was going to obtain the TRO on that Friday and also leak the video, the kitchen video with Mr. Depp being rather violent. I'm almost certain he's not going to claim it's Ms. Heard, so I think it's never going to come in.
All right. Ms. Berhoff, I understand all that argument. Do you have any argument as to this particular motion?
No,
okay, well, then we can address you.
My point is, though, if you balance the prejudice versus the probative value, I don't even see how he can come in on foundation or hearsay or relevance.
That's just not part of this motion at this time. Thank you, ma'am. All right, Mr. Tobin, your motion, you get the last word, sir.
Thank you, Your Honor. You know, I appreciate that the court shook your head when he made the snarky comment that this is not Edward R. Murrow. Obviously, the First Amendment applies to everybody, citizens, the New York Times, or TMZ. And this is a First Amendment-based privilege. Your Honor, the Philip Morris case is actually a very good case to answer Your Honor's question about the intervention of somebody else in order to assert the privilege. There, ABC was a defendant in the case, and it moved in order to prevent other people, the phone company.
Right. But they were already in the case in that particular
I understand.
matter.
There is no other mechanism, though, and so it would be an interesting procedural issue for appeal, Your Honor, whether a journalism organization or anybody else who's a First Amendment holder would be denied intervention on a constitutional-based privilege. I also, just for the record and for the merits of the case, if I understood Mr. Chu correctly, he said this is not an issue in the litigation. This does not relate to an issue in the litigation. Well, if it's not an issue in the litigation, if it's not part of a prima facie part of the defense, part of the allegations of the complaint, if it's impeachment evidence, if it's collateral to the main issues in the case, under the Brown v. Commonwealth decision under the Virginia Supreme Court, under the application of that privilege in the Philip Morris versus ABC News, it is not supposed to be compelled in this case.
Which is, again, it's not being compelled, it appears.
Well, he is appearing by subpoena, and it is a compulsory process, and he will have an obligation unless he asserts privilege under oath. But it is our privilege, Your Honor. It's not an employee, a loyal or a rogue employee's privilege to waive on behalf of its employer. This is an unusual situation.
Tell me about it.
But the answers are there. In the law, and it is a First Amendment concern.
This is not the first unusual situation in this case. I can
for
tell you
for
Mr. Tobin.
For anybody here, I'm sure.
Yes, sir. I appreciate you coming in today, and I appreciate your arguments. Yes, sir. Thank you. All right. In this matter, under Virginia Rule Supreme Court 3:14, a new party may intervene as a plaintiff or defendant to assert any claim or defense germane to the subject matter of the proceeding. A new party may not intervene unless they assert some right involved in the underlying litigation. A party is not entitled to intervene merely because a byproduct of the litigation adversely impacts them, and the decision to allow intervention is within the broad discretion of the trial court. Here, the rights asserted are not germane to the trial. The central issues in this case are whether defendant defamed plaintiff and whether plaintiff defamed defendant through a theory of vicarious liability. The issue of the confidentiality of sources has has not come up as in other cases cited by EHM, which is the corporation that TMZ belongs to, is under their umbrella. In Brown versus the Commonwealth, there was an attempt by the criminal defendant to subpoena institutions in order to obtain the name of the confidential source. When the author of the article was subpoenaed, she refused to identify her confidential source on the stand. And in this case, it appears that the witness is willing to state the name of the confidential source without being compelled voluntarily. Whether that breaches a non-disclosure agreement between Mr. Tremaine and EHM is not germane to this matter and can be litigated in a separate matter if EHM so chooses. And while breaches of contract must be taken seriously, and the court does, any alleged breach is not germane to the underlying litigation here. That contractual action has no bearing on this case and is thus not germane to this litigation. Therefore, I'll deny the non-party EHM Productions motion to intervene.
Thank you, Your Honor. For the record, I've known Mr. Tobin for several years. I meant no snarkiness toward him.
Well, you're just a snarky guy.
May I just ask one more procedural issue for the record?
Ashley, Mr. Tobin.
Your Honor, I am concerned that we preserve the issue fully. And so,
for the record, yes,
for the record. And so I would ask, may I have the opportunity to object when Mr. Tremaine is questioned by question?
No, sir, you're not a party to this case. However, I will note for your record your objection to his complete testimony on behalf of your client.
Right, thank you, Your Honor.
Okay, thank you. Your microphone.
All right, so with that, TMZ's motion is denied. The judge made a little joke at the end there, directed at Mr. Chu. Very friendly commentary at the end, but boy, oh boy, that was a big dig there, what Ben Chu said about TMZ being not exactly Edward R. Murrow. And you clearly, Mr. Tobin, the attorney representing TMZ, took issue with that because TMZ certainly does do journalism, and they are concerned and put forth the argument that they are the journalistic privilege holder. The First Amendment affords protections to journalists who cannot be compelled to reveal sources or be brought into a court of law. And what the attorney was arguing was that they are the privilege holder as the organization, not this individual, Morgan Tremaine, who is now no longer working for the organization. So the judge was kind enough to note the objections for the record going forward. But I think with that, we can expect the testimony to happen in just a short while. The jury's lunch break is going to be finishing up, and as soon as they're brought back in, we're going to go back in together live. In the meantime, here at Court TV, of course, we are following other stories happening throughout the country, and we have some breaking news just in that we want to share with you right now. This is about that love triangle murder case we've been following for you involving that professional cyclist. The U.S. Marshal Service has just released surveillance video of who they say is a murder suspect, this woman, Caitlin Armstrong. She is currently on the run. The 34-year-old Texas woman is suspected of shooting and killing cycling star Mariah Wilson on May 11th. Authorities say the killing happened in a jealous rage because of this love triangle. Now, the U.S. Marshals say that Armstrong boarded a flight from Austin, Texas to Houston's Lobby Airport 3 days after the shooting. They then say she boarded a connecting flight. Investigators say that flight was to New York's LaGuardia Airport. The Marshal Service tweeted out that Armstrong was last seen looking as she is here, wearing that blue denim jacket, a black t-shirt, white jeans, and a black mask. A possible yoga mat as well she may have being carried on her shoulders. Now, Armstrong is suspected of killing Mariah Wilson in Austin, Texas, after finding out that Wilson had had an affair with Armstrong's boyfriend. Wilson was in Texas training for an upcoming race near Waco when a friend she was staying with discovered her body. This is so sad, and a story that continues developing with every minute. We'll keep you posted if we hear more from the marshals. As I've said before on the show, I'll say it again, they are good. If somebody's on the run, they will certainly find them. What we're going to do now is squeeze in a break. When we come back, we'll talk about that motion we just heard in the Depp Heard defamation case, what that testimony from that TMZ employee could mean on rebuttal, and then what's coming in Rebuttal. So much more ahead. Don't go anywhere. This is Court TV. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. We are waiting for the jury to return back from their lunch break to hear more of the rebuttal case in Depp versus Heard. So the way things go, you've got the plaintiff's case, you've got Amber Heard's defense to that case, and her counterclaim. And then in this rebuttal opportunity, Johnny Depp gets to defend the counterclaim allegations and then also offer rebuttal to, her defensive, responses that she gave. So it can be a bit confusing. And after rebuttal comes what's called sur-rebuttal. So Amber Heard will have her opportunity as well to put on evidence after this. Johnny Depp ended on a very, very strong note today. And so as we look ahead to the next witness that is probably going to be called, of course, Johnny Depp's going to be cross-examined, but we think the Depp team is going to move forward with their plan to call that witness from TMZ to talk about video that was supposedly leaked showing Johnny Depp assaulting the cabinets, as many people have kind of referred to that video. Let me bring in my guest to see what she thinks about it. I have with me in Atlanta, Georgia, trial attorney C.K. Hoffler, and also I have with me forensic psychologist Dr. John Delatorre, who I'm going to have some questions for you, Dr. John, about Dr. Curry's testimony. But first, let's address this motion. So, C.K., you were watching this playing out. We know the judge said, sorry, TMZ, we're denying your motion to intervene. So if that journalist wants to come in and testify, he can. Do you think that was the right ruling by the court?
Julie, I do think it was the right ruling. I am licensed in Virginia. That's one of the states, that's probably my fourth state that I became licensed in. And I pretty much felt that the judge was going to rule that way, consistent with Virginia law that I had researched just very, very quickly. But I think it was the right ruling because they could not intervene being non-parties. And as much as I think, there is a privilege that can exist, that journalists need to protect their sources, in this instance, because of their posture, not being a plaintiff, not being a defendant, coming in, the interest not being vital to the ultimate outcome of this case, I think the judge was right on, spot on. Now, TMZ, unfortunately, is going to have to potentially sue its former employee. But this decision is going to have ramifications, or will resonate, if you will, in the journalistic community as relates to First Amendment rights and the protection of sources, and it's going to be important. But we have to remember that this is a defamation case. By definition, this is a First Amendment case. I've tried these types of cases. And so the judge is keeping her eye on the prize, the focus on this case, and I think she made the right decision. Now, I will say this is a victory for Johnny Depp's team. They opposed TMZ's motion. So that just tells me that, of course, and we know this, they want to bring in this witness, and they believe this witness is going to say something that's going to be very incriminating against Amber Heard. Otherwise, they wouldn't be fighting this way. So I think this is a victory for the Depp team, and I think this is not good for Amber Heard's team, as evidenced by the arguments put forward by each side.
CK, thank you for all of that. Yeah, I think this is coming on in and not going to be good, as you said, for the Heard side of the case. Okay, what I want to do now is play some clips from the woman who was on the stand earlier this morning offering expert witness testimony, Dr. Shannon Curry. We saw her before when the Depp team presented their case as of course, the plaintiff's case in chief, and now she was called again on rebuttal. Let's take a look back together now.
There were 3 checklists that she gave that are specific to abuse. And the first she gave, the danger assessment scale, was actually developed for use by nursing staff in an emergency room setting, specifically for female victims of intimate partner violence. The purpose of this is important because our forensic ethics, our psychology ethics, talk a lot about relevance. Is the test relevant to the purpose? And the danger assessment scale, its initial purpose was completely different. This was developed to show high risk factors for dangerousness and pretty much to help a female who is in an extremely abusive partnership, who is in the emergency room with extreme injuries, to stop rationalizing, because if she has to check off all the things that have happened that year that have been dangerous. Does he own a gun? Has he, I won't go into all of them, but the more she checks off, the more likely it is that she might realize that she is in imminent danger, and then accept resources offered by the hospital and social work to protect her. That was the purpose of this scale. It was never intended to be used as a retrospective measure to look back in time and find out whether abuse was occurring based on one person's report years later in a litigation. She also misrepresented information, clear indications on several of the objective measures that she offered. And there were indications visible that Ms. Heard had essentially engaged in what we call response distortion. So clear indications of exaggeration on one of the measures that's specific to PTSD, clear minimization of symptoms intentional on another more broad personality and psychopathology-based measure that she gave to Ms. Heard, which she did not acknowledge.
Okay, so this expert witness brought in to refute everything that Amber Heard's expert witness said about Amber Heard having PTSD, about all the abuse and trauma she suffered allegedly at the hands of Johnny Depp. Now, earlier when I was talking with Ted Rollins, I said, this witness is so good on the stand. She could tell me the sky is pink, and I'd be like, huh, you don't say. I believe you. You so are effective before this jury. Just the way she engages and looks at them, she's so natural. But is she right? Dr. John, you were watching this carefully today. Kind of cut through the clutter for us. For those of us, who don't know anything about forensic psychology, was she right what she was saying when she was criticizing the Heard witness for what she did and did not do in the test administration and such?
Yeah, absolutely. I find her to be a highly credible witness, and I love listening to her. She breaks everything down absolutely to bite-sized morsels that a jury can take in and fit the narrative that's already in their heads. And she's not wrong when she comes to the criticism of Dr. Hughes's evaluation. The problem is that similar criticisms can be made about Dr. Curry's evaluation. So she's not immune to the same kinds of issues that she identified in Dr. Hughes's evaluation. It's just that Amber Heard's team did not have a true way of impeaching Dr. Curry's evaluation.
Now tell me, Dr. John, let's just say you were asked to consult with the Heard team about some things that you would want to, cross her on, to bring out those things where you said she would be open to criticism. What are the areas that you see? Because for lay folks, like myself, I wouldn't know, where to go with that. I'm not trained in your field.
Yeah, the first thing that I would do is have questions about test construction. Right, she talks a lot about what all of these questions are supposed to be, whether they're face valid or not. So I would ask her, well, how are these tests actually constructed? Who are the norming population samples when it comes to the tests that you administer? There's a score, there are psychological evaluations that have a T-score, some that have a Z-score. What do these scores, how are they derived? What do they actually mean? How do you compare Amber Heard's results with those individuals that are from the norming population? If you can't answer basic test construction and statistical measures, then you can go to argue that the person doesn't understand the results that were obtained and misinterpreted those results.
Dr. John Delatorre, attorney C.K. Hoffler, great to have you both on the show. We're going to squeeze in a break. When we come back, we will continue keeping our eyes on the courtroom in Virginia as the jury's set to be brought back pretty soon. We're going to see Johnny Depp cross-examined by Amber Heard's attorney. Don't go anywhere. This is Court TV Live, your front row seat to justice.
I just see my little sister with her back her back to the staircase, and Johnny swings at her, and I don't even wait for any other, I don't hesitate, I don't wait, I just in my head instantly think of Kate Moss and the stairs, and I swung at him. In all of my relationship to date with Johnny, I hadn't landed a blow. And I, for the first time, hit him. Like, actually hit him. Square in the face.
Oh, remember those words where she said, I think of Kate Moss and the stairs. And then many of you watching closely saw that moment where Johnny Depp's attorney was kind of like, yes, you know, he made that motion in court telling all of us trial watchers that they had something in their pocket ready to go if she did reference that incident with Kate Moss. That did not happen. First witness of the day today called by the Depp team was the supermodel herself, who testified via video link from the United Kingdom. She lives in London, and she dated Johnny Depp back in the 90s. They were an iconic couple. She spoke about their romance. It was several years long, and she was asked about an incident where she fell down the stairs. The two were on vacation in Jamaica. Take a listen to how she says it happened.
We were leaving the room, and Johnny left the room before I did, and there had been a rainstorm, and as I left the room, I slid down the stairs, and I hurt my back.
How did you...
And
I apologize, Ms. Moss. Please continue.
And I screamed because I was because I didn't know what had happened to me, and I was in pain, and he came running back to help me and carried me to my room and got me medical attention.
So with her testimony, Johnny Depp saved her, picked her up after she had slipped, fallen, hurt her back, and then he carried her back to get some medical help. That is how she says the story goes, not that she was pushed by him down the stairs. Apparently that rumor kind of arose, according to some research, by way of Amber Heard's testimony in the United Kingdom case. Let me bring in trial attorney C.K. Hoffler, standing by in Atlanta, and forensic psychologist Dr. John Delatorre in San Antonio. C.K., you know, this is one of those things that, you know, it's kind of like a self-inflicted wound here. You know, Amber Heard didn't have to reference that at all, and then look what they got.
So, Julie, this is a moment where the mic just simply drops. You know, they obviously anticipated that Amber was going to raise this because she has been talking about this evidently outside of the courtroom, and maybe this is an issue that she threw in his face before. And they were hoping, you could just tell, they were just hoping and praying that she would raise it because they knew what Kate Moss was going to say. This severely impacted Amber Heard's credibility on that issue. And they were just waiting for the opportunity and rebuttal to bring it up. So I think that was a bad strategic move. There is still blood on the floor, figuratively speaking, related to Kate Moss's testimony. And I think the jurors are probably just wondering, you know, what they're giving more credence, I believe, especially with Dr. Curry testifying again on rebuttal, to what Dr. Curry is saying about Amber having, you know, two personality disorders, if you will, which cause her to exaggerate, to inflate, and to envision things that are not truly the case. Plus, they're putting that together with Amber Heard's own testimony that she finally got a punch in and hit Johnny Depp. I don't think Amber really fully recognizes how destructive her saying that really is to her case.
Yeah, that was a problem. Didn't need to happen, and they were smart to bring her in on rebuttal. Dr. John, quickly, what did you think of Kate Moss, how she testified? She's so gorgeous and statuesque, and when you're listening to her, do you find her to be very truthful?
Absolutely. You know, we've been waiting for star power. Here's star power. Here's everybody. Here's someone that everybody knows, and she testified cool, calm, and collected, exactly how Depp's team would want her to be.
Dr. John, C.K. Hoffler, so great to have you both on the show. Thank you so much. My time is done here, but don't you go anywhere. We're going to get you back into that courtroom in just minutes. Ashley Wilcott is taking over here at the desk. Ashley, good to see you. What a day it is today.
What a day it is. Great to see you, Julie. I'm glad you brought up that testimony from earlier today of Kate Moss, but Johnny Depp did his direct examination, compelling testimony. When we come back, we are going to bring you his cross-examination when that jury returns to the courtroom. We will take you back there. Live testimony will continue right after this quick break. Court TV, your front row seat to justice.
We call Mr. Depp.
Okay. All right. So just a reminder, you're still under oath, okay?
Yes, ma'am.
Johnny Depp back on the stand today in his defamation trial against Amber Heard. So is he performing as well as he did during his initial testimony? His rebuttal case could be done soon. Depp's testimony follows that of another superstar, his former girlfriend, Kate Moss. What did Moss say about Amber Heard's claim that Depp pushed the supermodel down the stairs? And yet, another big moment for Depp's team, recalling psychologist Dr. Shannon Curry. Will the jurors believe her diagnosis or that of Amber Heard's doctor? We're going to go back into court for Depp's rebuttal case in just a moment. Our legal experts are standing by to discuss whenever we have breaks or sidebars. All that coming up. Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Good afternoon. Thanks for joining us. We're in day 22 of testimony in the dueling defamation cases of Johnny Depp versus Amber Heard. Possibly the final day today of Depp's rebuttal case. Both sides are suing for millions, each claiming that the former spouse ruined the other's Hollywood career with allegations of domestic abuse. Johnny Depp took the stand just after 11 a.m. Eastern time today and addressed Amber Heard's version of the liquor bottle assault in Australia, among other things. The jury is expected to get this case by Friday. Now, they had a lunch break and Depp is back on the stand. Johnny Depp now under cross-examination. You haven't missed a thing. Let's go back to the courtroom.
July 2015.
Surely.
You testify that you took a train ride from Bangkok to Singapore, is that right?
That's correct.
And you claim that on this train ride that Miss Heard hit you in the face, correct?
Yes.
And left a black eye, correct?
Yes.
And Michelle, could you please pull up PX 162?
Is that already in evidence?
Yes, Your Honor.
Published to the jury?
Thank you. Mr. Depp, this is the picture that your counsel showed you both in your prior, or showed you this morning, correct?
Yes, sir.
Okay. And that mark under your left eye is what you claim to be a black eye caused by Miss Heard, correct?
Seems to be there's some scratches around my nose as well.
Okay. All right, but that it's your left eye, the one close to the chef. That's what you says your black eye, correct?
Yes, sir.
Okay. And that was the picture your team chose to show you, right?
Let's
pull up Exhibit 1905, Michelle, please.
I'm sorry, which number was it?
This is a new exhibit, Your Honor, 1905.
And that's defendants?
Defendants Exhibit 1905.
Okay, thank you.
Ask for permission to publish, Your Honor.
Or you want to put it in evidence? Okay, any objection to 1905?
With the comments, we have no objection to the photograph itself. We would ask the comments be redacted as hearsay.
Well, I'd like to at least question the witness about the
I
comments.
have no objection to the photograph being published.
Okay, well, then let's wait a minute. Mr. Depp, you see here, these are 4 pictures of you, right?
Yes,
see that? And below it, they indicate that they were taken on July 24th, 2015 in Bangkok, Thailand, correct?
Objection, lack of foundation, calls for speculation.
Overruled.
In Bangkok, Thailand, so before the train ride.
Correct, before the train ride, because you didn't get on the train ride till the 25th, is that right?
Somewhere in that area, I guess.
Okay. Your Honor, I'd ask for permission to publish this to the jury.
All right.
If it's just the photographs, we have no
All
objection.
right, if you want to redact the, just have the photographs in it?
Sure. We'll do 1905.
05, just with redaction, so it'll be fine. I think there's still some on the bottom. I'm just.
It's just redact that. Yeah.
Okay.
Thank you, Michelle.
All right, publish.
Thank you, Your Honor. Michelle, could you please scroll down to the bottom 2 pictures there? Mr. Depp, in these pictures that were taken before you got on the train ride for your honeymoon, where you claim that Miss Heard hit you and gave you a black eye, you have the exact same shadow or sunburn or mark under your left eye. The exact same mark, don't you?
That's the, when you get a side light, you see the occipital bone. So that is the exact area.
Yep. And it's actually...
A side light will cause that.
Yeah, well, the picture's not being taken from the side, is it? It's being taken head on, isn't it?
No. The lens in front,
the
light on the side will cause that occipital bone, I believe it's called, to appear sunken.
Just like lights on the side of a train car, correct?
Objection calls for speculation.
You can take that down, Michelle.
That was, in fact, in the dark. And I had a chef, I had people on either side of me, so I don't see where the light fill is from the side there.
Mr. Depp, if you could wait for the next question. Next question.
Next question. Even the picture your team chose to show you on that train isn't accurate, is it? Let's pull up
Objection
exhibit.
calls for speculation.
Let's pull up exhibit 1859, please.
1859, is that in evidence?
No, Your Honor. Mr. Depp, this is the same picture or the exact same scene displayed in PX 162 that you looked at this morning, correct?
That looks like my face has been, the eyes have been photoshopped.
Oh, okay. So this post from the Eastern and Oriental Express's Facebook page, you're saying that that's photoshopped?
Is that from their page? I would, sure, why wouldn't they?
Let's pull them up side by side, please. Your Honor, I'd move for the admission of this exhibit. We can just have the pictures. We don't need the...
Any objection to the picture?
Objection, lack of foundation, lack of authentication.
Is that you in the photo, Mr. Depp?
It is me, but it's clearly...
Your Honor, I'd move to strike anything after that, first of all, and would ask for admission of this photograph.
All right, just the photograph?
Yep.
You're gonna...
We maintain our lack of authentication, lack of foundation.
All right, over objection, I'll allow 1859.
Thank you, Your Honor. Michelle, could I please get you to...
You need to redact it first.
We actually have one that will admit or ask to be admitted as 1858. That is just the picture.
I already have 1858.
Okay, so we'll call this 1859 then.
This is 1859.
Yeah, we just need to...
Okay.
We'll fix that exhibit sticker on the bottom and get you that correct 1859.
1859.
And Michelle, what I'd like to ask you to do, please, is to put the picture displayed as 1859, just was admitted into evidence, next to PX 162 that was shown to Mr. Depp this morning.
Okay, you can pop those, are both in evidence.
Okay, can you try to make them the same size, please? This is the exact same picture, isn't it, Mr. Depp?
With radically different quality. And...
No, you answered my question. Permission to
you know
publish.
I wasn't done answering.
You answered my question, sir. Thank you. Appreciate it.
You're very welcome.
Mr. Depp, you had that, whatever mark it is, whether it's a sunburn, whether it's a shadow, whether it's the light reflecting, you had that same mark on your eye before you got on that train.
Well, it's pretty difficult to get a sunburn on a train. And in the photographs with the child, I don't look particularly sunburned. Can we see those again?
Let's pull up exhibit one. Actually, no, let's talk about Australia for a little bit.
Oh, good.
You testified that you've never done ecstasy more than a handful of times in your life, correct?
6, 7 times.
Now, you heard Miss Heard's testimony. You've been sitting here. I know you didn't look at her, but you heard her testimony. And you heard her. You didn't hear her say you ingested 8 to 10 all at once. She said she came down after being apart from you for some time, and there were 8 to 10 gone from the bag.
Objection form compound.
Oh, overruled.
I also heard Miss Heard say I reached into a bag and poured a bunch of MDMA down my mouth.
Correct. That's right. She didn't say you poured 10 at one time, did she?
No, she said a handful.
Okay.
Which is more than 10, I believe.
Okay, the fact is, Mr. Depp, you were asking for ecstasy. You who have only done it 6 times in your life, you were asking for ecstasy and cocaine within minutes of being admitted to the hospital after suffering your finger injury, weren't you?
Objection compound.
I don't recall that I was begging for any drugs.
Yeah, let's pull up plaintiff's or exhibit 393, please. You just said you don't recall you were begging for any drugs?
No, I don't, but I do recall being in great pain and great distress, so.
Okay.
I could have asked for a teddy bear as well.
Okay. So this has been admitted, Your Honor.
This is in evidence, okay? You can publish.
And if you can blow up the text, please, Michelle. In this text message, Mr. Depp, you were, after you suffered your finger injury, you just testified you don't recall asking for any drugs. You're texting Nathan Holmes, your personal assistant, need more whitey stuff ASAP, brother man, and the e-business. Now, we went over this in your cross-examination, didn't we?
If you say so, sir.
And whitey stuff is cocaine?
I would say.
And the e-business is ecstasy?
You already testified? Quite likely, yes.
Okay.
So I didn't recall that.
Thank you.
But,
can you pull up exhibit 1817, please? This is a picture that you were shown this morning, Mr. Depp.
Yes, sir.
And you kind of made some illustrations on the picture and gave your account of what you see here. Mr. Depp, you testified previously that the vodka bottle that you allege cut off your finger was a handle of vodka, correct?
Yes.
You've already testified to that.
The second bottle, there was a handle on that bottle,
Right.
yes.
This bottle, whatever it is, to the extent it's glass at all, that's in the corner of this room, that's not a handle of vodka.
Objection calls for speculation.
I think you'll find that I said 2 bottles.
Well, actually, what you testified to this morning, Mr. Depp, was that the bottle in the corner was the handle. And there is no other bottle in the picture, is there?
No, that's not what I testified. I testified that, may I touch the screen?
Yes.
This is glass. This is glass.
Yep. And that's not a handle. Neither of those are handles of vodka.
It's that big. It's broken. The handle's up the top on those vodka bottles, sir.
Yeah.
I mean,
and none. If you combine all that glass on the floor, that doesn't make up the amount of glass in a handle of vodka, does it?
Objection calls for speculation.
I'm not a,
When there's objection, hold on. I'll sustain the objection. Next question.
There is no picture of a handle of vodka broken on that floor, is there, Mr. Depp?
No, I don't see it. I see glass under this chair here.
Okay. Well, you testified this morning that you did see it, so it's good to get that clarification. Let's move on.
I didn't say I saw a handle.
You also testified this morning that and I want to get this. I want to make sure that we're on the same page here. You testified earlier this morning that there was no phone in the bar area downstairs. Is that what you testified to?
I don't recall a phone in the bar area.
Okay.
I don't recall a Bakelite phone in the bar area where I.
Okay.
No.
Let's pull up Michelle, please. The UK day 3, page 421. Mr. Depp, we've done this drill before. This is your testimony from the UK, correct?
Can I please have?
We don't have copies for everyone. It's on the screen.
Your Honor,
right there.
may I please? I would like to have.
We're not going to miss any of this testimony. Johnny Depp under cross-examination during the rebuttal case that he is putting forward. Is it an effective cross-examination? Let us know what you think. You are going to not miss anything. We'll be right back on the other side.
Download the free app now.
Let's get you back into this Virginia courtroom where Johnny Depp is under cross-examination. And I'd love to hear from you on social media. The cross-examination is rather aggressive, but as a result, attorneys are talking each other and Johnny Depp's trying to answer while another attorney's talking. It's hard to understand all of it. Where we left off, you haven't missed anything. We hit the pause button, is two attorneys talking about their objection. Let's go back to court.
What is the testimony of the witness?
Here, you can have my copy.
Thank you.
Mr. Depp, you remember giving testimony in the UK trial for several days, correct?
Okay, so here.
Yep.
So I do remember a telephone in the bar area, and this telephone you picked up was made of Bakelite.
This is my turn to do this, Mr. Depp.
I'm sorry.
On page 421, line 19, you were asked the question, and this telephone that you picked up was made of, I'm sorry, I'm going to go up line 15. Question, at one stage when you were in the kitchen screaming at Ms. Heard, you picked up a wall-mounted telephone. Do you remember a telephone in the kitchen? Answer, no ma'am, I remember a telephone in the bar area. Question, and this telephone that you picked up was made of Bakelite. Do you know what I mean by that? A retro telephone, wall-mounted but retro. Answer, it was a wall-mounted telephone, but it was not Bakelite. It was a modern phone. It was plastic. Question, a phone that was a wall-mounted phone that was picked up, can you scroll down, please? Question, a phone that was a wall-mounted phone that was picked up by you, held in your right hand, and you were repeatedly smashing it against the wall in your right hand. Answer, that is possible. But I do not, if that is the case, I do not believe I spent very much time on the phone. I remember ripping the phone off the wall. That was your testimony, correct?
It seems it would be yes.
Thank you. You answered my question. Thank you. Mr. Depp, you've claimed before, you've said, if I'm angry and I've got to lash out or hit somebody, I'm going to do it. And I don't care what the repercussions are. Anger doesn't pay rent. It's got to go. It's got to be evicted. You've said that before, haven't you?
Have you a quote from me somewhere saying that?
It's my question to you. You've said that before, haven't you? Well, actually, let's refresh your recollection. Can you pull up the Ghost in the Machine article, please?
Possibly about paparazzis.
Mr. Depp, you see the picture of you on the lower left.
Yes.
Appears to be shirtless and wearing a crown, I believe. You see the long paragraph above that starts with "in the Mark Hotel"?
Yes,
You see that?
yes.
At the bottom of that, does this refresh your recollection that you said, I have a lot of love inside me and a lot of anger inside me as well. If I love somebody, then I'm going to love them. If I'm angry and I've got to lash out or hit somebody, I'm going to do it, and I don't care what the repercussions are. Anger doesn't pay rent. It's got to go. It's got to be evicted. Did I read that right?
You did read that right, yes.
Thank you. You can take that down, Michelle, please. Now, Mr. Depp, you've also claimed that you've said before that if you want to be with a woman sexually, that she is rightfully yours, haven't you?
Could you repeat that?
And you've also said that with
Could you repeat that, please?
Yeah, that if you want to be with a woman sexually, that she is rightfully yours.
That's ludicrous.
You've also said that with respect to women that you want to be with, you've remarked, I need, I want, I take, haven't you?
Equally as ludicrous, no.
Can you pull up DX883, please?
You can pull what you like. I've never said those words. There's not enough hubris in me to say anything like that.
883?
883, Your Honor.
It's not, is it empty?
It is not admitted yet.
Okay, 883.
Mr. Depp, these are text messages from you to Stephen Deuters on February 22nd, 2017, correct?
This looks nothing like me. You might have mistaken.
Mr. Depp, we can show the full unredacted. You've looked at a number of text messages in this case, and the words him as the identifier, that's you, correct? In every text message we've seen in this case.
Yeah, sure. It still doesn't mean it hasn't been screwed with. That's not anything that I've ever said or written.
You want to see the whole thing unredacted? We can look at that too.
No, because you could have typed it up last night. No.
Yeah, I can assure you I didn't type it up last night, Mr. Depp. Your Honor, I'd move for the admission of Exhibit 883.
All right, any objection?
Objection on relevance grounds, Your Honor.
All right, Marilla, do you want to approach for a moment? Yes. Let's take a look.
You know, could this be a critical moment for the jury if, in fact, a text message between Johnny Depp and someone else says, I need, I want, I take? Because Johnny Depp just testified he absolutely has never said that he doesn't have the hubris to say that. So what is the jury going to decide? You're not going to miss any of this testimony. We're going to take a break, of course, hitting the pause button. When we come back, we'll get you back into the courtroom.
Your hard work pays off.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. The rebuttal case is today by Johnny Depp's team. On the stand, Johnny Depp himself. He finished his direct examination. He's been under cross-examination. I've been looking at social media posts. Many are finding that Rottenborn, who's the attorney for Amber Heard doing cross-examination, is too aggressive and somewhat rude to Johnny Depp. But listen, he just was about to present evidence. We're going to take you right back into court to prove that Johnny Depp did say, I need, I want, I take, even though Johnny Depp has denied that under oath. Let's get you right back into the courtroom. You've missed none of the testimony.
All right, 883 in evidence as redacted.
Thank you. Mr. Depp, you're aware that these are text messages. You can see the bottom right where it says Depp and then it has a number, 8129. Those are produced by you in this litigation. You understand that, right?
I understand that, sir.
Okay. All right, Michelle, could you please, let's take a look at the top text first. Mr. Depp, on February 22nd, 2017, you texted Mr. Deuters, right,
You read it, right?
And the one beneath that, you say, I want to change her understanding of what it is like to be thrashed about like a pleading mackerel. And then in all caps, you write, I need, I want, I take. Did I read that right?
You read it right, but I did not write that.
Okay.
Perhaps someone else.
You wrote
had
every
my
other
phone.
text that you produced that came from you in this litigation, didn't you?
Not necessarily. Sometimes you give your phone to people and they
Now,
text
when you
from
got
it.
off that plane from Boston,
I'm sorry?
when you got off the plane from Boston, you knew Miss Heard was angry with you, didn't you?
It was pretty much a given.
Objection, calls for speculation.
And you understood her to be angry, right?
She was always angry, yes.
And you asked Mr. Deuters, same person, you can take this down, Michelle, please, thank you. Same person that you texted in that last exhibit, you asked Mr. Deuters to communicate with her on your behalf, correct?
I don't know what you're talking about. You'll have to explain.
You asked Mr. Deuters to communicate with Miss Heard by text to speak to her about the incident, correct?
About what incident?
To speak to her about the plane flight.
The plane?
The Boston plane.
The Boston plane?
Yeah.
So you're saying that I influenced Mr. Deuters. I told him that he had to write this, and I told him that he had to write that. Is that what you're saying?
No. It wasn't uncommon for Mr. Deuters to text to communicate with Miss Heard on your behalf, correct?
Objection, calls for speculation.
He was your personal assistant. Mr. Deuters was your personal assistant, correct?
I had two personal assistants at the time.
He was one of them, right?
Yeah, Mr. Deuters was one of them, yes, sir.
Right, and it wasn't uncommon for you to ask Mr. Deuters to communicate with Miss Heard on your behalf, correct?
It wasn't uncommon for any of them to communicate with Miss Heard on my behalf if I were on set or unavailable or any of that.
Or if Miss Heard and you had a fight, you would sometimes have them communicate with Miss Heard on your behalf, correct?
I think my crew caught on very quickly that
just a yes or no
would be necessary for them to.
No, just a yes or no. It was not uncommon after you and Miss Heard had.
I'd ask that he be allowed to finish his answer.
Yes or no question, Your Honor.
All right. Go ahead and ask your question again.
Thank you, Your Honor. It wasn't uncommon for you to have one of your personal assistants communicate with Miss Heard after you and her had a fight.
I disagree because you're insinuating that I had them do it, and you don't know that.
After the Boston plane flight, you had Mr. Deuters communicate with Miss Heard, correct?
When I'm asked what to do, I said placate her, just placate her like we always do.
And you told him, send her whatever message you need to send to placate her,
I'm sorry,
correct?
he's sorry, he feels bad, yes, because any other answer, it would turn into World War III.
Okay. Can you pull up Exhibit 229, please? Your Honor, I think you know where I'm going here, and based on Mr. Depp's testimony, I'd move for the admission of Exhibit 229.
Your Honor, can we please approach?
Sure.
Benjamin Rottenborn is attempting to have evidence introduced that contradicts what Johnny Depp is saying on the stand in response to his questions. Will it be effective or not? That's something for the jury to decide.
Mr. Depp, you were pretty angry after Ms. Heard got her temporary restraining order, weren't you?
Angry. I was, more than anything, I was hurt.
And you testified earlier this morning, you claimed that you somehow were responsible for her getting the role with Warner Brothers, correct? That's what you testified to this morning. You also tried to get her fired from Aquaman, didn't you? After the temporary restraining order.
Which question would you like me to handle first, sir?
One question, sir. You tried to get her fired from the Aquaman after the temporary restraining order, didn't you?
Well, what is related to the story about me getting her?
Yes or no, Mr. Depp. I didn't ask
does
what
not
related,
come down to
what
yes
story
or no at all
related to.
times. I can't please you with a yes or a no every single time.
It's a yes or no question, Mr. Depp. You tried to get Ms. Heard fired, didn't you?
Answer's no.
All right, let's pull up Exhibit 821.
Is that
Mr.
me
Depp,
trying to get her fired?
This is a text message that you had with your sister, Christy Dombrowski. She was the first witness in this case, right?
She doesn't work at Warner Brothers. You can't fire Amber.
Yeah. This is a text message you had with her on June 4th, 2016, isn't it?
June 4th, yes.
Your Honor, move for the admission of Exhibit 821 as redacted.
Any objection?
We would object on relevance grounds, Your Honor.
I'll overrule that objection. 821 in evidence.
And on June 4th, 2016, Mr. Depp, you texted your sister, "I want her replaced on that WB film." Did I read that right?
You did.
Her is referring to Amber, right?
That's correct.
And WB is Warner Brothers, correct?
Again, correct, yes.
And then after you sent this text to your sister, following the temporary restraining order, you reached out to Guy Silverstein to have him fire Amber, correct?
Who?
Greg Silverstein, I'm sorry.
I don't recall reaching out to Greg Silverstein.
You reached out to Sue Kroll to get him to fire Miss Heard, right?
I had vetted Miss Heard. I had vetted Miss Heard.
Mr. Depp, you got your chance
Warner
to speak
Brothers
this morning. Your Honor,
Warner Brothers had two franchises.
Mr. Depp, if you could just answer the question, sir. Next question.
You reached out to Greg Silverstein to get him to try to get Amber fired from Aquaman, didn't you?
Asked and answered.
Excuse me?
Asked and answered.
It's a yes or no question that he hasn't answered, yes or no.
All right.
Yes or no, sir? You reached out to Greg Silverstein to try to get Amber fired from Aquaman.
Second half of your question is wrong, sir.
You reached out
to
Sue
them
Kroll
because I vetted her.
No, Mr. Depp. You reached out to Sue Kroll to get her to try to get her to help you get Amber fired from Aquaman, didn't you?
No.
And you reached out to Kevin Sujihara to try to get him to help you get Amber fired from Aquaman, didn't you?
No.
Can you pull up Exhibit 857, please? Mr. Depp, this is a text message that you sent to Christian Carino on August 15th, 2016, correct?
This is already in evidence, correct? Or is it 857?
Parts
No.
of it are.
Oh, so not this.
Not this version.
Well, this can't be 857, then don't.
850. Sorry.
Mr. Ronberg, you can't do this to me.
I'm sorry, Your Honor. Understood. We'll call it 857A.
857A. All right. Yes, sir. Thank you.
My apologies, Your Honor. Mr. Depp, you sent this text to Christian Carino on August 15th?
I most certainly did.
Okay. And in this text that you sent to Christian, Christian Carino is the person who used to be Amber's agent and then was your agent for a time, correct?
That is correct.
And in this text, Your Honor, permission to publish, please.
Do you want to put in evidence first?
Move for admission of 857A.
Any objection?
No objection.
All right, 857A, as redacted, will be in evidence.
Thank you, Your Honor. And in this text, Mr. Depp, you said, she's begging for total global humiliation. She's going to get it. I'm going to need your texts about San Francisco, brother. This gold-digging, low-level, dime a dozen, mushy, pointless, dangling, overused, flappy. I can only hope that karma kicks in and takes the gift of breath from her. Sorry, man, but now I will stop at nothing. Let's see if Mollusk has a pair. Come see me face to face. I'll show him things he's never seen before. Did I read that right?
You did.
Now, not long after this, you can take that down, Michelle, thank you. Not long after this, you met Mr. Waldman in the late summer or fall of 2016, correct?
I believe, yeah, September, October, somewhere in there, whatever.
And he's been your attorney since then, correct?
Yes, sir.
And you met with him with the Daily Mail in London in February 2020, didn't you?
I'm sorry, again?
You and Mr. Waldman together met with the Daily Mail in London in February 2020, didn't you?
Are you asking me a question about my attorney and I?
Yeah, that you two met with people from the Daily Mail in London in February 2020.
Was that during the London trial?
No.
No?
No, in February.
I don't recall it, though.
Okay.
I don't.
To the extent Mr. Waldman testified that you did, you don't dispute that, correct?
I just don't recall it.
Okay. You don't disagree with Mr. Waldman's testimony that you and he met with people from the Daily Mail in London in February 2020, correct?
If that's Mr. Waldman's testimony, then...
Okay.
But I just didn't necessarily know who these people were.
Right. The same month that the Daily Mail released alleged tapes between you and Amber.
Objection
Correct?
calls for speculation. Lack of personal knowledge.
Alleged
I'll sustain.
And we just heard explosive text messages read by the attorney coming from Johnny Depp. Will this hurt his case? What does the jury think? Tell us what you think. We're going to hit the pause button. When we come back, we will continue showing you this testimony from court in Virginia.
5.
Taking you right back to court where we left off. Now, if you can't hear everything that's being said, it's because these explicit texts have a number of words that we cannot play. Let's go back to court.
Now, Mr. Depp, you testified, and I wrote it down before lunch. You said, when Ms. Myers asked you something about, how does it feel to make you, or how does it feel to be here? You said, I've been living with it for 6 years and waiting to be able to get the truth out. Remember saying that?
Yes.
You also said, I've spoken up for what I've been carrying on my back. Something to that effect. You remember saying that?
Yes.
And you've claimed several times in this proceeding, Mr. Depp, that this trial is your first chance to tell your story, haven't you?
Yes, sir.
But that's just not true, is it, Mr. Depp? That is not true.
No, for me it is true.
Okay, well, here's the thing. The fact is, Mr. Depp, when Dan Wooten wrote an article that was published in The Sun calling you a wife beater, you brought a lawsuit against The Sun in June of 2018, correct?
Yes, I brought
And that was 6 months before Ms. Heard ever wrote her op-ed, correct?
I don't know.
And in the summer of 2020, there was a several-week trial in London against The Sun, correct?
Ms. Heard was not a party to that trial, was she?
Not my question, Mr. Depp. In the article that The Sun wrote that you sued over, you sued for Mr. Wooten calling you a wife beater, correct?
Objection asked and answered.
Sustained. Next question.
And in the trial that you subsequently brought, you called a lot of witnesses, right?
I don't know what a lot is. I don't know.
Many people testified on both sides of the trial, correct?
Yes, many people.
And many exhibits were introduced, correct?
Like a trial, yes.
Yep. And you, just like in this trial, you were on the stand for several days in that trial, correct?
Yes, sir, I was.
And that trial involved the same factual issues that you are litigating here, which is whether you committed domestic abuse against Amber Heard.
Sustain the objection. Next question.
You brought that case against The Sun because you were angry at The Sun for calling you a wife beater, correct?
Yeah, that's probably a pretty good reason.
And you went through that trial in London, correct?
I did indeed, yes.
Mr. Depp, you've already had a chance to tell your story, haven't you?
No, there were great limitations in the UK trial.
Okay.
No further questions.
All right. Redirect. Thank you.
Mr. Depp, Mr. Ronborn asked you some questions about the UK trial. Why do you feel that this is the first time that you've actually had an opportunity to tell your story and, as you said, get the load off your back?
As the UK trial was me suing Dan Wooten and The Sun for defamation for calling me a wife beater. The UK have there are different laws, there are different ways they handle things. There are also limitations in evidence. Some things can be brought up, some things cannot be brought up. Mr. Ronborn.
He's talking about limitations in evidence in English.
Your Honor, he's talking about his experience testifying.
Overruled.
You'll be okay. Yes, there is a very everything is quite boxed in with regard to what can be said, what can be spoken about. So Ms. Heard provided information to the Sun as their star witness, but the case was not brought against Ms. Heard. It was brought against the Sun newspaper, journal, whatever it is.
Mr. Rottenborn referenced that you were on the stand for multiple days.
4.5, I believe, yes.
Yeah. What was the nature of that examination? Or, excuse me, who was conducting that examination of you?
QC Sasha Watts,
And whose attorney was that?
the Sun's.
Can we please pull up DX 857A?
All right, it's already in evidence, so you can publish it.
Mr. Depp, do you recall seeing this text message when Mr. Rottenborn was questioning you?
Oh, yes, I do.
Can you explain what you're conveying to Mr. Carino in this text message?
I'm in total shock that this is happening to me, that my entire life on the planet has been brought to the head of a pin with all this completely, utterly false information. So I am, when you're accused of horrific acts and things that you have not done, when it's actually some very ugly things that are going out there into the world about you on a non-stop basis by Ms. Heard and her team, you have a tendency as humans to get very, very irate and angry, not to the point where you go out and hurt someone, not to the point even where you assault a cabinet. But you do get irate. You do wonder why this person is doing this to me. So yeah, many things go through your head.
Redirect of Johnny Depp, is he resurrecting himself? Do the jury believe him? We're going to let you take a break right now. When we come back, you won't miss any of his testimony. Stay with us.
Get the education you deserve, the skills you need, and the confidence to achieve your goals. Enroll today. Call or visit us online.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Good afternoon to you. We are in day 22 of testimony in the dueling defamation cases of Johnny Depp and Amber Heard, possibly the final day of Depp's rebuttal case. Both sides are suing for millions, each claiming that the former spouse ruined the other's Hollywood career with allegations of domestic abuse. Johnny Depp is finishing up his time on the stand under redirect. Today, he has sparred with Amber's team over her version of the liquor bottle assault in Australia, some explicit text messages, among other things. Right now, we're going to get you back into the courtroom. You haven't missed any of the testimony. Again, redirect. That means that Johnny Depp's team asking him questions on the stand.
And then you've got your family, you've got your kids. You've got your parent. My mom, thankfully, didn't get to read any of this because that would have killed her. But my father, my family, everyone that I've met, the people that have supported me, suddenly I'm scum. Why? Never had to happen. One little lie. So yes. Very angry.
Could we please pull up Defendant's Exhibit 821? Mr. Depp, do you recall seeing this text message when Mr. Rottenborn was asking you questions?
Yes, he loves this one, yes.
Yes. Would you care to explain what you're trying to convey in this text message?
Well, Warner Brothers was about to find themselves in quite a dilemma as the person that they had just cast.
Objection, Your Honor. Lack of foundation as to what Warner Brothers knew or thought.
Didn't I meet with them?
All right. If you could just wait for the question. I'll sustain the objection. Next question.
Mr. Depp, without explaining what Warner Brothers felt, why did you send this text message to your sister? And what were, excuse me, strike that. What were you trying to convey to your sister when you sent this text message?
Honestly, I felt responsibility for having gone to those people and you know, painted such a beautiful picture.
Objection. Hearsay, Your Honor. Now he's talking about what he said to Warner Brothers.
Overruled.
Please continue.
You change seats.
So, sorry, you can please continue.
I felt it was my responsibility to get the truth to Warner Brothers about what they were going to end up facing down the line, which is 2 franchises that would be causing problems for one another, especially as any news, any press, any media that came out about me at that time had been turned into, you know, I was Charles Manson, you know, I was the worst thing on earth, and they just kept coming. It was like a nonstop fire. So my responsibility, after having painted a beautiful picture of her for them, was to tell them, I think you better.
Objection, Your Honor. He's getting into what he claims he told Warner Brothers or wanted to.
He's saying what he wanted to tell them. He's not saying what he actually told them.
I'll sustain the objection. Next question.
Mr. Depp, you mentioned 2 franchise films with Warner Brothers. What 2 franchise films are you referring to?
There was Aquaman and Fantastic Beasts, the one that I was in.
And why did you feel a responsibility with respect to those 2 franchise films?
Warner Brothers was starting to get quite upset about some of the things that were being said about me in the press that were constant hit pieces. You know, on one level, yes, it's just acting, it's just movies, but it's business and it's your word. And I had given my word to them, and I felt responsible that I had to tell them exactly what was going on, and that it was going to end up ugly.
And which of those two film franchises were you a part of?
I'm sorry?
Which of those two film franchises were you a part of?
I was in Fantastic Beasts and Where to Find Them, and I was in the Fantastic Beasts: The Crimes of Grindelwald.
Could we please pull up DX 883? Now, Mr. Depp, do you recall seeing these text messages during Mr. Ronborn's examination?
Oh, God, yeah. Yes, I remember.
And you didn't seem to recall these text messages, is that fair?
It truly is fair. It's not, I'm not.
Do you have any?
Knows. I don't know who Molly is. I don't know nothing about these.
Do you have any understanding of what you're referring to in this text message? Or these two text messages?
No. I honestly, if somebody else had borrowed my phone or something and made this text to Stephen, possibly. But I don't understand the. I don't have that kind of. I don't write like I don't have that kind of hubris or expectation. That's quite grotesque text.
Can we take that down, please? Can we please pull up Defendant's Exhibit 1821? Mr. Depp, do you recognize this document?
That is behind the bar, yes.
Okay. And do you see Mr. Ronborn asked you some questions about whether there was a telephone in
now
Australia.
I see a telephone there now.
Yes. And did you recall that telephone being there?
I don't recall the telephone being there, but I can see it now.
Can we please pull up Defendant's Exhibit 1820? Do you recall me showing you this text message earlier on? Or excuse me, do you recall me showing you this picture during your examination?
Yes, yeah.
Okay. And I think I asked you whether you recall a phone being mounted on the wall in the left of this picture. Do you remember that?
Yes.
And what was your answer to that?
No.
Mr. Depp, Mr. Ronborn asked you some questions about your honeymoon. Do you remember that?
Yes.
And I believe you had testified that you and Miss Heard were on the Orient Express together.
That's correct, yes.
Where had you been prior to being on the Orient Express?
We had been in Australia. And then made it over to Thailand to catch the Orient Express.
Okay. If we could bring up the Plaintiff's Exhibit 162 again. Mr. Depp, do you know who took this picture?
Malcolm Connolly.
And despite what Mr. Rottenborn showed you about the picture of you prior to this, do you see a bruise on your face in this picture?
I see like what looks like a pretty decent shiner and a kind of a scratched up nose, yes.
And do you recall how you got the scratches and the shiner?
There was a very brief freak out that Miss Heard had in our cabin just before this dinner. I can't remember why, but there were many. I remember taking the photograph, though. I mean, I remember being there. I remember meeting the chef and all that. But I mean, the quality of the photo is not great. The quality of the other photo that he showed us has been prettied up.
Mr. Depp, did you ever physically abuse Miss Heard during your relationship?
Never. Never.
No further questions.
All right, sir, you can have a seat next to your attorneys. Thank you.
Thank you very much. Thank you.
Your next witness.
That call for again, Tremaine.
Didn't quite get that, I'm sorry.
Johnny Depp's testimony is concluded. That was redirect. Let me welcome now in St. Louis, Missouri, trial attorney Alicia Dern. Alicia, tell me about redirect. We know that they were giving him the opportunity to put his testimony, the explosive texts, the pictures, everything from cross-examination in context. Do you think that Johnny Depp effectively did that?
I actually do think he was effective in some of his responses, particularly when he talked about his anger in a calm manner, but in a human manner. I often tell clients when they're on the stand that they don't want to back away from their emotions without overacting, without being dramatic. The jury understands that people can react to things and have feelings about things, and his ability to express that was useful in minimizing some of the damage of some of those exhibits.
And let me just ask you briefly, I know we need to take a break, but those exhibits, cross-examination, do you think that that cross-examination, which was fairly aggressive, was successful in affecting the credibility of Johnny Depp?
If maybe for some of the jurors who are still on the fence, I think that by now we've been weeks into testimony. The jurors probably have a fairly good idea of who they believe and who they don't believe. And an aggressive attorney in cross-examination can sometimes be useful, but sometimes it just looks like the attorneys are being jerks. And I think to some degree, the aggression and the objecting might actually have backfired.
And I did ask the public for any social media responses, and I just have to tell you, I've been looking at those and can tell you that many felt that Rottenborn, who was the one doing the cross-examination, was too aggressive and rude with Johnny Depp, and they didn't like the way he treated Johnny Depp. Is the jury going to find the same? We don't know. We'll have to keep watching. When we come back, continuing testimony in this case in Virginia. Also, we will be bringing you breaking news. The verdict is in Oregon versus Nancy Brophy, accused of shooting her husband. What is that verdict? We're going to bring you that on the other side.
Download RoboKiller today.
Have never in my life committed sexual battery, physical abuse, all these outlandish, outrageous stories of me committing these things and living with it for 6 years and waiting to be able to bring the truth out.
Johnny Depp testifying earlier today. We're going to get you back to the Depp trial in just a moment. But first, breaking news in another trial that we are following here on Court TV. An Oregon jury has reached a verdict in the romance novelist murder trial of Nancy Brophy. You may recall she's accused of killing her husband Dan after writing a blog post called, wait for it, How to Murder Your Husband. Here's the verdict.
All right, if we can have Mrs. Brophy rise. It says, we, the jury, duly impaneled and sworn in the above entitled cause, do find our verdicts upon the counts submitted to us as follows. Count 1, murder in the second degree, guilty. And then with regards to the 2 questions, the state alleging that during the commission of this felony, the defendant caused or threatened the use of a firearm, the answer is yes. And then the state further alleges that during the commission of this felony, the defendant and the victim were married, the answer is yes. Now, I will ask juror number 46, it indicates your number in the signature block, and that is you who put your number there? All right, and then by a show of hands, I'm going to ask everyone first whether the verdict of guilty is their verdict on count 1. Raise your hand if it is. All right, and then with regard to the question of caused or threatened the use of a firearm, if your answer is yes, raise your hand. And then lastly, if during the commission of the felony, the defendant and victim were married and your answer is yes, raise your hand. All right. Does either side have anything for the record?
No, Your Honor.
No, Your Honor.
All right. The jury will be excused. We thank you for your time.
Watching Nancy Brophy as the verdict was read, you could see it appeared as if she really started to breathe a lot heavier as she heard from the judge, guilty of second-degree murder. That is what the jury found. She'll be sentenced on Monday, June 13th. And of course, for more on her case, go to courttv.com. Now we want to take you back to the Johnny Depp case against Amber Heard and a countersuit by Amber Heard against Johnny Depp in Fairfax, Virginia. On the stand now, Malcolm Tremaine, former TMZ employee. You haven't missed anything. Let's go back to court.
Do you solemnly swear or affirm to testify truthfully in this case in the penalty of law? Is it?
Yes, ma'am.
Good afternoon, Mr. Tremaine.
Hello.
Would you please state your full name for the record?
Morgan Cliff Tremaine.
And what do you do for a living?
I produce esports events and design video games.
And in 2016, what did you do for a living?
I worked as the field assignment manager at TMZ.
What is TMZ?
TMZ is an entertainment news website and television show.
And what were your responsibilities as a field assignment manager for TMZ?
I was the go-between the news desk in the office and the reporters in the field, which you might know as paparazzi.
Approximately how many paparazzis were you in charge of?
At the time, it was about 20 in LA, a handful, maybe 3 in New York, and then 1 in DC.
And what were your responsibilities specifically as to the paparazzi?
It would be to dispatch paparazzi to various locations based on tips or just direction dictated by having a list of sort of hot spots where celebrities would be.
And how were those tips received?
They were received either through tips that we received through our tip line or directly through news producers in the office.
And were tips frequently received directly from sources?
Very often the case, yeah.
And who were the type of sources that TMC received tips from?
They would receive tips from, oftentimes it would be publicists, managers, agents, or B-list celebrities.
Lawyers?
And lawyers, definitely.
How are tips verified?
Tips are verified by an extensive process. If they come in through our tip line, we have to verify who sent it, that the source is truthful, and so they have to add their contact information, which is a field in that on that website for like name, phone number, things like that.
And how long did that process typically take?
If we receive a tip through the tip line, it could take a while because that would need to be, if it was a tip, we would need to verify it. If it was media, such as photos or videos, that would need to be extensively verified to ensure that the person sending it is the copyright holder and that we would have the legal ability to air it and distribute it.
And while working for TMZ, were you involved in any assignments related to Ms. Heard?
I was.
What was the first time you recall working on an assignment related to Ms. Heard?
I believe it was May 27th, 2016.
And what was your role in that assignment?
For that, Ms. Heard was filing a restraining order at a courthouse in downtown Los Angeles. So I dispatched camera people to that location.
Under what circumstances would you normally send paparazzi to a courthouse?
Only if we had been informed prior. It's not by any means a celebrity hotspot. We would only ever send people there if we had been tipped off that something was occurring and there was somebody present there.
And what footage was TMZ trying to capture at the LA courthouse on May 27th, 2016?
We were trying to capture Amber leaving the courthouse and an alleged bruise on the right side of her face.
What was your team of paparazzi supposed to do while they were at the LA courthouse on May 27th, 2016?
Objection, Your Honor. Hearsay and foundation.
What were they supposed to do?
Right. She's asking for, I don't think there's a foundation or hearsay.
I'll overrule the objection at this point. I'll say.
Go ahead, Mr. Tremaine.
Can you state the question again?
What was your team of paparazzi supposed to do while they were at the Los Angeles courthouse on May 27th, 2016?
Their objective was to capture her leaving the courthouse, and then she was going to sort of stop and turn towards the camera to display the bruise on the right side of her face, the alleged bruise.
Did your team of videographers get the shot of Amber Heard?
We did.
What is the difference between receiving a tip from a news producer and any other source?
If it's any other source, it would have to be verified by copyright. If it was anything that was received directly through a news producer, then they go through that process to verify the source.
Did you do anything to...
Malcolm Tremaine testifying about a tip they received and showing up at the courthouse after Amber Heard filed that temporary restraining order to take a picture. We're going to pause it there so we can hear what else he has to say about that day in question. We'll be right back on the other side.
Did Mr. Depp push you in any way down the stairs?
No.
During the course of your relationship, did he ever push you down any stairs?
No, he never pushed me, kicked me, or threw me down any stairs.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Good afternoon. My honor to be with you. We want to take you back into the dual defamation trial in Fairfax, Virginia. On the stand now is a TMZ ex-employee, Malcolm Tremaine, and he is testifying as to the time that Amber Heard went to the courthouse to file a temporary restraining order against Johnny Depp, May 27th of 2016. So far, he has said that TMZ received a tip and they were going to take pictures of her as she exited the courthouse, and specifically to see an alleged bruise on the right side of her face. You've not missed any of the testimony. Let's pick up at that point.
May 7th, 2016, related to Amber Heard?
I did not.
Why not?
Because it had come directly from a news producer.
Does that mean it had been verified?
It means that they had verified that tip and deemed that it was credible, and therefore a camera person needed to be dispatched.
After May 27th, 2016, were you involved in any other assignments related to Amber Heard?
Yes.
Can you tell me about those assignments?
The next one would have been August 6th, 2016, where she was giving a deposition.
So what did you do in relation to that tip?
I dispatched camera people to a parking lot adjacent to a law office in which she would be arriving to, so we could get the footage of her arriving for the deposition.
Do you typically send paparazzis to parking lots of law offices?
No, not at all.
Did you get the shot of Miss Heard on August 6, 2016?
We did.
After August 6, 2016, were you involved in any other stories involving Miss Heard?
Yes, I was.
And what story was that?
On the 12th, we received a video depicting Johnny Depp slamming some cabinets that was captured by Ms. Heard.
And what day was that?
I believe that was the August 12th.
Of 2016?
Of 2016, yes.
Can you describe to the jury how you received the video on August 12, 2016?
Yes, the video was sent in through our email tip line, which is an email distribution that goes to all the producers and to myself as the field assignment manager, because it often included celebrity locations. It came in as I recall,
Objection, hearsay.
He's just describing how it came in.
I think he's about to reveal hearsay, Your Honor.
I'll overrule for now. We'll see where it goes. Okay.
Please continue.
So I received that email, and it included a link from some unknown Dropbox type public website in which it contained that
Objection,
video.
Your Honor, hearsay. He's about to describe what comes from the Dropbox website, and that's...
So far, he just said he's was a link from a Dropbox. We'll see the next question. Go ahead, next question.
So you received a link. What was in that link?
In that link was the video of Johnny Depp smashing the cabinets.
Okay. And you received this video in your inbox, correct?
I did.
Okay. What did you do once you received that video?
We downloaded it. We alerted the web editor who was sitting next to me at the time. We downloaded it, and then were instructed by the news producer to do what we call slap bumpers and a bug on it, which is putting the dun 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 at the beginning end, and then putting a translucent watermark over it, which indicates copyright ownership.
Okay. After you did that, was it posted?
It was posted, yes.
Where was it posted?
It was posted to tmz.com.
Did you do anything else related to Amber Heard on August 12, 2016?
Yes, I received a tip that Amber Heard would be arriving at LAX, and so I dispatched camera people to film that exit, or her arrival to LAX, rather.
And why did you do that?
I was instructed to.
How long does it take to post a story after media's been received by TMZ?
After media's been received, it could take any length of time depending on who owns the copyright.
How does TMZ obtain copyright over images and videos?
The only way to obtain copyright over media would be if we shot it ourselves, if it was sent to the tip line, source verified that it was from the original copyright owner, and then either purchased from that person or given to us. And then the third option would be if it was directly given to us by the copyright holder, like a direct source.
And how long does it take to copyright something TMZ has received through the tip line?
It can take a while because you have to extensively verify that that person owns the copyright. And then possibly, it depends also if you can even get in contact with the person because they might not be super responsive immediately via phone or email that they provided. And then potentially you'd have to enter a negotiation with our clips and clearances department to figure out the cost of that media.
How long does it take for TMZ to obtain a copyright over something received directly from a source?
Something in the realm of 15 minutes just to do what I described before, which is putting bumpers and a bug on something and write the article and post it. It's pretty fast.
How much time had passed from the time you received the kitchen cabinet video to the time it was posted on TMZ?
About 15 minutes.
Did any other tabloids other than TMZ post this video?
Objection,
No,
leading and cause for hearsay.
Did any other tabloids?
Overrule.
Mr. Tremaine, go ahead.
No, they did not.
And why not?
Because it was a TMZ exclusive.
And what does that mean?
It means the TMZ owns the copyright to it. So it can't be distributed by any other media source without backlinking to TMZ, and they wouldn't be able to upload that media without getting a copyright strike.
Have you seen the kitchen cabinet video that was played in this trial?
I have, yes.
How does that video that was played in this trial compare to the one you received on August 12, 2016?
When I had clicked the direct link that we received and watched the video in its entirety, it was much shorter than the video we had received, than the video that's been played in this trial. There was a bit at the beginning that was played here in which Ms. Heard is seemingly sort of setting up the camera and getting into position. And then there's a bit at the end where she's seemingly sniggering and looks at the camera. That part was not present in what we received.
Did TMZ edit the video?
No, not even a little. When we receive something and it's edited, there's a clear indicator because there's sort of a journalistic practice they use is when there's an edit, you do what's called like a white flash transition, which covers the entire screen with white to very clearly indicate to everybody there was an edit here for time or whatever, just to make it a little more compelling. But in this case, it was not edited as I was staring at the machine that edited it and present for the entirety of receipt to publishing.
When was the next time you worked on an assignment related to Amber Heard?
It was, well, there was the time where we went to the airport. And then the day after that, because she had flown in for the deposition, because I think the first time didn't work out. So she was arriving again for the deposition in that same parking lot adjacent to a law office.
And what's that, August 13th, 2016?
That was August 13th, yeah.
And what was your assignment on August 13th, 2016?
To dispatch camera people to that parking lot at a specific time in order to film Amber Heard arriving for the deposition.
How did you know that tip was legitimate?
It came from a news producer.
While you worked at TMZ, did you ever receive any communications from Mr. Depp or his camp?
I did not.
Nothing further, Your Honor.
Cross-examination?
Yes. So
I think the significance of this testimony, we just heard on direct examination, and I want to correct first because we had understood a different name. The first name of this gentleman is Morgan Tremaine, so apologies for that. But Morgan Tremaine testifying that the video that TMZ received that was an exclusive that they did not edit, did not have a piece of the Amber Heard looking at the camera and kind of snickering that was in the same video shown during the course of this trial. What will the attorneys for Amber Heard do on cross-examination? You're going to see that next. We're going to hit the pause button. When we come back, we'll get you back into court. limited time offer. Back to Fairfax, Virginia. On the stand, TMZ ex-employee Morgan Tremaine on cross-examination.
How do you know what video was shown at this trial?
I was alerted by a friend that that TMZ was being kind of talked about in this trial, and so I had seen a clip of that.
Okay, so you watched some of this trial?
Correct.
Okay. When did you first reach out to counsel for Mr. Depp?
I believe that was 6 days ago, whatever that date would be. I'd have to do that.
All right. And then you received a subpoena, I think yesterday, in care of your attorney, Cindy Hickox, right?
Correct.
Okay. And Cindy Hickox represents Christy Dombrowski, Kate James, Robin Baum,
Objection,
and
Your
Debbie
Honor.
Lloyd. Were you aware
Calls
of
for
that?
speculation.
Overruled.
Were you aware of that?
No.
Now, if you don't have information that's helpful to this case, then you wouldn't be a witness, correct?
Objection. Calls for speculation.
Sustained. Sustained. Next question.
I'm not aware.
Okay, you know this case is being televised, right?
I am aware that there are cameras.
And so this gets you your 15 minutes of fame, doesn't
Objection, Your Honor. Argumentative.
I can ask that question.
Overruled.
So I stand to gain nothing from this. I'm actually putting myself kind of in a target of TMZ, a very litigious organization, and I'm not seeking any 15 minutes here. Though you're welcome to speculate. I could say the same thing by taking Amber Heard as a client for you.
A little argumentative, don't you think?
Oh, hardly. I find that to be purely logical. Thank you.
Now, are you aware that Mr. Depp's attorneys were well aware of the TRO that was going to be presented on May 27th?
Objection. Calls for speculation.
Were you aware of that?
Lack of foundation.
Overruled if you can answer it.
Can you restate the question?
Were you aware that Mr. Depp's divorce attorneys were aware that Amber Heard was going in to seek a TRO on May 27th?
I don't think I understand the question, but I don't think so, no.
Okay.
It's kind of a complicated question.
Whether Blair Burke, one of Mr. Depp's divorce attorneys, had a very close relationship with TMZ at that time?
Objection. Calls for speculation.
Overruled. If he knows.
I was not aware of that.
Okay. And when you said that you were dispatched twice, once to film Amber in a parking lot for the deposition, and then it didn't work out, and so you had to do it another time, how did you know it didn't work out?
Because TMZ.com posted an article saying as much.
Okay.
And I was not dispatched.
Do you know
I worked in the office.
why the deposition did not work out?
I'd have to reference the article, I forget.
So do you know?
I didn't write that story. I wasn't involved in the actual
Do you know
journalism of that.
which side? Do you know which side would have known or not known whether that deposition was going to work out? In other words, the people representing Mr. Depp or the people representing Ms. Heard?
I wouldn't know.
Okay. And then the video clip. You don't know who provided that, correct?
Correct.
Okay.
Not testifying to that.
I have no further.
All right. Redirect.
Mr. Tremaine, why did you contact me in relation to this case?
I saw that there was a discrepancy with the video that was shown here and the video that I know I had received. So I had no interest in testifying. I had reached out simply to maybe try to help with the timeline of things or help with the case in any way, just by virtue of understanding the timeline of the stories that were published and kind of how that can be unclear. But I had no idea I'd be on the stand.
Okay, nothing further. Thank you.
All right, sir, you're free to go. Thank you. All right. You have another witness? Okay.
Mr. Depp calls Brian Neumeister, Your Honor.
All right.
And that rebuttal witness is done testifying. A perfect opportunity to bring in, still with us, trial attorney Alicia Dern. All right, Alicia, first of all, did you note that witness's retort to Elaine Bredehoft and said, you could be looking for your 15 minutes of fame in representing Amber Heard. How do you think that came across to the jury and the testimony of this witness?
I actually liked the retort by the witness, and also when he was saying that TMZ was litigious and he was doing this at his own peril. I think the cross was utterly a failure in showing any kind of bias or memory issues or anything that would sort of take the sting out of this testimony, and that attacking a third party that had nothing to gain from testifying today in that manner actually just made the defense look weak.
Let's get down to the nuts and bolts of why you think this was presented by Johnny Depp's team on Rebuttal, because he admitted the video received by TMZ of Johnny Depp breaking the cabinets he doesn't know where it came from. The only thing he did say is that the video TMZ received did not have a little bit of what Amber Heard was looking in the camera and appeared to be snickering that was in the video presented in this trial. So what are they trying to show by introducing that kind of evidence, in your opinion?
Well, the video was edited to omit anything that might make Amber Heard look bad or look like she enjoys drama or like she was not very afraid of Johnny Depp. And who would have the interest in doing that? I mean, you don't have to know who submitted the video to understand that the editing benefited Amber Heard, and that tends to create some credibility for the plaintiffs, for Johnny Depp's theory that she was looking to paint him in a negative light and that she was intentionally presenting a biased story in order to hurt him.
And of course, we always want to consider the body language. Do you have any thoughts about Amber Heard and her reaction first to Johnny Depp's testimony and now to this witness's testimony?
Well, she seemed to be scribbling furiously quite often and writing things over to her lawyer. I'm not sure that tells us anything other than she didn't really want to look at the witnesses, and maybe she felt uncomfortable by their testimony.
All right, let's go back into court for the next witness.
Do you solemnly swear or affirm to testify truthfully in this case on penalty of law?
Yes, ma'am.
Good afternoon, Mr. Neumeister.
Good afternoon.
Could you please state your full name for the record?
It's Norbert, N-O-R-B-E-R-T, Brian, I go by Brian, B-R-Y-A-N, Neumeister, N-E-U-M-E-I-S-T-E-R.
Could you start by describing your educational background, please?
My educational background, well, I graduated from Cal State University Northridge 42 years ago with a degree in political science. From then on, I've been working professionally in photography, totally unrelated, for the past 42 years. And that would also include videography, audio, and a few other different binary-related tasks.
Where do you currently work?
I own USA Forensic.
What is USA Forensic?
USA Forensic is a digital forensics company. We are boutique. We're very small. We work. We have offices in Grosse Pointe Farms, Michigan, and in Phoenix, Arizona. We work with varying types of clients because to us, data is data and it takes no side. So we can end up working for prosecution, defense, law enforcement, the Innocence Project. We have a contract with the Department of Defense. We do classified and unclassified work. We've done classified work with various agencies. We've worked with DOJ, and I've worked in 23 countries as a photographer.
What's your title at USA Forensic?
CEO.
Did you also found USA Forensic?
Originally, in around 1990, it was called Skymeister, and that is because of the amount of helicopter photography time I have. About 10 years ago, we changed it to USA Forensic while still doing a lot of the same tasks.
And you described, I think, some of the entities that you work with. What kind of work do you do for those entities that you mentioned?
We do audio forensics, which is clarifying audio, for example, sting operations or audio that may have been picked up on surveillance or any other type of recording, removing background sounds. Video clarification, we do a lot of work with Axon
Your Honor,
cameras.
I'm just going to check on relevance based on the discussion we had earlier. This experience has absolutely nothing to do with anything.
All right, do you have an objection to him being moved in as an expert in the field?
Well, she hasn't moved yet. I'm objecting to the relevance of the testimony on the subject matter right now.
I'll overrule the objection.
Thank you, Your Honor. Go ahead, Mr. Neumeister, you can continue.
Where I left off is we do a lot of work with Axon police cameras because they don't really handle low lux levels or low light levels very well. So we clean up, we are beta testers for a program called Input ACE, which is part of the Axon company used by police officers. We clarify their cameras to better see what happened at night, for example, in different scenes. We do the same with surveillance cameras, any kind of camera, cell phone cameras. We also do cell phone forensics, computer forensics, and cell tower forensics, along with photographic forensics.
What types of cases do you work on?
It can be anything from Fortune 500s to it can be anything from a pro per, which is a person that's actually just representing themselves in a smaller case, to a lot of homicide cases, defamation. It can be any kind of case that requires cell phone extractions or computer extractions. Could be money laundering, could be a Department of Defense identifying a voice, that type of thing.
We are approaching the top of the hour. We need to take a commercial break. I want to thank Attorney Alicia Dern for joining us today. We're going to take you back into court for continuing testimony here on Court TV, your front row seat to justice.
We call Mr. Depp.
What specifically had you actually told Miss Heard about the incident with Miss Moss and the stairs?
She slipped, her legs went up, and she landed directly on her lower back.
Have you ever consumed 8 to 10 MDMA pills at once?
I'm pretty sure I did. I've never in my life committed sexual battery. I'd never heard a rumor of that before Miss Heard grabbed hold of it.
Johnny Depp was back on the stand today in his defamation trial against Amber Heard, but was too testy under cross-examination. His rebuttal case could be done today. Depp's testimony follows that of another superstar, his former girlfriend, Kate Moss. What did Moss say about Amber Heard's claim that Depp pushed the supermodel down some stairs? And yet another big moment for Depp's team, recalling the psychologist, Dr. Shannon Curry. Will jurors believe her diagnosis, or will they choose to believe Amber Heard's doctor? We're going to go back to court in just a moment. Our legal experts are standing by to discuss when there are breaks and sidebars. All of that coming up next. Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Of course, my honor to be with you this afternoon. We are in day 22 of testimony in the dueling defamation cases of Johnny Depp and Amber Heard. Possibly today will be the final day of Depp's rebuttal case. Both sides are suing for millions, each claiming that the former spouse ruined the other's Hollywood career with allegations of domestic violence. Johnny Depp took the stand just after 11 a.m. Eastern time today, and over several hours, he addressed the Australia incident, some explicit text messages, and lots of contentious exchanges with Amber Heard's attorneys. Right now, we want to go back to court. There's a metadata expert on the stand. He had just started testifying when we needed to take a break. Internet expert Brian Niemeister. You haven't missed any of the testimony. Let's go back.
Basically anything with binary information.
Have you been retained as an expert before?
Oh, yes. I would say we average about 150 to 200 cases a year. In the last 4 years, we've done over 600 cases, and that would be in U.S. federal courts, U.S. district courts, various state courts throughout the United States. We just wrapped up a case that was an overseas case, wrapped up yesterday. We do U.S. military court. We have a case coming up in front of the U.S. Supreme Court. So it's really varied. I've done quite a few U.S. district court cases.
Have you testified as an expert in digital forensics before?
Yes. And what people sometimes don't understand is only about 2% of all cases go to trial. So 98% of the time, you're actually just doing the forensic work and giving it to the parties. And as we say, data is data. It really doesn't take a side. We don't have a narrative. So very often it's just providing the data for the attorneys to work with or the parties.
Have you ever been excluded from testifying as an expert regarding any work that you performed?
No, but you have to take into account that sometimes there might be curbs put on. For example, in this trial, there's certain boundaries. Or if you're working with a pro per or with an attorney that is not very familiar with electronics. And the thing is, again, they teach Latin in law school, not binary, and binary is the universal language these days. So sometimes in the legal system, it's a little bit hard to explain to attorneys what exactly we're doing, so we try to break it down and make that work.
What is digital forensics?
Digital forensics is anything that you are using, like your television set, your cell phone, your computer, anything that runs off of binary information that has coding in it.
How long have you worked in digital forensics?
Well, I actually started off in analog, so it's been 40 some odd years. I started off as a cameraman. My first cameras were film cameras. When I was a kid, my dad was a director of sales and sales service administration for the NBC television network on the West Coast. So I grew up around television cameras. My first cameras were cameras people might not have heard of, Leica, Hasselblad, cameras like that. I trained with some of the best photographers around at the time, William Wallner, Niall Latham, really excellent photographers. And I started shooting videotape from helicopters, and I logged about 14,700 hours of video. And at that time, oddly enough, since we were the only helicopter, a television helicopter, we were the only helicopter in Phoenix. At the time, the sheriff's department did not have a helicopter. The police department did not have a helicopter, nor did Aerovac. So we ended up doubling up, being a news crew as well as an air rescue crew. So as far as forensics, analog probably from 1980 to 1990, and digital from 1990 through current.
How'd you get started in it?
Really by osmosis. I started in the production field. I usually don't do that much TV work anymore. I did shoot part of an episode, a program called Planet Earth for the BBC last year. I don't normally do television anymore. It's just 99% forensics. But I got started because very often, as working in the helicopter, we'd be asked to work for a police department in a rescue or a chase or whatever the situation might be. And since I'd be videotaping it, they would ask me to break it down frame by frame and analyzing it using what's called a time-based corrector in the day. And so word got out that I could do unusual things because I'm pretty good with machines. And it just ended up, more and more people started calling, and it just became a full-time job.
Have you received any professional certifications in forensics?
Yes, but again, most hackers and people who do interesting work don't have any certifications, because the certification is usually like a week-long course. I've been doing this stuff 42 years. My partner, Matt Erickson, he's actually a
Objection, Your Honor, to the partner who's not testifying to these qualifications on relevance.
Sustained ejection.
Yep. Mr. Neumeister, can you just describe which professional certifications you have received?
For cell phones, Oxygen, which is a program similar to Celebrite. But these are programs that are used by law enforcement and by private parties to extract data from cell phones that has been deleted, or which is critical in a lot of cases, deleted data, or just to what we call image a cell phone. In other words, get every bit of data that's possible on a cell phone. And again, every cell phone is different. The next would be in cell tower forensics.
Are you a member of any professional associations in your field?
Yes, the IEEE, which is the International Engineering Society. And the reason I belong to that is about 40% of the world's white papers on electronics are published through IEEE. So they have a huge database on anything from microwave technology to telephone transmission technology. Anything that I might work with, they might have a white paper on it. Also, with the Audio Engineering Society, AES, I'm a member of that. I lecture to AES. There's a few others, but again, they're just mainly to have a repository of information.
Have you received any honors or awards?
Yes, I've received about 80 honors and awards. I have, for videography, I've got a total of 12 Emmy Award statues, but I've been the principal in 39 Emmy Awards, which means I've written the music for the program, and the program has won the Emmy Award for music, but it was given to the production company, which happens a lot. I won for best editing. I won for best ACE editing, which is computer editing. Best sound. I've done the music to a piece that won the Golden Lion at the Cannes Film Festival. I've done music to a piece that won the gold at the Calgary Film Festival. I've got a lot of awards from Associated Press and different companies from doing documentaries and news.
Have you published any works in the field of digital forensics?
Yes, and they're mostly articles, about a half dozen of them or so. We don't have much time, and I don't usually do it, but it was basically on most of my work deals around clarifying or authenticating. So it was basically the things I published were on clarification of digital files.
Have you appeared on TV as an expert in digital forensics?
Yes.
Where?
CBS, NBC, ABC, BBC, Discovery Channel, a number of different things.
Any particular examples of things that you've spoken on TV about?
Boston bombings, how the frame averaging was done on that, sort of things like that. Again, we get calls a lot, but I don't speak specifically about cases. I just speak about technology.
Have you given any public lectures in the field of digital forensics?
Yes, we get asked quite often, but due to our schedule, it's a little rough. We do what's called Inns of Court. We speak in front of private investigator groups. We do attorneys continuing legal education. Audio Engineering Society. We try to do a few a year, and that's about what our schedules will allow, given our time.
Your Honor, at this point, I'd like to tender Mr. Neumeister as an expert in the field of digital forensics.
Any objection?
No objection,
All
Your
right,
Honor.
so moved.
Mr. Neumeister, turning to the work you've done in this case, what have you done?
And this is now an expert in digital forensics, clarifying, authenticating digital. What are we going to hear from him? We're going to hit the button. You're not going to miss any of his testimony. We need to squeeze in a break. Stay with us here on Court TV Live.
Call or visit us online.
You know this case is being televised, right?
I am aware that there are cameras.
And so this gets you your 15 minutes of fame, doesn't
Objection, Your Honor. Argumentative.
I can ask that question.
Overruled.
So I stand to gain nothing from this. I'm actually putting myself kind of in a target of TMZ, a very litigious organization, and I'm not seeking any 15 minutes here. Though you're welcome to speculate. I could say the same thing by taking Amber Heard as a client for you.
A little argumentative, don't you think?
Oh, hardly. I find that to be purely logical.
That was testimony from just a few moments ago. That witness had the last word with the attorney for Amber Heard. Right now on the stand, we have another witness, Brian Nymeister. He's a metadata expert testifying about the authenticity of photos. And again, you are not missing any of the trial, any of the testimony. We pause and then we start back where we left off right before the break.
It's the photographs of purported injuries to Miss Heard.
And what was the purpose of that analysis?
To authenticate photos or to review and see if they were altered in any way.
What did you analyze to reach your opinions?
Well, I analyzed groups of photos that were submitted by Miss Heard's legal team.
What work did you do to analyze those photographs?
Well, normally you start off by looking at what's called the Exif data. The Exif data is the binary data that's encoded into a photograph. It tells you, for example, if the flash fired, what the operating software version was of the cell phone or camera that shot a photo, what type of lens was used, what the f-stop was. There's literally about 1,000 lines of code in the Exif data on a JPEG photo. So we would start with an Exif editor or an Exif viewer.
Anything else that you looked at?
Yes, when we're dealing with RGB cameras, which are red, green, and blue channel cameras, which would be a cell phone or a basic home camera. They're based on RGB channels. We would do four types of scopes. We would do a vector scope. We do a luminance scope. We do a waveform scope, and then what's called an RGB parade. And those scopes analyze different things. The vector scope analyzes where the different types of colors are headed in, for example, it's broken up into reds, magenta, different areas on a scope. We would take a look at that to see if there's anything out of the normal for the type of camera being used. In other words, would there be above a certain percentage of chroma? And chroma means color saturation.
Objection, Your Honor. Outside the scope, we can approach if
All right,
you'd like.
you want to approach?
They were approaching based on, this is an expert that can testify about the authenticity of photos, talking about the coloring of photos. Franz Borchardt is with me, criminal defense attorney from Louisiana. And I must say first, I had the privilege of being on iHeartRadio with Brian Haldane this morning, and he, Franz, mentioned you. So I'm so glad to have you on today. What are your thoughts about this particular expert? What do you expect to see?
Well, I would expect that he's going to testify that he found something unique or particular about the photos submitted by the Heard team with regard to possibly being altered or manipulated in some way. Otherwise, why else put him on the stand? And so far, he's a cute, cuddly expert witness. He's testified that, look, he just looks at the data and reports on it. He has a lot of experience, so he's oozing with credibility, Judge. And I think the jury's going to believe whatever he says.
I think so too. I'm wondering if it's specifically about the two photos used on cross-examination of Johnny Depp when he was testifying just a little bit earlier today in his rebuttal case. And counsel for Amber Heard showed two pictures, different lighting in each picture of him at a wedding to say, hey, or it wasn't at a wedding, it was on the honeymoon, I believe, and saying, listen, the lighting is different, but isn't it true that in fact you really didn't have a bruise under your left eye? Let's go back to court.
Mr. Neumeister, based on the analysis you performed in this case, have you formed any opinions?
Pardon?
Based on the analysis you've done in this case, have you formed any opinions?
Yes.
What are they?
Well, three basic ones. One is quite a number of the photos had been through a photo, at least one, possibly two.
Objection, Your Honor. Foundation, which photos is he referring to? We have to go through this one by one.
One's in evidence.
Mr. Neumeister, in terms of the photos that you looked at and that you formed opinions about, do you understand if they've been submitted as evidence in this case?
Yes.
Okay. And what conclusions have you formed about those?
Same objection, Your Honor. That doesn't cure the issue of the objection. We have to go through this. Which photos is she talking about? Which one's in evidence? What exhibit numbers? That's the basis of the objection.
We're talking generally about opinions right now, Your Honor, and we're going to get into some specifics.
I think we have to go straight to specifics.
Okay. Mr. Neumeister, have you prepared a demonstrative that aids in your testimony with respect to any of the photos that you looked at in this case?
Yes.
I'd like to pull up Plaintiff's 1303, Your Honor, if I might approach.
All right.
Your Honor, I would again object. We can approach to discuss
Okay,
it.
you want to approach?
All right, while they've approached, Franz, do you have an opinion as to why you think they're objecting or what the problem is with trying to get him to testify as to what he sees about these photos?
I think this is a series of objections to rattle the attorney, and it seems to be somewhat working. You could see her taking a elongated pause after the objection and after the judge instructed her to get to the specifics. I think she's a little rattled, but I think she's going to rebound from it. I think what we're really getting to is Heard's attorneys are trying to pinpoint specifics. And I think it's just an inevitability, Judge. I think we're going to see that happen. I just think this is an example of a I'm going to rattle you a little bit objection.
All right, back to court.
Can we pull up Defendant's Exhibit 170A, which has been admitted into evidence? Mr. Neumeister, does this photo appear to be one that you have analyzed as part of your analysis in this case?
There were many versions of this photo. I would say there were dozens of different versions with different chromatic values, different file sizes, different physical sizes. Some had been through Photos 1 or Photos 3, which are photo editing software programs.
Okay. Your Honor, at this time, I'd like to show Mr. Neumeister's demonstrative, Plaintiff's Exhibit 1303.
All right. Any other objection?
I would object again, Your Honor, because the photograph in 170A is not in evidence.
All right.
Or, yeah, I mean, the photograph is in evidence. None of the photographs he wishes to show the jury are in evidence.
1303 is in evidence over objection. Not in evidence, I'm sorry, as a demonstrative.
Just as a demonstrative.
I'm sorry.
Could we go to
Published in
1303, please? And Mr. Neumeister, what does this demonstrative show about the photos that you analyzed?
Well, they appear to be similar. However, if you look below at the file sizes, one on the left is 712 kilobytes. The one in the middle is 489 kilobytes. And the one on the right is 524 kilobytes. Now, what's unusual about that is these photos will not digitally fingerprint with each other. They won't hash. In other words, forensically, they don't match. But the thing is, you could say, well, it was sent through email, maybe it's a different size. The file sizes, for example, would be possibly, you can select the file size, you send a photo, but there's no way to authenticate any photo that was presented in the way the evidence was collected.
And so what conclusions do you draw from that?
Well, this is just three of many of the same type of photos that are all different sizes and have different chromatic, which means color.
Objection, Your Honor. We just had a ruling on this.
All right. Sustain objection.
Mr. Neumeister, stick to your opinions that relate specifically to what you analyzed about the Exif data, please.
All three of these photos had to go through some type of transformation to change sizes.
We can take that one down. You mentioned Photos 1.5 and Photos 3.0 earlier, I believe.
Photos.
What is that?
Photos 3 and Photos 1.5 are editing programs that Macintosh or Apple put out with their product. It's for editing photos. In other words, you would put a photo in and you would change the colors, or you would crop it, or you would clarify it by enhancing, for example, the sharpening, or you could darken it. But when you save a photo through an editing program, you leave a mark on the Exif data.
And what is the Exif data?
The Exif data is the data that is embedded in a photograph that tells you a lot about the photograph. And again, in the early days when we were using film cameras, you would write down the f-stop, which is the light setting. You would write the type of lens you use, the time of day, the type of film stock, the type of filters you're using. Now with digital cameras, that's done electronically, and there's about 1,000 lines of code, of which 50 are probably important, that tell you what the camera was doing.
So what's the significance of Exif data in your photo analysis?
Well, in this situation, I can see that normally where the operating system of the camera would be, which means the version that of operating system the phone is running on, it would normally say something like, I'll just throw out an arbitrary number, 9.1.3 operating system for iOS, which is Apple's iPhone operating system. Instead of saying that, it says software Photos 3.0 or Photos 1.0. That means that the photo had to be rendered, which means composited together in an editing program.
Did you prepare a demonstrative that shows some of your analysis of some of the Exif data of the photos in this case?
Yes, I did.
Okay. Can we pull up 1304, please? Your Honor, may I approach?
You okay?
What compelling testimony did you catch? All three of these photos with the bruise on Amber's arm went through some transformation to change sizes. What does this mean? He just testified that this photo, all three of them have been altered. All right, you're not going to miss any of this testimony. We don't want to miss a bit of this. We have to take a break. When we come back, we'll go back in where we're leaving off.
Alpacas, dinosaurs, all kinds of stuff. It's like paradise.
And welcome back to Court TV Live. I'm Judge Ashley Wilcott. Good afternoon to you as we bring you our continuing coverage of the dual defamation trial. Johnny Depp on one side, Amber Heard on the other. And we want to go back to court. But listen, I really want to emphasize that so far, this is an expert in digital forensics. And his testimony was that there's a picture that we've all seen introduced into evidence of Amber Heard's arm with a bruise that she's taking. And he just testified that all 3 images of that photo have been altered. You haven't missed any testimony. Let's go back.
Any objection, Mr.
I'm sorry,
Murphy?
Your Honor. My
She wishes to
co-counsel
publish
talking. I'm
it
so sorry.
as a demonstrative.
No objections demonstrative.
All right, thank you. We'll publish it as 1304, just as a demonstrative.
And Mr. Neumeister, are these images in this demonstrative excerpts from the report you prepared in this case?
Yes, they are.
And what do they show?
On this particular photo, and on all of them, it shows the first few lines of Exif data, the ones that would be most important for this photograph. So, for example, things you would see, the very top line would be the make of phone. It's an Apple iPhone 6. And then the resolution is 72 pixels per inch, 72:1. And instead, where it says software, on a normal iPhone photo, it would, instead of saying Photos 3, it would say the software version, for example, 9.3.1. And then you've got the date and the time of the photo below that, which is really easy to change in an Exif editor. And below that, you have things like the like the flash. You've got the exposure type, how long the exposure was. So what you just highlighted there again was the date and time. So that's universal time code minus whatever area you're in the world.
Anything else you want to show us with this demonstrative?
Yeah, just below that, if you look, there's some things that would say, for example, a directly photographed image. That is not going to be necessarily accurate once it's been through an editor. It will always pretty much say that. So when you're looking at scene type or auto exposure, these are things that really don't matter all that much. What would matter is, for example, if you're taking notes, the focal length would be important. The pattern of metering, things like that to a photographer would be important. And again, this is just a few lines, and the reason I put these in there was just to explain a bit what Exif data is. The actual thing I'm trying to point out is the fact that instead of an operating system, it shows the editing program that was used on this photo.
Are there additional photos that you did this analysis for?
Yes, many.
Okay. Can we scroll to the next page, please, Tom? Is there anything about this photo that you noted as part of your analysis, Mr. Neumeister?
Yes, again, it's right there you've got Photos 3.0 on that particular photo. And I think, we've pretty much covered what the stuff is, but again, you see the Photos 3.0. And again, this could not come out of an iPhone this way. This would go into a computer, be edited and rendered through the photo editor. And this would then be embedded in the Exif data.
Okay. Do you have other photos in this demonstrative?
Yes.
All right, can we scroll to the next page?
Same thing. You've got up here on the top, you've got the Photos 3.0. And this is throughout a lot of the photos that are in evidence, or versions of the photos in evidence, were gone through Photos 3.0 or Photos 1.5, an earlier version.
Can we scroll to the next page, please, Tom? And what about this one?
Same thing, Photos 3.0. And again, in a photo editing app, you can do an awful lot of things. So when you see Photos 3.0, first of all, you know it's not anywhere near an original. There's going to be compression artifacts because it's a JPEG file.
All right, I'll sustain the objection. Next question.
Okay. Can we move on to the next page of this demonstrative, please?
And again, same thing. You've got the Photos app.
Okay. And I believe there's one final photo in this demonstrative. What about this one?
Again, if you look up there, it says Photos 3.0 on that particular photo.
All right. We can take that one down. Your Honor, I have a little bit left. I don't know if you wanted to.
All right, you want to take our afternoon? Let's go ahead and take our afternoon recess. Just do not discuss the case and don't do any outside research. Thank you.
All right, they are taking an afternoon break. Still with us, criminal defense attorney Franz Borghardt. All right, Franz, do you think so far this expert's testimony is convincing the jury that Amber Heard's photos have been altered?
Oh, I think he has clearly established they've been altered. The problem's going to be that the Heard team is going to argue, well, there was still bruising, right? And so any alterations were probably done to make it to where they were more visible. The Depp team is going to say, no, any alteration of one affects the credibility of everything, right? I mean, why would you alter a photo of a bruise? That just doesn't make sense. So I think this is huge testimony. And I think it also affects the credibility of the Heard side. Now, I'm curious to see what they're going to do on cross-examination with this expert. He has been very credible thus far, and his testimony has been somewhat restricted as to what he can and can't talk about. But the inferences that we can draw are clear that these photos of Amber Heard bruising were altered. I think that is a fact now established with this jury.
So let me ask you this, trial strategy-wise, if you were the one to be representing Amber Heard and you were cross-examining this expert, how many questions would you ask? What would you try, if anything, to narrow the issue to?
I think if I were representing Ms. Heard, I think it has to be a softer cross for me, where I'm not going to be overly aggressive with this credible witness. You know, I might emphasize there's reasons people edit photos that have nothing to do with them, people wanting to pull the wool over someone's rug. It may just be that we want a better view of what's going on. It's dangerous though, right? Because, you know, we're looking at two different photos right now, and one of them looks very much like a bruising and the other one maybe not so much. So I certainly wouldn't come at this witness very hard. It just doesn't. I mean, his credibility came across very, very nicely in direct examination, and I don't think they're going to be able to crack that. Now, that all being said, one never knows. One never knows what this team is going to do, and so they may come at him hard. I think it's really problematic right now that these photos that were supposed to be like the aha bruising photos, now are they even of any kind of evidentiary weight because they've been altered? And that is a huge, huge deal, especially in her establishing that she was really abused by Johnny Depp.
Yeah, I agree. It's a huge deal because the jury has now heard, at least from an expert on the stand, hey, these photos have been altered. What is the jury going to do with that? And cross-examination, you're right. We don't know which attorney is going to be doing the cross and what they're going to sound like when they do the cross. We actually do know who it is because the person objecting is going to be doing the cross, but what type of cross will they present? Of course, you have to stay with us to find out. You're not missing any testimony. We're going to squeeze in a break. When we come back, we're going to go back into the courtroom for more testimony from the expert.
All now.
Johnny. Morning, Johnny. Morning, Johnny. Johnny, why should we believe you and not Amber, Johnny? Why should we believe you and not Amber? Oh, not this morning, not the time. Johnny, how's the trial going? How's the trial going, Johnny? Johnny, how do you want to be remembered?
Of course, we know the crowds continue to be gathered there outside of the courthouse, waiting to get into the courthouse. 100 wristbands for people to observe in court in the gallery live. We're going to take you back into that courtroom, and we did hit the pause button. You haven't missed any testimony. A very important testimony that Johnny Depp's team is presenting, because this is an expert that appears to be credible, well qualified, testifying as to authenticity of photos of Amber Heard with bruises, and testifying that in his opinion, those photos have been altered.
All right. Okay, you can be seated. Your next question.
Thank you. Mr. Neumeister, do you have another demonstrative prepared that shows a photo with Exif data reflecting that it was saved in Photos 3?
Correct. Photos 3, yes.
Your Honor, we have a video of these photos, and we're happy to play it once so that counsel can review, if that's all right.
Okay.
They've been through some objections and some sidebars and established that this witness can apparently look at the photos that have been used in this trial as demonstrative aids to testify as to his opinion of them. Still with us, Franz Borchardt. Franz, what else do you think they might be discussing at the sidebar?
You know, the question becomes, we know that they were altered, but is the issue for the Heard team the nature of the alteration? And if the nature of the alteration is well, look, we modified the file size for cropping, or we modified the file size for this reason or that reason, well, you know, it draws a different conclusion. And maybe that's what they're trying to limit is what this expert can testify to that isn't in the realm of speculation. However, I mean, the cat is out of the bag at this point. The cat is well out of the bag at this point. The jury has now heard testimony as to at least 3 photos that were altered in some way. Now, how they were altered, we don't know. We know that the photos have different file sizes. To what end or what conclusion that can be drawn as a result of that, that's going to be, unless he testifies to that, that's going to be argument and closing arguments for the Depp side. But right now, this is really, really damaging to the Heard side.
And, you know, he did specifically say that first photo that he testified about was Amber's arm with the bruise, where she's taking the picture of it on her left arm. And he says there were 3 different of those same photographs, same in terms of what it was being taken of, in evidence, and that forensically, those 3 photographs didn't match. So there was no way to authenticate them, which means theoretically they could not hold any weight at all. All right, let's go back to the courtroom. I think they may be done with the sidebar.
All right, we took care of that, Your Honor.
Right, thank you.
May we publish, or would you like to see it?
I'd just like to see it first.
Okay. And what's demonstrative is this going to be then?
This is plaintiff's 1305, Your Honor.
All right, thank you. Could you play it? There you go.
Subject to Your Honor's ruling, that's not.
All right. So marked as plaintiff's 1305, and used as demonstrative, you can publish to the jury.
Mr. Neumeister, we're going to go ahead and play the demonstrative that you prepared, and then after the jury's had a chance to see it, if you want to explain to them what the demonstrative shows, that would be great.
Yes, ma'am.
Can you publish it? No, this.
So, Mr. Neumeister, what was depicted in that video?
The same photo treated two different ways. One was marked with the original with the operating system from an iPhone, which is iOS 9.3.1 on that particular photo. The one that says 9.3.1, there is a graphic below indicating it. The second photo is marked Photos 3, and it looks quite a bit different.
Okay. And just, Tom, could we pull up Defendant 708? Mr. Neumeister, does the image in Defendant 708 appear to be similar, same photo as what was depicted in your demonstrative?
Actually it's the Photos 3.0 edit version.
Thank you. We can take that one down, Tom. Mr. Neumeister, have you also formed an opinion about Defendants Exhibits 712 and 713?
Correct.
Did you prepare a demonstrative that shows?
Your Honor, Exhibits 712 and 713 are outside the scope of this lecture.
I can show you if you'd like, Your Honor.
So again, I want to mention a sidebar, the purpose of the sidebar. The sidebar is an opportunity for the attorneys to approach, to have a conversation with the judge and say things about their objection or their basis that they cannot otherwise say in the presence of the jury. So while the sidebar in this particular case is, as I understand it, being recorded, it is not being said in order for the jury to hear it. So there's a real advantage as a former judge for the use of sidebars. But I have to say, Franz, they're going back to the podium. Let's listen in.
All right, could we pull up Plaintiff's Exhibit 1306, Tom? And Your Honor, this is another video that, can you pause that, please? This is another video that we prepared. It's not published yet, so I'm happy to play it once through. So that
Play it once through. This is 1306.
I would just request, what exhibits are they? Sorry, Your Honor. What exhibits are these that are in this video? It doesn't say. I don't know.
Yeah, I tried to get my question out a moment ago. Defendant 712 and 713, Your Honor.
12 and 713. All right. Okay, 1306 then will be a demonstrative as identified and be published.
And if we could go ahead and play that, please. Tom? And Mr. Neumeister, what's your, what do we see here in this demonstrative?
There's Exhibit 712, I believe you have. I'm not sure the date's number, 712 and 713. They're two separate exhibits, except it's the exact same photograph that's been, one's been edited, one hasn't, or I can't say that one hasn't, but the colors have been modified in an editor.
Objection, Your Honor. Beyond the scope of your ruling, talking about colors. It keeps happening.
Sustained objection.
Thank you, Your Honor. Mr. Neumeister, did you form an opinion in this case about the authenticity of the photos that you reviewed of Ms. Heard?
Well, first of all, nobody can identify the authenticity of the photos, of any of the photos. Marked photos 3, photos 1.
What a day of testimony. It's unbelievable. You've got to stay with us. We're going to continue to bring this testimony to you. I want to thank you to Franz Borchardt for being with us today as a guest legal analyst. Of course, thank you all at home for joining us. Michael Ayala is going to take it from here. You won't miss a thing here on Court TV, your front row seat to justice.
I'm a partner in hope today.
Hello, welcome back to Court TV Live. I'm Michael Ayala. Today on the stand in that Fairfax, Virginia courtroom, Johnny Depp, the sequel.
We call Mr. Depp.
Okay. Sir, just a reminder, you're still under oath, okay?
Yes, ma'am.
The man back on the stand today called during his own rebuttal case. He breaks down the bottle incident and much, much more. Plus, Depp's ex-girlfriend, model Kate Moss, testifies live from London and answers the question on everyone's mind: did Depp push her down the stairs? Well, we want to get you back into the courtroom right away. Right now on the stand, a metadata expert, and he's been testifying about the possibility that the photos of the bruise on Amber's arm might have been doctored. Let's go back into the courtroom.
Just marked with the operating system number, and the reason is the manner of collection. So these came from an iTunes backup. Now, what is an iTunes backup?
Objection, Your Honor. I'm sorry. You're beyond the scope of your ruling. Exif metadata. This keeps happening.
Your Honor, may I approach on this one?
Another sidebar. Well, that's something new. No, there's been plenty of them, folks. And I think Judge Ashley just explained to you guys what basically is going on. The attorneys don't like to have speaking objections in that courtroom. Actually, it's the judge that doesn't like it. So they go up to her and they have these conversations outside the hearing of the jury. It is on the record, though, so a record is being made of those conversations. I have a guest for this hour. Let me bring him in quickly. Criminal defense attorney and a former prosecutor, David Bruno. David, this particular expert, I'll tell you, in a case that's all about he said, she said, this expert, I think, is going a long way towards affecting the credibility of Amber Heard.
I was thinking, before I got on here, I was like, me and Michael are going to talk about credibility, corroborating, lack of corroborating, right? Because last time we spoke, we were talking about this. When it's a he said, she said, and credibility is at issue, like this case, the other evidence, either corroborating, disproving, supporting, is critical to the fact finder in determining who's telling the truth. And this expert here is showing that there's different pictures and images, and we're going to get into some metadata, which is very interesting on the technology standpoint, as to who's telling the truth and what pictures are authentic and real.
Yeah, this is going to get hairy, no doubt, for Amber Heard, at least at the moment.
Yeah.
Yeah, so we're still waiting for cross-examination. My understanding is that sidebar is over. Let's get back into the courtroom.
So, Mr. Neumeister, without going into the specifics, what's your opinion about the authenticity of the photos you received from Ms. Heard?
Based on the way they were collected, there would be
Objection,
no...
Your Honor. We just ruled on this.
I framed my question, I thought, Your Honor, to avoid the issue that you're concerned about. Mr. Neumeister, what's your opinion about the authenticity here?
There's no way for any forensic expert to validate any of these photos.
Okay, thank you very much. No further questions.
Good afternoon, Mr. Neumeister.
Good afternoon.
Your only degree is in political science, correct?
42 years ago, correct.
And you have no degree whatsoever from any academic institution in computer science, correct?
That's correct.
And you have no certifications in computer forensics, correct?
That's correct.
From the opinions you've testified today, you relied on no data except for the embedded Exif metadata to support those opinions, correct?
Incorrect.
What other data did you rely on for the opinions you've testified to today?
I was trying to explain that you kept it.
What other data did you rely on for the actual opinions you've been able to testify to today besides Exif metadata?
The type of extraction that was performed? You're asking the question
for the actual opinions you testified to.
That is what I would use. I would also use vector scopes.
Objection, Your Honor. That was not responsive to my question, Your Honor.
If you want to approach.
All right, so yet another sidebar. David Bruno, let me bring you back in real quickly. Wasn't surprised. The very first thing they went after was obviously, well, I guess it can be considered a weakness, the fact that the guy really doesn't have any computer education background.
Absolutely. Question number one, and I agree with the cross-examination so far. It's been limited, but I mean, how do you not bring up a forensic computer expert?
Yeah,
this is somebody that does not have.
David, I'm sorry to cut you off. We'll get into that in just a second. They're back on the record.
Can you restate the question?
I don't recall a question, Your Honor. Right. We can move on.
Your Honor, maybe we could have the court reporter read it back.
They could redirect.
No. Okay, what was the question, Judy?
I believe the question was, what methodology did I use to make my findings?
Judy's voice has changed. That's.
Sorry.
Is that correct, Judy?
No, I was looking for it in the sidebar.
Okay.
Asking for the actual opinions you testified to. Any question before that?
That's fine. Okay.
So, when you're analyzing video or photo, in this
Objection to video, Your Honor, that's beyond the scope.
All right, if you could just answer the question, sir.
when you're analyzing a photo, a digital photo, you look at the Exif data, you use a vector scope, you can use a Pantone chart if that's available, and that should be done, but that's a whole different deal. If I go into that, you'll object to it. So you'd also use a waveform scope, you would use an RGB parade, you can use a histogram, though in this case, it's not really all that relevant.
You are not offering any opinions that any photograph in this case was intentionally modified by Ms. Hurd, correct?
I'm just stating the fact that photographs were modified.
But so you are not offering any opinion that any photograph in this case was intentionally modified by Ms. Hurd, correct?
That's correct.
Can you please pull up Exhibit 170A?
Is that Defendants 170?
Defendants 170, yes, Your Honor. So you offered testimony regarding this photograph during the direct examination, right, Mr. Neumeister? That's a yes or no, sir.
Of a photograph like that, I don't exactly remember the photograph. There's so many different versions of this photograph, but yes, I've talked about that particular photograph.
But do you recall being deposed in this matter?
Yes.
And you were under oath?
Yes.
And that was on April 6, 2022?
I believe.
Can I approach Your Honor?
Yes, sir. Thank you.
So, Mr. Neumeister, if you could please turn to page 76. And when I say pages, those are the little pages in the 4 boxes, not the page at the top. And do you see page 76, line 3? You were asked on April 6, anywhere in your April 1st, 2022 expert disclosure, do you offer any opinions regarding the authenticity or lack of authenticity of the specific photograph produced as ALH 7101? Response, can I refer to my report to see if that specific number is in the report? Yes. Response, not that specific photo. I just grabbed 3 out of the batch. Do you see that?
Yes.
Can you please pull up Exhibit 517, or Defendants 517?
Thank you.
You are not offering any opinions regarding this specific photograph, right, Mr. Neumeister?
That's correct. My testimony's been limited here.
And you are not offering any opinion that any photograph was visually doctored by Amber, correct?
Not by, I can't put the person who might have done it.
Well, you're not offering an opinion that a photo was visually doctored by anybody, are you?
I'd have to see each photo. There's no way to authenticate any of these photos based on what I received.
So you testified about Photos 3. Do you recall that testimony?
Correct.
Yeah, Photos 3 is a photo editing and photo sorting application, correct?
It's a photo editor and photo sorter, as are a number of editors.
So when you reference Photos 3.0, you never did any independent strike that, Your Honor. So when the software of a photograph in the Exif metadata says Photos 3.0, that could be just saying that the photo was saved in Photos 3.0, correct?
Unless you looked at a scope of the photos that would tell you that the parameters of the photo do not meet that of the cell phone that it was taken on.
But the notation Photos 3.0 in the software Exif metadata, that does not in and of itself mean that the photo was edited in Photos 3.0, correct?
It means that you've recompressed the photo and it will not hash or digitally fingerprint with the original photo.
But it does not mean in and of itself that it was visually edited in any way in Photos 3.0, correct?
Again, it's not the same photo because you're using lossy compression once you save it. So you have changed the photo.
So if you could please turn to page 233 of that transcript. And line 20, do you see question? When it says exit software, okay, Photos 3.0, on to 234. That's just saying it was saved in Photos 3.0, right? Response, saved in 3.0, that's correct. Question, that notation in and of itself does not mean that the photo was edited in 3.0, right? Answer, that's correct. Did I read that correctly?
Yes.
A file has not changed visually just because it has been processed through Photos 3.0, correct?
That's incorrect.
Can you look at page 128 of your deposition, please? Bottom, line 20, question, you see, question, but the file changed visually just because it has been processed through Photos 3.0. Answer, obviously I understand what you're asking. From a technical point, yes, because of the compression. If you get down to scopes and artifacts, yes, it has changed. Was it intentionally changed? We don't know. In other words, did somebody save it in there and just save the photo? We don't know. Did I read that correctly?
That's correct. But again, it says here...
That was my question, Mr. Neumeister.
Okay.
So if the Exif metadata software field lists the software as iOS, you have no reason to dispute that, correct?
Incorrect.
Well, isn't data data? That's what you testified to, right?
It's very simple to modify Exif data.
Did you find any evidence in this case of actual modification of Exif metadata?
You can't authenticate any of these photos because of the way they were.
That wasn't my question, Mr. Neumeister. Did you find any evidence of any modification of Exif metadata of any photograph in this case?
You didn't listen to my answer. My answer is there is no way to know because of the way the files were presented.
So you found, but you actually...
So were the photos edited or not? Maybe this cross-examination will get us closer to the truth. Let's take a break. We'll get you back in the courtroom and you won't miss a thing when we come back. Hello and welcome back to Court TV Live. I'm Michael Ayala. We continue now with the rebuttal case of Johnny Depp. It's day 2 in his rebuttal case, and quite frankly, it has been a very strong one. They're really raising some questions as to the credibility of Amber Heard and her case, from calling Kate Moss to calling Johnny Depp to the stand again, to the witness that's on now, a digital forensics expert who's raising questions as to the whether these photos that she used in this trial were actually edited. Let's get back into the courtroom for his continued cross-examination.
Evidence of it, correct?
That no one could.
I'm not asking if anyone else could, Mr. Neumeister. I'm asking, did you yourself find, you found no evidence of any modification of Exif metadata of any photograph in this case, correct?
Now, I understand trying to control the narrative, but there's no way to answer that scientifically because given the evidence we were given, there is no way to positively or negatively answer that. It's not a question that can be answered.
It is a question, Mr. Neumeister. The question is, did you yourself, you found no affirmative evidence of any modification of software Exif metadata of any photograph in this case, correct? You found no actual evidence of that, did you?
No one could tell either way because
I'm not asking about anyone else, Mr. Neumeister. I'm asking about you. Did you found no evidence of that, did you?
Objection, Your Honor, asked and answered.
He's not answered what he found, Your Honor.
Overruled.
There's not a way to answer that the way you're asking the question. You have to restate it. You're trying to control
Your Honor, he's not
narrative.
responding to the
All right,
question.
could you just answer yes or no, sir, to the question?
It's not a yes or no question.
Did you, yes or no, you found no evidence of Exif metadata modification of any photograph in this case, correct?
That's incorrect.
Okay. It is your opinion that the metadata of all photographs of purported injuries that Ms. Heard has identified as her trial exhibits do not indicate that the photographs went through a photo editing application, correct?
Well, first of all, that's not a yes or no question because a lot of the exhibits that you have put up, they're not photographs. They're screen grabs, and they've been changed from Apple format, which is JPEG, JPEG, to a JPG Microsoft format. So you have actually changed the exemplars. You've changed the data yourselves. We actually ran Exif data on some of your own examples that you've entered in the evidence. They are not photos from an iPhone. Those were edited on a PC.
I'm going to hand up a page from your disclosure. 1 second, Your Honor.
You know what's interesting? When you have a witness who is so combative, clearly this looks like an experienced witness because he was saying, I understand trying to control the narrative, but he was doing the same thing. So the question would have to be whether, you know, who is looking worse when you have a witness trying to control the narrative and an attorney who's trying to make them answer a question.
So do you see on page 8 of your
Who comes off
disclosure,
worse?
Mr.
Let's get back to the court.
Neumeister, it states, quote, the metadata of all of the photographs of purported injuries that Ms. Heard has identified as her trial exhibits do not indicate that the photographs went through a photo editing application. Did I read that correct?
That's correct.
No
But
further,
we're talking
no
Exif
further
data.
questions, Your Honor.
All right, redirect.
Mr. Neumeister, a moment ago, Mr. Murphy was asking you some questions about your opinion about the trial exhibits that Ms. Heard has offered in this matter. And he asked you about your opinion that they don't indicate that they've gone through a photo editing application. What can you tell us about that?
Well, first of all, on this last exhibit, it says metadata, not Exif data. So that's two different things altogether. We're talking Exif data, and on the report, I put metadata because I was requested to cover meta and Exif data. So it's taken out of context. The Exif data is the data based that's embedded in the photo. Metadata can be the file data about the file itself, two different things. So the way the data was collected, it was An iTunes backup is a backup.
Objection, Your Honor. Backups outside the scope of Your Honor's ruling beyond Exif metadata.
I think he opened the door on the
overruled the objection.
Thank you, Your Honor. Go ahead, Brian.
An iTunes backup is only a backup of things that are on an iPhone that have not been deleted. It does not have the critical operating system. It doesn't have any of the files that would validate the path of a photograph in that phone. It does not have a lot of the log files. It does not have the Knowledge C database, which talks about usage of the phone and the patterns of how data was handled. All it is the photos you decided to save, not the photos you deleted. So it's a very limited database. Without the system registry or without the system operating system, there's no way to tell, because it's very easy to modify a photo on a phone and have it just read iOS 9.3.1. But with the actual phone, if you were able to get a hold of the actual phone, and in 95% of all cases we work, we have the actual phones. It doesn't matter if the phones are 10 years old or 20 years old, or not 20 years old, but 10 years old. The reason is if people have something they want to keep as evidence, they don't throw out their phones. They don't recycle their phones. They save their phones. So people ask how we're doing phones on 13-year-old cases, because people do not throw out evidence. They keep the phone. So in a situation like this, there are no forensic extractions. In fact, the extractions we were provided were backups of iTunes, just exports. So it's third generation, and there is no way to verify the file paths and the history of any single photo that we've looked at.
No further questions, Your Honor.
All right, thank you, sir. You can have a seat in the courtroom or you're free to go.
Thank you very much.
All right, your next witness.
We call Beverly Leonard by video link.
I need the TV. All right, just give us a moment to get the TV up.
All right, before they get going with this next witness, I think it's a good opportunity for us to step aside, take a break. When we come back, we'll pick it right up where we left off. So keep it right here on your front row seat to justice.
inspection and estimate.
Hello, and welcome back to Court TV Live. If you're keeping score at home, and this is the final stages of this trial, Johnny Depp's team hit a home run today, maybe even a grand slam, to take what feels like a commanding lead in this case. Why? Sure, we could point to the testimony of Dr. Shannon Curry this morning, who was brought back to rebut the testimony of Heard's expert, Dr. Dawn Hughes, or you could point to the star power of Kate Moss, who was absolutely radiant in her cameo appearance to let everyone know Johnny never pushed her down the stairs. But in the end, there really can be only one reason today was such a good day. Johnny Depp once again took the stand, and he knocked it out of the park with his staccato delivery and his impish charm. He once again held court and left the jury with some simple yet unforgettable words.
No matter what happens, I did get here, and I did tell the truth, and I have spoken up for what I've been carrying on my back reluctantly for 6 years.
It was a powerful moment, folks, one that I'm sure the jury or our viewers won't soon forget. And I want to take you back to the courtroom now. Johnny Depp, on the rebuttal case, has called Beverly Leonard. Now, she's an airport employee. She is going to testify about that incident. I don't know if you remember, Amber Heard was crossed about it, where she had an incident with her ex-wife. She was married to a woman, Tasia Von Rieck, and she said it wasn't anything. It wasn't much. They were mistaken. The cops made a mistake. She was arrested. We're going to hear more about that now, so let's get back into the court.
That's close. Can you raise your right hand? Do you swear or affirm to tell the truth under penalty of law?
Yes, I do.
Well, start talking. We'll see. Try the first question.
Good afternoon, Ms. Leonard.
Good afternoon.
All right, Ms. Leonard, if you could speak a little louder for me and try to count to 5 one more time. I'm just trying to get you on the TV screen.
Okay, 1, 2, 3, 4, 5.
All right, the lessons we've learned in COVID, correct? Okay. All right, your first question.
Thank you very much. Good afternoon, Ms. Leonard.
Good afternoon.
Would you please state your full name for the record?
Beverly R. Leonard.
Where are you testifying from?
I'm testifying from my home in Arizona.
Are you familiar with the defendant in this matter, Amber Heard?
Yes, I am.
And how are you familiar with her?
I met her in 2009 at SeaTac International Airport.
Why were you at the airport?
I worked there.
What happened when you met Ms. Heard in 2009?
I was in the baggage claim area, and I observed her with a traveling companion, and they got into an altercation where Ms. Heard had grabbed her traveling companion and pulled something from her neck. At that point, I got up and went over to try to break up what appeared to be a fight. And I summoned a colleague to help me, and I stepped in between them and separated them, stopping any further injuries or escalation.
How would you describe the interaction between Ms. Heard and her traveling companion?
Ms. Heard was aggressive towards her traveling companion, and she had reached up and grabbed her arm and pulled a necklace off of her, and then I observed her having it in her hand. She seemed to be not very steady on her feet. Her eyes were blurry and watery, and I could smell alcohol.
What was Ms. Heard's traveling companion's reaction to being assaulted by Ms. Heard?
Objection, relevance?
And I'll sustain the objection.
On relevance? Yes.
Yeah.
Okay. What did Ms. Heard's traveling companion do?
She raised her hands in what appeared to be a defensive manner. But other than that, she was pretty stoic and didn't really respond much. Her stature was 2 or 3 inches taller than Ms. Heard, so she didn't really need to have to defend herself.
How would you describe Ms. Heard's demeanor when you stepped in between Ms. Heard and her traveling companion?
She was somewhat dismissive. She just said, we're just having an argument. We're fine. We're fine. Because I was asking if they were okay. Are you okay? Is there anything wrong? What's going on? And
Objection, hearsay. Just objection, hearsay to what she's saying.
All right. I'll sustain the objection. Next question.
What, if any, injuries did you observe on Ms. Heard's traveling companion?
She had abrasion on the side of her neck where the necklace was, like a rope burn from the chain as it was removed.
How did you come to testify in this trial?
I became aware of this situation, specifically this trial, because I was sent an email anonymously. I don't even know who it came from, asking.
Objection, hearsay.
Right. I'll sustain the objection.
Understood. How would you generally describe Ms. Heard's behavior on the occasion you met her in 2009?
Objection, Your Honor. I already asked and answered the specifics.
I'll sustain the objection. Next question.
Did Ms. Heard's sexual orientation have any impact on how you conducted
Objection.
yourself?
I'll sustain the objection.
Nothing further, Your Honor.
All right. Any cross-examination?
Yes, Your Honor.
Okay. Cross-examination.
Ms. Leonard, when did you contact counsel for Mr. Depp?
Late last night.
Late last night. Okay. And this happened in 2009, correct?
Yes.
13 years ago, correct?
Yes.
And you know that this trial is being televised, right?
Yes.
And so you know that if you have something that might be significant to say, that way you can get on television, right?
No, I had no desire to be on television. I actually waited for a call and wondered why I hadn't been contacted.
All right. But you...
All right, we're going to cut that off quickly. Let me bring in my guest for this hour, criminal defense attorney, former prosecutor, David Bruno. He's standing by, still with me. David, once again, it's just those little nicks that can turn out to end up being very big cuts that can bleed you out. Another witness coming in, but I really want to start off by asking you about the fact that these are witnesses. We saw 2 today. So another one, Morgan Tremaine, from the former TMZ employee earlier, who are contacting Depp's people. How does that look to a jury? Oh, it looks like we lost his audio. Okay, no problem at all. We're going to take a quick break. When we come back, we'll have much, much more from inside that courtroom. So keep it right here on Quick TV.
Lapiplasty.com.
Hello and welcome back to Court TV Live. I'm Michael Ayala. On the stand right now is Beverly Leonard. Now, on direct examination, she had some interesting things to say about an event that took place back in 2009 at an airport in Seattle. Now, if you remember, when Amber Heard was on the stand, she basically downplayed this incident. She was arrested, but she said she was wrongly arrested. No big deal. Nothing really happened. Well, Beverly Leonard, who's an airport employee, tells a different story on direct, but she's now facing cross-examination. So let's get back into the courtroom.
You reached out and contacted them last night, correct?
Yes.
Okay. All right. Thank you. I have no further questions.
All right. Any redirect?
Nothing further, Your Honor.
All right. Thanks, Ms. Leonard. You're free to sign off. Thank you.
All right.
All right. Your next witness.
Your Honor, may we approach?
Sure.
Thank you.
All right, let me bring back in my guest, David Bruno. Hopefully we got those audio issues fixed up. Former criminal defense attorney, former prosecutor, and a criminal defense attorney. Great. David, this witness, and what I was asking you before, was this is a witness that came forward yesterday, it sounds like, contacted Depp's team. We had one earlier who had done the same thing, seeming like they want to get into the case. How does that affect the credibility of those type of witnesses?
Yeah, always, right? Because as cross-examination goes on, they're looking for bias. They're looking at conflict. They're trying to attack credibility, and credibility is at issue here. When the witnesses come forward late, when the witnesses have interest in the case, it's an attack. But here, look, Amber Heard put it at issue, and she denied, she minimized it. And this is an eyewitness that does have relevant evidence. And she's here to say that Amber Heard did more than what she has said before this jury. And she's there to color. Now, is this absolutely critical? No, it's not. It's not really material. It's not even an issue involving Johnny Depp. But the credibility, and we keep on hammering that home, and it goes to who's telling the truth here. Truth is at the critical issue here, because truth is a defense. Truth is a defense to defamation. And also, the truth is important in assessing credibility. And witnesses like this, although they come with some baggage and attack, do come forward to color Amber Heard as not telling the truth. And ultimately, that's the decision that this jury has to make. So I think that the cross-examination is ripe, it's proper, it's the way to cross. But in the end, this witness was there, and she saw things that Ms. Heard did not testify to. So I think it's a good move by the Depp team.
Yeah, at the end of the day, David, what I'm hearing her testify to, and again, even though she was a late contact to the Depp team, she doesn't seem to have a dog in the fight. She described to me what sounded like an assault. Now, maybe an arrest might have been going far. I don't know what happened, why she ended up getting arrested. Doesn't seem like that would lead to an arrest. Maybe something else went on. But at the end of the day, what she was recounting was clearly an assault on some level.
Yeah, don't forget, an arrest was made. So a police officer made an arrest, found probable cause, charged this individual. And Ms. Heard wants to come forward and say that that was nothing. Jury, don't worry about that. That's not the general way that she behaves. So I think, look, it's late, especially last night. That was a little bit surprising to me, that a witness contacts defense counsel last night. I mean, that's not timely at all. But at the same time, it shows the propensity to commit violence on the part of Amber Heard. And that's what Johnny Depp is saying. That's what we heard in the testimony. And we've seen a couple witnesses now testify that that is the disposition of Ms. Heard. And just put this particular witness in that column to support that argument that Johnny Depp's team will be making in closing.
There are two more things about her testimony that jump out to me that fit right into that narrative that you're mentioning, David. Number one, she says that she smelled alcohol on Amber's breath. So you have that. All right, it looks like they're going back. We're going to get back to it in just a minute. Let's get back to the court.
To have closing arguments on Friday morning, but the the plaintiff only has one more witness in rebuttal, and then since we have a counterclaim, the defense has a chance to have rebuttal for their counterclaim, and so you'll hear the remaining witnesses tomorrow on that. So since we don't have anything further today, I'm going to go ahead and release you at this point. Do not discuss the case with anybody, don't do any outside research, and we'll see you back tomorrow morning at 9 o'clock, okay? Thank you.
All right, so you heard Judge Penny Ascarati telling the jury what's to come. Essentially, there's one more witness to come on Johnny Depp's rebuttal case. Then there'll be a sur-rebuttal case because, of course, there are two suits here. So Amber will get another chance to present some witnesses to counteract some of the things that came out on rebuttal. Let me bring back in David Bruno and David, where I was going was basically there were two extra things that jumped out to me about Beverly Leonard's testimony. One, Amber had alcohol on her breath. Number two, her partner in that situation, albeit a woman, was bigger than her, and she was sort of backing off. She seemed meek, which to me mirrors the situations that we've seen with Johnny Depp. So that really jumped out at me as well.
Sure, those are two big themes in the case, the alcohol and drug abuse by both Johnny and Amber. But to your point, it's showing this aggressive disposition of Amber Heard that needs to be believed to really support the Johnny Depp complaint. Because in the end, he is saying that what she said in the op-ed is false, is not true. And that is what this case is about. Was that truth? Was that embedded in fact? Or was that a lie? That, number one, was a lie. And number two, affected Johnny Depp's ability to earn. And there's the second question that needs to be answered in the event that they do find defamation, is to what are the damages here? And I think Johnny Depp has done a tremendous job showing those damages. And on the flip side, Amber Heard has not, because she's got the complaint too. She's got the complaint for defamation as well. And she has the burden to show her damages as well. But look, she's an Aquaman, right? And Aquaman should have been basically the way that she got up to the top. And it was about a year and a half after until her alleged defamation statements by Johnny Depp, right? So when we talk about damages, and that's going to be part two for both complaints, if there is defamation found, if there's liability found, then the jury's going to have to go to the damage question. And I think that Johnny Depp has done a better job on the liability question, and I think he's done a better job on the damages question as well. And that's what we're going to start hearing as we end this case with the closing arguments of counsel. Those are the two questions that the jury has to really deal with.
I agree with you 100% on your assessment. Here's my question for you, though. The malice issue. There's some question. Now, they've done a really good job, this is Depp's team, of showing the aggressiveness on Amber's part, which may bring into question some of her claims. But I think it's within the purview of this jury to believe that she believed she was a victim of violence. There's enough there that if they wanted to say, hey, she believed she was a victim of violence. So when you're looking for malice in her comments in that op-ed, if you're looking for complete and utter disregard or reckless disregard of the truth in her op-ed, they could have trouble finding that. Your thoughts on that?
Yeah, no, I agree, but I was skeptical of Johnny Depp's case in the very beginning of this. In the beginning, when he first testified, I wasn't on his side on the question of defamation. But I'll tell you what, the more and more we learned about Amber Heard and the recordings that we heard and some of the statements that she has said, and look, she looked to be the aggressor on a number of different occasions. For her to come out with that op-ed, I don't see any other reason, honestly, for a reckless disregard of the truth. That's my thoughts on it. It's a high bar to get to, no doubt. It's a special additional element for a celebrity or a newsworthy individual, and that is what we have here. But look, they did such a great job with the recordings, with the other witnesses corroborating Johnny Depp's testimony, with the late witnesses, with the experts that brought forth. How about the expert today on the digital evidence that basically said that we don't even know that the images that have been provided by by Amber Heard are even authentic. They've been changed so many different times. We don't have the phone that was actually used. I mean, how about that for a takeaway, Michael? For all of our viewers out there, if you're ever going to use digital evidence in the court of law, maintain the original device, because that is the only way to authenticate a picture or a video.
You know, you hit the nail on the head, I think, in two ways. Number one, why would Johnny Depp bring this case? Exactly the reason you mentioned. We're hearing all this stuff about Amber Heard. I think that helps rehabilitate him in the public eye, which I think was the purpose of this case. But why else are we hearing all this about Amber Heard? Because I think it goes to that question as to why, whether they can find that malice. If you get this jury to believe that she was that aggressive and was often the aggressor, then I think, like you think, they might see that op-ed as being brought for only one reason, and that was with malice, right?
Yeah. Yeah, no, absolutely. And look at this soundbite of testimony that you just played of Johnny Depp. And essentially what he said was he got it off his back. What he did, and he said win or lose, essentially, as if he's already won. Even if he doesn't win on liability, even if he doesn't win on the damages, he comes out with a different public perception about him, excuse me. And I think that is why he brought this case. Win or lose, I think Johnny Depp did a great job rehabilitating his public image.
Absolutely. And then he retook the stand today in his rebuttal case. And I thought, again, I want to get your thoughts, but my feeling was that once again, I mean, he played the role of Johnny Depp very, very well. I thought he handled himself extremely well. I thought Cross didn't really nick him up too much. Your thoughts on that?
Yeah, because it's been a while since we've heard from him. He was one of the initial witnesses, and he's got a good cadence. He's a likable person. And you could see the fanfare in the courtroom, outside the courtroom. Look, there's witnesses that are coming forward, just contacting defense counsel yesterday. He's a likable person, a likable character. And in the end, the jury has to make a determination of credibility. And I would imagine that they are going to like him too. And it may be a major part in some of the factor that they come to in their determination.
Yeah, I mean, credibility often means likability in a lot of these cases, and you're exactly right. He's definitely the more likable character. Finally and quickly, do you expect Amber Heard to take the stand again in her rebuttal case, or should she?
Yeah, she should. She should. I think there's more questions to answer for her based on everything that's happened since her testimony as well. I'd anticipate it as well.
Yeah, to me, that's the only way to go in this case, is for her to take the stand again, tell whatever story she needs to tell to knock down some of what we heard on rebuttal, and leave that jury and let them decide at the end of the day. All right, well, David Bruno, thank you so much for joining me tonight. Appreciate you having you on the show. As always, love your insights. We'll have you on again soon. You have a great night. We're going to take a break right now. We have much more ahead in our next hour, so stick around. Johnny Depp back on the stand today, delighting his fans for sure. We're going to break down his important testimony just ahead, so keep it right here on your front row seat to justice.